Good morning, everyone. It is my great pleasure to welcome you to Human Rights at 60, Reflecting and Reimagining. This is a conference that we have put together to mark the 60th anniversary of the Ontario Human Rights Code. We want to explore new directions for human rights law policy and reflect on our history. To ensure accessibility, we have live captioning of this event available for all of our participants. The captioning will be embedded within Zoom, and it's available also via CAP app. So we'll now put the CAP app link into the chat for you all. We're also so pleased we're able to offer AS interpretation throughout the day. So my name is Tanya de Mello, and I go by Toni. I'm the Assistant Dean of Student Programming, Development, and Equity at Canada's newest law school, Lincoln Alexander School of Law at Toronto Metropolitan University. I'm a human rights lawyer, and I've been working in issues of discrimination, harassment, and sexual violence for 25 years. I was the former director of human rights at this university, Toronto Metropolitan. I also work with businesses and nonprofit organizations as a consultant across Canada to support them in making their workplaces more inclusive and equitable. I would like us to open this day in a good way and invite Nancy Rowe to do that for us today. Nancy is a traditional knowledge keeper, and she's a citizen of the Mississaugas of the Credit First Nation, on whose treaty lands and territory both the Ontario Human Rights Commission's offices and Toronto Metropolitan University's campuses are located. We are the co-sponsors of this event, and we are so privileged to have you here, Nancy.
Oni boso tidak kanan disnekas makwantorem anishanawe mit uchibuyan mitzagi kwen tau anishanawe uchibuy mitzagi wakin in GGs. Hi, hello, good morning, everybody. I'm just here to share a little bit whatever people call land acknowledgement opening or whatever they call it now, but I wanted to share a little bit in the sounding across our land, which is Anishinaabe Moen, and that sounding can be heard still from the East Coast to the Rocky Mountains and the entirety of the Great Lakes. And so I don't do ceremony and that online. I was told not to, but I want to share a few words with about what we want to look at, examine, pick up today. So sema bigitna ninduwe morganadak indo binan and beadma medewa queen we been toge yabe anishanavik bimoseyak mampi akin wamdana and kamagak Kida kinama going always going we begin na yang begin again. Meanwhile, sema awi nanduwe morganadak nabi sing skote keen niswewen. Anushanabe kitchi awe chi ninak ninakewen. Mino be matiswen api mino ina wendemoen mino ina wendemoen api nishwashwe mishum sananak saka kewen de wet moen. Mona dendemoen, Nebuakawen, Deba dendizuin, Guia Quatsuin, Minua, Akadewen. We do kage nadama and Gamino Saton Washigewin, Dodsuin. Still, Nishnave, we're still here, we still walk the earth, and we see what is happening. And we continue to do what we've always been taught to do. To follow those laws and protocols as we had been gifted since time immemorial, since the beginning of time. And we offer those things out to those seen and unseen things to Widokage to help us Shkimach to walk a new path, blaze a new path. We already know and understand as Anishinaabe our great laws of responsibility. We know and understand how to have a good life, and that Minowena Wendamoen. Minowena Wendamoen translates not very well into English, but it talks about everything, all beings, all life experiencing what might be called in English peace and harmony. And we have a law, Chinanok Nanokewan or Nishnave Anok Nanokewan. We've always had law. And in that law, in my training under Nishnave, I don't know, legal scholars, elders, I especially, I'm thinking of Musham Wandaban's Ba, who passed last year, and Harry Windigo Ba, and Roseanne Koser Ba. And I'm thinking of them. Several years ago, I had asked them, because I myself, my background in education is in political science, and I was learning the way non-native people do in their law. And I always go to the elders and say, how do we understand? What do we understand? And I'm humbled this morning because I searched to try to find what does it mean about rights, children's rights, women's rights, human rights, all those things. And there was no transcriptions around in equating that with the Western way. What I found out, and then still in training for, as I was learning from these people, what I found out was that rights was inherently embedded throughout everything that we did. And it was so broad and far reaching that it didn't only include the human, but it included those things I was mentioning earlier, those are life sources, water, earth, air, and fire. And that everything could be governed with, not by, but with, governed with those, some may be familiar with those laws of honesty and kindness. And when I was thinking about what I might share here, our first law is Zakagewin. Zakagewin is a law, not a concept, not an idea, but as a law. And that translates to love. Translates to love. And where we find that law is in our newborn children. They are the ones who teach us about law of love. And so I wanted to share just a little bit of that. And that is not me. That is those elders who shared and continue to share. So I can come to Nishnave Kendaswin, our way of understanding law. I want to acknowledge each and every one here. And I want to acknowledge those things that had come together to make this to happen. And I want to acknowledge OHRC and the people there. And I want to acknowledge also the people who are willing to speak here. Sometimes when we do these welcomings, openings, it's an opportunity for the rights holders to bring forward issues, concerns, celebration, what is happening in our communities. So if you know anything about Metropolitan Nation or where I come from, you'll know that there are two, what they call First Nations there today. There's New Credit and Six Nations. You may also know or not know that we are in the right now that we are looking for our children at the local residential school. We are with the Secretariat. We are looking for our children at the residential school. Something that you also may not know, and in alignment with reflecting, you may not know that we are also have several people within both our nations who are working right now on the day school process. If you don't know anything about day schools, they are working through that process. And so my Namawan, my hopes, my wishes, and my dreams. So we reflect on those things, but also remember that we, as Indigenous people, we are in the midst of some of those things. And so this is very, I'm going to listen hard today to pick up ideas on how to move things forward for my grandchildren, which I have four, for my grandchildren and for all our communities, all our people. Thank you for everything.
Nancy, thank you so much for welcoming us to this territory, to your territory in a good way. You know, we have many people that will do a land acknowledgement that are settlers. And Nancy is a knowledge keeper and Indigenous leader and opened us in a good way. But as a settler, I want to make sure that we acknowledge the land. And to do that as a settler, what we're acknowledging is the people of the land. And so the conference organizers and myself want to recognize the long history and many contributions of First Nations, Inuit, Métis, Indigenous people across this entire nation, which is known now as Canada. We honor these caretakers who have cared for and continue to care for lands across Turtle Island. So I'm incredibly thrilled to be your host for what I think promises to be a thought-provoking and engaging conference. In my time in human rights, I can tell you that there is nothing more exciting to somebody working in human rights than the Ontario Human Rights Code in this province. I always say it's like a blanket for us. It is something we're so proud of that has come to be, and it came into existence 60 years ago, and we're marking that today. So I'm going to tell you why somebody like me gets so excited about it. Many of us think of it as an important tool we use to say that you have identities that are yours, that you are born with, that you come onto this planet with, that need to be protected, that you should be able to go to work and work free from discrimination and harassment, right? And it's a way that we can use this code, this policy, to enforce that kind of respect for those identities and say you can't discriminate against people on account of them. We want people to go further than that, though. For me, the code, the reason I say it's a blanket is it's not just about enforcement and punishment. For me, it's about saying we want to honor the dignity of your identities. We want you to bring your whole selves to work, that your identities matter, that you matter as a person because of what you bring. And I think it's important to understand where this code, this Ontario Human Rights Code, came out of. So now 60 years ago, it came out after the Second World War, where there was an understanding that the atrocities and the genocide committed in the Holocaust didn't happen overnight. It wasn't something that came out of thin air. That these things happen because we allow them to happen in our everyday systems and institutions, and we do not take them into account or enforce when they come into play and enforce penalties, right? And so what happened was the community here said, we need to look at the ways in which discrimination is happening every day in our workplaces, in our communities, in our lives, and that it happens disproportionately to certain individual groups. At the time after the Second World War, over 60 years ago in Ontario, there were certain groups disproportionately affected that really played a role in saying, we want this to come to the fore. Jewish groups, Black groups, Asian Canadians, specifically Japanese Canadians, Indigenous folks, and all of these communities and women who saw disproportionate effects of discrimination said, we want to have a stronger focus. We want these communities and all communities to be uplifted in our human rights work. And so when we were thinking about a theme for today, it's hard to think about how you encapsulate 60 years of work into one day conference. We cannot cover everything. I promise we are going to miss stuff. We really try to be focused on a theme that we could dig deeply into and really think about where we've been and where we need to go. And so in light of that history, we wanted to look at our histories, right? And what's the history of systemic discrimination in this country, in this province? And how has that been embedded in our institutions, right? Systemic discrimination means that no matter who you put in the systems have been created or established in a way that they continue to discriminate regardless of the person there. So in changing the system, we can change outcomes for so many people. So we want to look at systemic discrimination, and the main theme of today's conference is to look at critically colonialism and its impacts and where we are today as a result of that legacy of colonialism. We want to open this up by having our first keynote who's going to share sort of where the Ontario Human Rights Commission comes out on this. And then we'll open up with an incredible keynote speech. So before we hear that first keynote speech, we'd like two speakers to help us set the stage for today for this discussion on decolonization and systemic discrimination, how we tackle it. So first, our first speaker, it's my absolute pleasure to introduce, is Patricia DeGuire, who is the Chief Commissioner of the Ontario Human Rights Commission. So Chief Commissioner DeGuire is a powerful and inspiring Black woman who pushes boundaries to ensure access to justice, equality, and equity every single day. Before her appointment as Chief Commissioner in August 2021, she served as Deputy Judge within the Ontario Superior Court of Justice and on various tribunals and boards. Many of you who know her will know she plays a leading role in many equity organizations, and this is her lifelong work. She's a constitutional law scholar, an avid mentor and coach for many young people and adults in the legal sector and other professions. Please join me in welcoming warmly Chief Commissioner of the Ontario Human Rights Commission, Patricia DeGuire.
Mr. President and Vice-Chancellor, Dr. Mohamed, Lachemi, Dean Young, other distinguished guests, and all the participants, a jolly good morning to you. This is indeed a great day. And thank you so very much, Assistant Dean Mello, for your warm introduction. I am honored to be participating with our partners at the Toronto Metropolitan University, the Lincoln Alexander School of Law, and the Human Rights Services. As Toni said, we're here today at the Human Rights at 60 conference to reflect and reimagine and to explore new directions for the human rights law and policy. Last year, the Ontario Human Rights Commission celebrated its 60th anniversary. And on the 15th of June, we celebrated the 60th anniversary of the Ontario Human Rights Code. The first legislation of its kind in Canada, the code was designed to affirm and uphold the inherent dignity and the equal and inalienable rights of all members of the human family by providing a legal mechanism to combat discrimination. The code was inspired by principles of individual liberty and minority rights established in Canada's constitutional traditions and by international and civil rights movement that emerged after World War II. Marginalized communities and unions worked together to push changes and advocate for legislation that included a right enforcement mechanism. So we had advocates like Louis Fine, who became the first chair of the Ontario Human Rights Commission, Daniel Hill, the first executive director of the commission, Kalman Kaplansky, who spearheaded a joint labor committee to combat labor discrimination in Toronto, Windsor, Montreal, and Winnipeg, Alan Borovoy, a human rights activist who was deployed to Nova Scotia and fought for residents of Africville and Aboriginal peoples, as it then was, to fight discrimination. We had Bromley Armstrong and Ruth Law Malloy, to name a few. Tracking the history, we see 1959, Ontario established its first anti-discrimination commission to raise awareness and to educate the public about these new anti-discriminatory acts. And by 1961, the Ontario Human Rights Commission and the Human Rights Tribunal of Ontario, then called the Ontario Board of Inquiry, were established. on June 15, 1962, the various discriminatory acts were brought together under the Ontario Human Rights Code. And in the beginning of the code, the prohibited grounds included signs, services, facilities, public accommodation, employees, trade union membership on the grounds of race, creed, color, nationality, ancestry, and place of origin. And you would see every one of those had a nexus to the first ground I mentioned, race. So Ontario became the first jurisdiction in Canada to formally recognize the moral, social, and economic consequences of discrimination by enacting the code and establish a Human Rights Commission. Over time, to reflect social changes, new grounds have been added to the code. Its broadened scope established Ontario as a national and international leader in human rights promotion and protection. And that first code reflected the thinking of that time, and the code continues to reflect the current thinking of times. So at this juncture, it is timely to reflect and to look ahead to respond effectively to the needs of our communities. The collective musings in 1977 produced Life Together, and new grounds under the code were added. Today, Ontario boasts over 200 languages and perhaps the same number of cultures. Is it time to undertake a similar inquiry? Today, the Ontario Human Rights stand 35 members large, having been left to hemorrhage from the wounds that were inflicted from a surgery between 2006 and 2008, when it was deprived of its gatekeeping responsibilities. As it was in the days of Hill, so it is now. Insufficient resources to carry out our mandate. As a small axe, undertaking a huge task like major inquiries to deal with systemic discrimination on 17 grounds. And despite keen strategic planning, best practices, and astute stewardship, we are unable to respond to the demands of our communities. The demands are growing exponentially. The needs are critical. Standing in this current space, I ask myself, and I ask you, every one of you, what are the pressing needs of the communities we serve? Today, we are at the intersection of the two 2020 catastrophes, COVID-19 pandemic and the global racial pandemic. Both have laid bare the inequities that plague or marginalized communities today. Flowing from them are the exponential growth of the EDI industrial complex and the IT and AI industrial complex. We hear about epigenetics and neuroscience, often presented as tools or approaches to dismantle systemic racism and other forms of discrimination. All offer an unprecedented opportunity to reset the dial. What are the needs flowing from them, and how shall we respond to the needs of our communities? Those are key, and every need is almost at its critical stage. And so I say to every Ontarian, you must understand the values of rights and the human rights institution that promote and protect those rights. And the value of rights include the responsibility of acknowledging all rights, not some. Every Ontarian must know that when we are enjoying rights, we must not enjoy rights to the exclusion of others. In Rights Speak, we talk about competing rights. But if we practice the golden rule, do unto others as you would have them do unto you, there may not be the issue of competing rights after all. For it behooves every one of us to follow the golden rule, to treat one another as we would like to be treated. In part, this is what this conference is about today, to reflect, to reimagine what human rights may look like in the new era. We can do this in a single space, albeit virtual, because of the strategic tool of collaboration. We achieve so much when we work together. Thanks to everyone for the hard work of putting this conference together.
Thank God.
And thanks to all of you for joining us today. I am eager to hear the exchange of ideas.
Thank you so much, Chief Commissioner DeGuire. We're so grateful for your important words and for the work you are doing to lead us all. Next, we have Dr. Mohamed Lachemi, somebody to whom I am very close and honored that he could provide a video for us today. Mohamed Lachemi is our Vice President and Chancellor at Toronto Metropolitan University, and he's going to provide some remarks on behalf of the university. As an internationally recognized researcher and accomplished academic administrator, Dr. Lachemi has been a key contributor to the growth of Toronto Metropolitan over a transformational time in the university's history. He's also a professor of civil engineering since 1998. He served in progressively senior roles, and I can tell you that everyone at this university will tell you he is a huge advocate for human rights, equity, and inclusion, not only at this university, but in the nation in general. He wasn't able to be with us today, but he shared a video recording of his remarks. So we're going to play that for you now. Thank you so much.
Thank you and welcome. I want to begin by thanking the three organizing partners of this conference: the Ontario Human Rights Commission, Human Rights Services in our Office of the Vice President, Equity and Community Inclusion, and the Lincoln Alexander School of Law at Toronto Metropolitan University. What a remarkable milestone. 60 years of the Ontario Human Rights Code. It is incredible to think the code was the first of its kind in Canada. In today's discussions, you will explore the evolution of this landmark legislation, looking at its strengths and weaknesses through the lens of the past 60 years, and imagining what the future might be. At Toronto Metropolitan University, we are proudly at the center of a multicultural international city. It is therefore an ideal space to talk about this important issue. Human rights, freedom from discrimination and racism are central to our university's values. We're pleased to see those values in action as we hear the voices of members of diverse communities who have been historically and systematically marginalized. And we are excited to be hosting today's conversations on what a future human rights system could look like when we center perspectives by Indigenous, Black, and other marginalized communities. The conference is very timely for our university. As you know, we recently changed our name in response to the voices from our own community and elsewhere. We know this is just a first step in reconciliation and first step down the long road towards an equitable and just future for all. This conference is timely also because in the coming year, our university will be embarking on a major review of our human rights policy. So I'm excited to hear the perspectives and insights from today's conversation. And I'm looking forward to seeing how we can incorporate these ideas in advancing the culture of human rights at Toronto Metropolitan University. I wish you all the best for a wonderful conference. Thank you.
Thank you so much, President Lachemi. So our program today is jam-packed, as human rights work often is. And I know we're all eager to hear our first keynote speaker. But first, I want to do a little bit on accreditation and logistics because I know many of you are interested in that. So we were able to get today's conference accredited for 5 hours and 45 minutes of EDI professionalism content at the Law Society of Ontario. So you can look at the conference agenda for more details on that for those of you who need it. But this is a really big deal to have this much access to EDI credit that you need and free and available to everyone that wants to join, whether or not you're in the legal sector. And so we're really grateful for the work that went in to make that happen. We also want to let you know that each of you can share your questions with our speakers during the session. If you're joining on the Zoom webinar, you just pose your questions under the Zoom Q&A feature. If you're watching the YouTube live stream, you need to submit your questions via email. So just do that to ontariohumanrights60@gmail.com. So that's ontariohumanrights60@gmail.com. So we encourage you to send your questions throughout the day. My guess is we won't have time to answer all of them, but we will do our absolute best. And we also want you to join the conversation if you're able on Twitter. You can do so using the hashtag #HumanRights60. 60 the number, okay? We're almost ready to transition into our first conference session, the morning keynote. It was the first thing I was excited about when I got up this morning. If you haven't heard this person speak, you are in for an extraordinary surprise. So I'd ask you to please bear with us as we move between sessions throughout the day. You might see a slight delay as speakers come on and off screen, but please be patient with us. So let me introduce this first morning keynote. As we prepare to hear from Dr. Cindy Blackstock, I'd like to introduce Raj Dhir, who's going to moderate this session. Raj Dhir is the Executive Director and Chief Legal Counsel of the Ontario Human Rights Commission. And before taking on that role, he was a portfolio director at the Ministry of the Attorney General Civil Law Division, where he spent over a decade in a wide variety of management roles. He also spent 11 years as counsel at the Ontario Human Rights Commission, where he has litigated and advised on a variety of human rights matters and appeared before administrative tribunals at all levels of court, including the Supreme Court of Canada. This is a person that's extremely knowledgeable on human rights and has been an advocate, a litigator, and somebody that has worked at the forefront on Ontario in this work. Raj, welcome.
Thank you, Toni. It's my great pleasure to introduce Dr. Cindy Blackstock. Dr. Blackstock is a member of the Gitxsan First Nation. She has over 30 years of experience working in child welfare and Indigenous children's rights. Through her work as a professor at McGill's School of Social Work, and particularly as the executive director of the First Nations Family and Caring Society, Dr. Blackstock has had a significant impact on First Nations children, their families, and communities across Canada. Dr. Blackstock is, of course, most closely identified with the case she championed involving First Nations Child and Family Caring Society and the Assembly of First Nations against the federal government in 2007. This case was about the failure to provide equitable and sufficient funding for child and family services to First Nations children on reserve and the failure to implement Jordan's Principle. Dr. Blackstock is going to talk to us today about her experiences over the last 15 years using the human rights system as a tool for addressing systemic discrimination experienced by First Nations children in Canada. She will also speak to how the human rights system can be utilized to disrupt long-standing colonial discrimination, including inequality in the provision of services for First Nation communities on reserve. Dr. Blackstock is the perfect speaker to kick off Human Rights at 60 today. As we reimagine what our next 60 years will look like, there is no doubt that Indigenous communities will shape human rights in this province and in this country in meaningful and challenging and inspiring ways. Dr. Blackstock has been at the forefront of that change, and we are so pleased to have her join us today. Dr. Blackstock, the virtual floor is yours.
Thank you. It's a real honor to join all of you. I just need to have my video enabled. There we go. There we are. So I'm really honored to join you from unceded or Algonquin territory in Ottawa, where I normally live, but today I'm coming to you from Treaty 6 territory. You know, I still remember the day when I went to see a First Nations little boy in the Squamish Nation. His standing frame was held together with duct tape. Now, he lived on a reserve that was just across the street from a major metropolitan center, Vancouver. And I had worked in Vancouver. And when I would find children like him, I would just call up the health professional. They would make sure that the child had the equipment they needed, and the government would fund it. But in his case, the federal government said no. He actually had a wheelchair provided to him 3 years before, so it would be another 2 years before he would be eligible for any kind of mobility equipment. This was outrageous to me. And it was when the inequalities in First Nations public services for children came into stark relief. I was convinced of really three things back then. First of all, somebody needed to do something about this. Second of all, it was not me who needed to do something about it. I wasn't familiar enough about human rights. I didn't know enough about this. There had to be someone else out there who could do it. So my job was just to wait around and hope that happened. The third thing is there has to be a pathway to holding the government accountable for this discrimination that's gone on since Confederation, where First Nations children are getting what amount to apartheid public services, but being judged by a Canadian public who didn't know any better. Well, eventually that waiting didn't pay off, and I realized that despite all of my fears, including my profound fear of public speaking, I'd have to cross into this fora and try to work with others to do something about it. And that's what the setup is for the Canadian human rights case. But first, we need to understand more about the Canadian government as a respondent. Was it, as I had originally believed, that they were continuing to give First Nations children less because they didn't know any better? Or if they did know, it must be because they didn't have an answer on how to fix it. I had not taken myself to that third category, which is that they chose not to fix it. That they did know. They knew it was harming kids. They just didn't want to do anything about it. And had I looked back in the colonial history in a more detailed fashion, I would have known that. This is a photograph of Thomas Moore. Now he is in Regina Residential School. This is a famous photograph that was taken as a propaganda picture. Now, you might think, looking at the photograph, that the one on the left is a before the assimilative experiment, and the one on the right is after that assimilative experience. But you'd actually be wrong about that. You see, what they did was far worse. They actually dressed Thomas up in the most extravagant mishmash of what they thought regalia was as part of a public relations thing, so that they could really put into stark relief their civilizing project. Poor Thomas dies at a very young age from tuberculosis, like many First Nations children did in that era. And why were they dying at such prolific rates? Well, they were dying because the government of Canada was giving them far less healthcare funding than everybody else. And the health practices in the schools were horrendous. Now, the government knew this. Laurier, Prime Minister Laurier knew this personally. The bureaucrats knew it personally, and they knew it from their own medical health inspector. And they chose not to fix it. The public knew too. Look at these headlines. These are from 1907. This is pointing out the knowledge from the public health officer, Dr. Bryce, and his reports about how these unequal healthcare funding and practices like the children being exhausted, malnourished, sick kids being put in with healthy kids, poor ventilations in the schools, all of this was creating what the newspapers of the day were calling incubators of disease, resulting in startling death rates. And you can see the editors of the paper didn't normalize it. It wasn't one of those things that people back then didn't know any better. Clearly they did, and it was shocking and horrifying. But even then, there was a sense that the government would not be moved, even by this compelling moral project that they had an opportunity to save kids' lives. And we see this, the one on the left, by the way, is from the Victoria Columnist. The one on the right is from the Saturday Star. And there's an important thing in the Saturday Star that I think that we need to really think about in the contemporary context. It says, he, and that means Dr. Bryce, their medical health officer, has the statistics before him revealing a condition disgraceful to the country. He has visited many of the schools and wonders that the death rate is not greater than 25% a year. And yet he recommends nothing. That actually was not true. He did do recommendations. But the article goes on and says his report is printed. Many people will scan the title on the cover. Some will open it. A few will read it. And so the thing will drift along for another year. And so with the next year and the year after. Such will be the course of events. The protests of medical health officers buried in blue books and complaints of missionaries lost in pigeonholes, unless public opinion takes up the question and forces it to the front. This is 1907. There was a sense there that the government was not going to choose anything other than letting these children die, unless the public was outraged for a sufficient period of time that they would take action. Now, we know that the public was outraged. In fact, we have Samuel Hume Blake, a lawyer, a judge, and a co-founder of Blake's law firm, writing in 1908, that he wonders if Canada's failure to obviate what he calls the preventable causes of death brought itself into unpleasant nearness with manslaughter. But not enough of them stood up, and the headlines soon turned, and the headlines died, and so did the children. This is what the normalization of this type of discrimination looks like. Had I known that, had I better understood that Canada was choosing this pathway, they were choosing to give these kids less. When I entered into the national scene in the mid-1990s, I would have not been sucked into this process of using official procedure to mask inaction and addressing the hardships for kids. Following on the Royal Commission on Aboriginal Peoples in 1996, the same year the last residential school closed, we were finding that there were more First Nations children in child welfare care than at the height of residential schools by a factor of 3. And one of those areas was the underfunding of child welfare and other public services for First Nations kids on reserves primarily. So I get into this and I think they mustn't know or they mustn't have the solution. So we do the report with the government. They admit that they're funding 70 cents on the dollar for First Nations kids, and that the key area of inequity is the help to keep families together. They write us a nice letter. They say they're reviewing this report, that they'll take it seriously. And of course, they care about Indigenous kids. But they need a more detailed report, they say. So I get sucked in a second time and we do the second set of reports. We employ more First Nations experts and also economists to cost out the inequality in detail and propose solutions. This again is done with the government. By then, 5 years later, the discrimination has deepened. And now First Nations children are getting 70 cents on the dollar compared to other kids. And we also have Jordan's principal come forward. We're out of the story of Jordan River Anderson, who was spending 2 years unnecessarily in a hospital because governments couldn't figure out who should pay for his at-home care because he was First Nations. You see, this is the kind of using of official procedure. It helps us feel like we're doing something, but the suffering doesn't stop for children. During the time when we were at the table doing these reports, the number of First Nations kids going into care increased 71.5%. So we filed the human rights case, the Assembly of First Nations and a Caring Society, finally, giving up on the fact that we were getting no real action from the government. And within 30 days, the government took immediate action. They cut all of our funding. And I think the hope was that we would just disappear. And this is why we were so heartened. We were literally on a shoestring budget of donations, and we did things like doing our own janitorial to try and save money in our office. The Auditor General, Sheila Fraser, weighs in 2008 after we filed this, and she agrees with the inequalities. And the government agrees with her recommendations and her findings, but they do nothing about it. Like, this is how systemic racism plays out in our country. And I need to say, too, that there was very little action from the human rights community about these apartheid public services. There was a normalization of this level of discrimination that really kept those from in mainstream human rights organizations from really taking any action here. In fact, even though there are investigative powers under most human rights statutes, no one had thought to exercise those in this circumstance. It was left to us as First Nations to really do that work. And that's something that I think I'd encourage all of you to do. So in that 2005 report, and I also talk about this case as one of the biggest boondoggles of public policy, because back then in 2000, it would have been hundreds of millions of dollars to fix. Now we're talking north of $40 billion to fix this. But there was a passage in this 2005 report, which I think is as close to a crystal ball as we could as what is going to happen in the next 20 years. And it was really where we costed out the cost of doing nothing. Nothing seems is seductive because it feels like inertia, that nothing is going to change. We're not going to do any harm. We're not going to do any good. But the reality is, for kids, it was doing devastating harm. And we said that, Canada could be found vicariously liable for discriminatory funding and child welfare, knowingly resulting in harm and disadvantage for another generation of First Nations children. And the political fallout will be substantial, especially on the heels of residential schools. So there's no question that Canada knew this, but they just banked on the fact that this would never really get to public attention, and they wouldn't have to move. And I think that that's an important point. They didn't disagree with the findings of their public health officer when he raised the alarms about the unnecessary deaths of kids in the schools either. Now, there was when we were looking at filing the report, one of the things that was really important to us is the government agreed with the inequality. In fact, we had to go no further than their website to look at this. This is the actual website, their fact sheet that was in play when we filed the complaint. And you can see here that on the left, you can see that they talk about the disproportionate overrepresentation of First Nations kids in child welfare, and that reflects the lack of available prevention services. So they absolutely knew about it. And then in the middle, you have speaking notes from a deputy minister to a parliamentary committee that lays the whole facts bare. Circumstances are dire. Individual resources may force individual agencies to close down. But still, in the face of that, and in the wake of residential schools, the department didn't think these kids were worth the money. And in Jordan's principle, we see another track record. We see poor Jordan dying in the hospital unnecessarily, never seeing a family home because he's First Nations. If he was a non-Indigenous kid, he would have gone home. So there's the founding of Jordan's principle in 2007 under the leadership of then member of Parliament Jean Crowder. The Parliament unanimously approves Jordan's principle. But what does the government do? They don't implement it. They take this child's sacred memory and they craft a definition so narrow that no child would ever qualify. So they took a sacred gift and made it discriminatory. I mean, what an insult to a child's memory. And then even after the tribunal ordered them to implement the full definition of Jordan's principle, which is really about ensuring First Nations kids can get the access to the public services they need free of discrimination, the government then still kept discriminating. The definition they had was something along the lines of, well, Jordan's principle applies to kids with disabilities and kids with long-term or short-term medical needs. Well, what about kids with cancer, we would ask? That may not be short-term. You mean they don't get any help? It was ridiculous. Yet they would often profile themselves as being the victims, that we weren't appreciating the government enough for the good measures it was taking. They would say change can't happen overnight. All of this was ridiculous in a defense of a country that is one of the wealthiest in the world, and it was using racial discrimination against children to fund projects like hosting the Olympics and other types of things. So we have had about 19, actually that's an undercount, we're now at 22, I think, procedural and non-compliance orders against Canada since the 2016 decision that substantiated the complaint. And thankfully, those non-compliance orders are starting to have an effect in that we've had 1.3 million supports given to First Nations kids that they otherwise would have been denied. But we're not there at full compliance on Jordan's principle yet. And this just shows you how resistant Canada is. It's not that they don't understand, it's that they're actually fighting to ensure that they are not having to give these kids the same services as other kids. They are really doubling down on the same narrative that they were foisting onto poor Thomas More, which is that you are a savage and you are not worth the money. They won't say it in those terms, but their actions actually result in the same output. There's the House of Commons motion. You can see there that there was no dissent. And on the left, I just want to point out, this is Jordan's family. Like there's real people behind this, right? And in the government disclosure, what I found one of the markers is that the government would rarely talk about these children as people. They would talk about it as a file. They would talk about it as a system. They would talk about different kinds of government policies, but they'd never talk about the children themselves. And that's one of the cycles we have to break. So here's the case, we filed it. It would be 8 different motions that Canada would bring on technical matters before it was ever heard by the tribunal. They're trying to get it kicked out on jurisdiction. And for me, as a complainant, as someone who was not a lawyer, I was astounded that they wouldn't actually argue this on the facts. And I know I probably was really naive, but I think for most complainants, we think that they're going to press back on the evidence. And that's the way that I wrote the complaint. But that's not the way that they're going to argue. They're going to try and find some kind of procedural mechanism because they know the facts are against them. And I think we need to find a way of balancing what is Canada's procedural fairness efforts to the actual harm, against the actual harms that are happening to people, because I think far too much oxygen was taken up by these procedural matters. And as you all know, in 2016, we got the order from the tribunal substantiating a complaint. It's the first one in the world that I know of where a government has been held accountable for its contemporary discrimination against First Nations children. And that's important because we've seen a lot of apologies, you know, like, oh yeah, we did a bad thing and we're going to pay compensation. Well, the problem with that is that Canada's a repeat offender. They did that with residential schools. They did it with the 60s scoop. And indeed, they're going to have to compensate the victims of this complaint as well. So we're seeing this repeated behavior where the department is never reforming itself. It's always repeating the behavior and doing these payouts. But the sad thing is that kids are literally paying for their childhoods, in some cases, their lives. So what did Canada do? I think one of the things that surprised me too is I knew that they would fight. I just didn't realize how the extent to which they would go. For example, not only did they cut our funding to the Caring Society, we are still the only First Nations, Métis, or Inuit organization that is not government funded. They also use these procedural or jurisdictional challenges. And then they even went as far as obstruction of process. What happened there is that we're moving towards the hearings finally in 2012, after the federal court dismissed yet another attempt by Canada to get this case kicked out on jurisdictional grounds. And I filed an access to information request because this disclosure seemed really spotty to me. And I was told by our legal counsel at the time, you don't need to do that because they have to disclose everything. And I thought, well, I don't trust them. I'm going to do it anyway. And we were then 3 months into the hearing when I got an access to information disc with over 4,000 documents on it, 4,000 pages of documents, highly prejudicial against Canada that they did not disclose. This was then brought to Canada's attention where they say, oh, we're just getting those together for you. And by the way, we have another 50,000 to put on to you. That withholding of evidence was done consciously by the government, the tribunal says. And this was delayed the hearings, therefore delayed justice for kids. And we see this withholding of documents, not just in this case, but remember in the Truth and Reconciliation Commission itself, it had to take Canada to court to get disclosure of Canada's residential school documents. So this weaponizing of disclosure was something that I had never thought they would do. I was also unprepared for their retaliation. I knew that they would cut our funding. I was pretty clear about that, but I didn't realize that they would actually go into doing surveillance against me and others. And so we'll get into that in a bit and the depths to which that went. And then the repeated non-compliance with legal orders made under their own law. I've really come to see that if you do not have a good enforcement mechanism that has some significant penalty to the government, they're prepared to just ignore it. You know, it's cheaper for them just to ignore the decision versus comply with it. And this was extraordinary because even if you read the Canadian Human Rights Act itself, it presumes that persons who are doing the discrimination are actually going to remedy it. We've created this whole new body of law around non-compliance orders in this case. So what was it like for me as a person coming into this? Well, I'm a First Nations person. I am a social worker. And I was the one who wrote the complaint on the basis of evidence. And the problem with that is that you're writing it and you're not thinking about the jurisdictional challenges that might come later. For example, Section 5 of the Canadian Human Rights Act notes that that you have to bring a claim against a service and that it can be a denial or a delay of service. Sections 5A and B. Well, I didn't write those in a complaint. I just said Section 5, but thank God I did, because that mention of Section 5 was actually something that kept this complaint going when Canada tried to get it dismissed at the federal court and federal court of appeal. And we also need to craft the complaint so that we actually get the remedies we need. None of these things were on my radar when I wrote that complaint back in 2007. So I think one of the ways that human rights commissions can be helpful is actually assisting you when you write the complaint, right? Helping people in these systemic things write these complaints, knowing that these systemic challenges will come forward. The other is that not only was I I'm pretty fluent in cross-cultural stuff. I consider myself pretty good at that at this point, but I was entering into a new culture, and that was the culture among lawyers themselves, the different kinds of words that they would use, the different types of courtesies they would offer each other, and the way that they would conduct cases. Now, I think because I had never really been involved in litigation like this before, I just assumed as a client, we give instructions, so we need to be involved in this thing. So I would attend case conferences, I would help with the writing of submissions, I would even make oral arguments. And all of this was new to me. but it didn't feel unusual. What I came to understand is that there was sometimes a view that by me making opening statements in the tribunal or in the courts, that somehow was an expression of non-confidence in counsel. That was not the case. It was actually about being heard and being able to tell the story from a human point of view. Because the law itself is very antiseptic. And what we always wanted to do in this case is bring it back to the children. So I would speak up in these cases, and I think that there needs to be more space for that and more space for actual real involvement of clients. I worry sometimes that human rights cases are largely run by lawyers without a real centering on the client experience. And a glossary of terms is sometimes helpful, right? In this case, we had, we even brought a mandamus application against one of the tribunal chairs to get her to rule. So all of this stuff is brand new to me. And it would be really helpful to kind of have a glossary of terms and also a clear-cut sense of the process. When we filed the complaint, the reason we went for the human rights case over the charter was that the Canadian Human Rights Act, there was a pamphlet that says, this is kind of citizen friendly. Anyone can do this. I thought, well, they're perfect. And this is what we're going to do. And we can get more specific remedies. I come from the community that filed Delgamoot. And I was alive to the issue even then that you can get a charter victory, but then there's no real implementation of remedies. So I didn't want to go down that route. The other is in preparation of witnesses and safeguards. In this actual case, I'll never forget, it was in 2009, and it was one of my first times I was cross-examined by Canada. I think I was cross-examined 5 or 6 times by them for weeks. It would eventually be weeks on end. But this was one of the first times. And the Canadian Government Counsel had me sworn, had me affirm under the oath. And the first 2 questions out of their mouth was, do I believe in God? And was I in child welfare care when I was a child? I think that this lack of decorum, this willingness to use their power to try and incite the witness was completely inappropriate. I was thankfully okay with responding to it. I just simply said I wasn't aware that a belief in God was a prerequisite to telling the truth under Canadian law. But many, many witnesses would not be. And I think when you're dealing with the government of Canada, you have got to prepare witnesses for very difficult cross-examination on matters that are unrelated to fact. And so that witness preparation piece, I think, is really, really important. There also needs to be part of this culture in the case is, oh, well, the government of Canada didn't meet its deadline for filing, and they're asking for a short extension. It seems reasonable in a moment, but the problem is that they will always be late, and they always ask for extensions. And our small organization, which then had 4 people, we were always filing on time. So eventually I saw that this was a strategy they would use. And so we created an ethical screen to balance their procedural fairness requests, or requests for things like extensions, against what was happening for kids. And if the extension was not in a service for kids, I would object to that. And I know that the usual discourse and lawyers is to allow each other these extensions, but I think in a human rights forum, we need to really safeguard the people who are being victimized by these breaches against this type of procedural. The final thing was having kids at the hearing. That was a natural thing for me, is this is a systemic case about children. The UN Convention on the Rights of the Child includes Section 12 that says kids have a right to participate in matters about them. So we invited all kinds of kids to the hearings. And the children, they actually wanted to testify in the case. They wanted to testify as non-Indigenous kids about why this was so wrong and what that meant for the society they were growing up in. First Nations kids wanted to testify, but there was no mechanism to allow for that in a systemic case in Canada. And because of Canada's inappropriate, in my view, cross-examination of me, like asking me if I was in God, we couldn't put children in that scenario. And so we had to find other ways of trying to get children's voices into the hearings. And that would be inviting the children to be there. It was ensuring that the proceedings were broadcast so children could watch them in their classrooms and watch them across the country and be a key part of learning about it. But I think that there needs to be some more guidelines in human rights cases that allows for children to meaningfully participate and testify in systemic cases. So the other piece is this human rights case was important, but we knew when we filed it that Canada would want to keep it in the dark space. That's where Canada likes to operate. The turning of the headlines. So what we did is we actually nested it in a social movement, and this is kind of consistent with Rosalia Bella, right? Is justice may be blind, but the public isn't. Need to bring the public into this. And that's like what the Saturday Night magazine was saying in 1907. So we would load all of the government's documents onto a website, load all of ours, and we wouldn't ask the Canadian public to take a side. We simply asked people to watch. And this was our way of trying to expand the circle and create that public pressure on Canada, because the evidence was so overwhelming that what Canada was doing was wrong. So I think the lesson here is to litigate in human rights, but also in a systemic case nested in a social movement and involve children in that. Broadcasting was key, and thanks to APTN, the Aboriginal People's Television Network, they brought a motion at the Canadian Human Rights Tribunal against Chair Chatalia, who was the same one who originally dismissed our case. It's a whole story there, but I won't get into it. She said that no, this case could not be broadcast. Canada wanted it out of the television screens. They had no interest in this thing being filmed. All the rest of us were for it being filmed. And Canada's arguments basically boiled down to, well, we're going to have public servants testify, and that's an invasion of their privacy. Well, we went to federal court. Chief Justice Lefty of the federal court disagreed with that, said this is a systemic case, and therefore there is a public interest in it being broadcast. So this particular hearing opened up not only the televising of all of the Canadian Human Rights Tribunal hearings, but it was also a precedent setting for the federal court. We've been to federal court 7 times now, and also to the Federal Court of Appeal. And I would argue that this is something that ought to be done in all systemic cases. There are mechanisms, and the tribunal has shown good practice to ensure that when private information is shared about a particular individual, that's safeguarded against broadcast. But the vast majority of the evidence is all systemic and ought to be available to the public. And the good news about this is that this generation of First Nations children or the Canadian public never have to rely on me to say what happened in that hearing room. They can watch this. They can make up their own minds about what is going on in that hearing room. Again, with the children's participation, we need to develop guidelines for courts and tribunals on human rights cases that are consistent with Article 12 and the United Nations Declaration on the Rights of Indigenous Peoples. First Nations are amongst the most impoverished in the country because of these inequalities in public services that continue to be foisted on them. So there needs to be accessible mechanisms for people to participate no matter where they are. And we need to promote the children's participations and make sure that they have opportunities to understand legal procedure and rulings. And what the kids involved in this case showed us is they're completely capable of understanding that stuff. You just tell them what the various people are, what their roles are, who the judges are, what kind of decisions they'll be making, and then what the evidence is, and allow them to engage. So one of the things the kids saw was Canada's breaking of the law. And, there were 4 places that really Canada broke the law in this case. And this isn't a matter of opinion. This is a matter of legal ruling. The first is that Canada put me under surveillance. They started around 2010, and they were looking for something that could get the case kicked out on frivolous and vexatious, because their efforts to do it on jurisdiction were not paying off. So there is this whole process of going onto my social media, following my personal movements. They'd even make comments about when I was not at events. So the privacy officer looked into that and found that to be a violation of the Privacy Act. I found out about that through a privacy request again. So this really speaks to the importance of this access to information stuff. The obstruction of process, the withholding of those, what actually became 90,000 documents, it wasn't 50,000, by the CHRT. The CHRT found what Canada was doing against me to be retaliation. So that was a third piece that they did, was the human rights retaliation. And then the more problematic piece about their non-compliance with the Canadian Human Rights Tribunal's order. And I need to say this non-compliance was not benign. The tribunal, in an uncontested ruling by Canada, links the deaths of 3 12-year-old girls in 2018 to Canada's non-compliance under Jordan's principle. So, but Blake, back in 1908, wondered if Canada's failure to obviate the preventable causes of death brought itself into unpleasant nearness of manslaughter. I still think that's a contemporary question that ought to be answered about Canada's conduct towards this generation of children. So here's an actual one of the access to information documents that I got. And I think you have to prepare your clients and those who are complainants for retaliation when it comes forward. And you can see here that it's clear what they're after. It turned out that they deployed about 189 different public servants, not the RCMP, because they would be accountable under certain guidelines, not CSIS, but bureaucrats to kind of do this type of surveillance, which I think is completely unethical. And they will do this to try and find a way to prove other motives for filing the complaint. Now, we of course had retaliation hearings in this complaint, and they were invited to prove what these other motives were, but they were never able to evidence anything. This is just clearly an intimidation tactic by Canada. So how do you manage backfire? And how do you prepare complainants to manage backfire? Well, I think one of the important things is to know how it happens. And this is a great article by Gray and Martin. And they talk about kind of the top 5 ways that corporations or other big systemic rights abusers will get involved in this. And one of them is cover up. Of course, you know, nothing to see here. Devaluation of the target, which is what they were after with me. Reinterpretation of events. We see that quite often, right? The official procedure, we talked about that. Reports to nowhere, inquests that never get implemented, and intimidation and bribery, right? So, and actually I experienced kind of both. I had the intimidation, certainly, of the retaliation. And most distressing to me is that my 17-year-old nephew was living with me at the time. So it's not just me alone, it was also him. Bribery, it wasn't outright bribery, but I did get a very curious call during the course of this case from a senior government official offering me a very lucrative federal position in the government service. All that was required of me, he said, was to be loyal to the minister. And I told him I am very loyal, but to the children and not to the minister. And that ended that call. There's Frontline Defenders. I think everyone needs to know about this organization. They actually are there to protect peaceful and respectful human rights defenders. This organization came to my aid, and they certainly are out there. And I think every Human Rights Commission needs to do 2 things. One is enshrine the UN Declaration on Human Rights Defenders into your act and put further measures to protect against retaliation. One of the weaknesses of the Canadian Human Rights Act is there is no injunctive relief. So even though all this documentation showing what Canada was doing was available as of 2011, there was no mechanism to get the Canadian Human Rights Commission or Tribunal to issue an order to get it to stop pending a hearing. Nothing like that. So this is something that ought to be done in Canada. And folks should, if you don't know about this organization, you should look them up. The strategies Canada is using in our case go way back, and I'm not going to go into them now because of the interest of time. But one of the things that is important here is this is Jerry Gamble, a former Indian Affairs employee, setting out what is the department's old mindset that the tribunal repeatedly notes. It's this old way of thinking, this colonialism that keeps on seeping into the way they respond to this case. And a couple markers is that they make themselves out to be the victim. They supplant the children for themselves, and that they make the problem about them not being appreciated enough, that this is a very complicated thing, that they have to go out, they'll even put us in the window and weaponize First Nations people and say, well, we need to talk to First Nations people. That's why we're not doing anything. Just to be aware that this kind of narrative has been passed down from generation to generation of bureaucrat. And we're looking now at the Canadian Human Rights case about how to disrupt that. And we're looking actually into the research on undue influence, which is very important now, given that we're dealing with QAnon and everything else. But the same type of thing is happening in the department, where persons enter into the public service with a good set of public compassion and ethics that guide their action. But through undue influence, they start to get to a place where they will actually perpetrate these horrible crimes against kids and human rights abuses. And it really begins subtly, like you get in the door and then people say, well, that's not the way we do things around here. You got to realize that you're just new. Once you understand, you'll begin to understand. And then when you see what the repercussions are for speaking up, you think, well, I got to keep my job. I got to feed my family. And you start to then rationalize all this good stuff. So we're working on this stuff with one of the leading undue influence experts in the world, Stephen Hassan, who wrote the book, A Cult to Trump. And I really recommend human rights groups look at this, because as a rise of hate and other things around the world, it's very important. Going to wrap up here in just a couple of minutes, but all this to say that everything we went through was worth it for First Nations kids. I would do it again in a second. We have been able to make some inroads in getting them the supports they need, but there is still no firm compliance, and it's uncertain in the future as we're in this space around the final agreement about how we're going to hold Canada accountable. If they aren't prepared to really observe legal orders under the tribunal, and we have to go back for non-compliance orders to get them to move, what is it going to look like after we sign off on a final agreement? That is a major question. And also we need to appreciate that this is only one aspect of First Nations kids' lives. There's still lack of water on reserves. Only 35% have broadband. All of these inequalities continue to pile up on the kids' hopes and dreams, and they need to be addressed. And we have a mechanism to address it, the Spirit Bear Plan, cost them all out, and then come up with a Marshall Plan to address it. Canada has not agreed to do this. So this just shows you how difficult it is to get the Canadian government to move. Canada, however, has come out with a new law affirming jurisdiction in child welfare. But I'm unsure what this actually is looking like. Is it offloading, or is it real, sincere affirmation of jurisdiction? Because we filled up the bucket of hope with prevention services for families for the first time in 154 years. And it feels like when Canada is saying, if you draw down jurisdiction, that the orders don't apply, they're putting holes in the bottom of that bucket, so that they're actually transferring the liability over to a First Nation and really getting rid of the mechanism to hold them accountable for proper funding. So I think it's important to really look at what they're doing very closely. Watch some of these other cases. This is one on policing. This is relevant to the Spirit Bear Plan, where the tribunals made a case about the policing funding being inadequate. And Canada is appealing that decision, and they're using many of the same jurisdictional arguments they used against us. There's one in Manitoba that is at the Manitoba Court of Queen's Bench, where the Canadian government just sat on the sidelines while the Manitoba government took the children's special allowance for kids in care and put it into their own coffers, leaving it to a grandmother to fight against the government of Manitoba to get that money back. Moreover, the legislature in Manitoba filed a law saying that no one could challenge them on this. This is ridiculous. But it's a charter case, and it was decided in favor of the grandmother. But the question is, will Manitoba still appeal? So we're leaving really individual citizens in situations where they're having to litigate. C-92, the Act Respecting First Nations Children, is up at the Supreme Court this year. The constitutionality of it is being argued between Canada and Quebec. This brings me back to the St. Catharines Lumber Company case, where we had two non-Indigenous governments arguing over who had rights over First Nations lands back then. This was over about 100 years ago. And now we have two non-Indigenous governments arguing over who has jurisdiction over First Nations kids. We are going to be intervening in this case, but this is a very important one for human rights defenders to look at because it speaks right to UNDRIP. So what are my wishes if I had them? If I was me 15 years ago, I would say you would never have your ducks in a line to file a human rights case of this nature, but do it anyway. I would say that they are going to come for you. They are going to retaliate against you, but it's our job as adults to stand in the winds of discrimination so that kids don't have to do it alone. Do it anyway. I would say hire lawyers who fall in love with the children because they will bring the best skill set to the job. If you just hire someone who's a technician and they're not in love with the kids, they're not going to be able to endure this case. Frankly, they're not prepared to spend the money against a litigant who has got an endless bucket of money. Have ethical screens to balance procedural fairness, open hearings that are broadcast, have guidelines so kids can participate, improve the protections for human rights defenders. Like, this is ridiculous that citizens can't use legitimate legal mechanisms to challenge governments without fear of retaliation. Better enforcement measures and a more willingness by commissions to actually to take enforcement measures against Canada. And more interventions by human rights commissions in these precedent-setting cases. We had some interveners by human rights cases at some points, but not a lot. And I was kind of surprised by that. And I was also surprised that they weren't using their authority to conduct investigations proactively. Nest the case in a systemic movement for sure. Legal challenges are absolutely necessary, but not sufficient. And improve access to information. Don't rely just on disclosure. Make sure that you're using access to information laws and advocate as human rights commissions for the improvement of those laws. And funding for these systemic cases needs to be provided when people are acting in the public interest. They shouldn't have to rely on donations and other types of things to do it. You can watch this film. Go check it out. You can even, those of you on Air Canada, you can watch Jordan's Story free of charge on their entertainment system. They're on Netflix. They're also available at the National Film Board. Take you right inside the courtroom so you can watch this case live. And we also have books on from children telling the true stories of that, and even an animation of the courtroom. So all of this to say that without the human rights mechanisms, we would have not made these gains for children. But there is so much more we can do to end this broad sweeping apartheid public service regime and challenge other reports that go unimplemented, like murdered and missing Indigenous women and girls. We just have to have the courage and the dedication to do it. Thank you.
Thank you, Dr. Blackstock, for starting us off today with such a powerful and inspiring presentation. Even though your experience was with the federal system, there are so many lessons from the experience that are transferable to other human rights systems, including in Ontario. we've got a little bit of time for some questions. I've already received several questions from the chat. And I'm going to try to integrate a few different questions into one. So let me start by asking you, Dr. Blackstock, you talked about the importance of public outrage and enforcement mechanisms during the course of your presentation. Can you talk about the importance of ensuring accountability when addressing systemic discrimination? And I guess my other related question, just to try to bring in a few different questions that I've received, is the legal system the best way to achieve that accountability?
In our case, it was the only way to achieve accountability other than in terms of legal orders against Canada. But that would prove to be insufficient. For example, when we've had 30 legal decisions in our case, all in favor of the kids. Canada won once, but that was overturned on appeal. So their record in the courts is abysmal, right? Where things really changed, though, is with the children in the unmarked graves. When the public pressure came to bear last summer, and then we had the election where the Prime Minister is being asked, are you really fighting First Nations kids in court? This started to be just an outrage for the Canadian public, an election issue. The legal losses, along with the public pressure, is really what forced Canada to announce that $40 billion, which I don't think will be sufficient, and they bracket by 5 years, but that's an important piece. Mm-hmm. So I think we need to strengthen the non-compliance measures to have serious ramifications for big organizations and states. I don't think human rights mechanisms necessarily contemplated resistant, large respondents. And I think the penalties for those groups ought to be in keeping with their public profile and their financial resources.
You know, of course, when the Family Caring Society brought the claim, the co-claimant was the Assembly of First Nations. Yeah. In their opening statement to the Canadian Human Rights Tribunal, they said, the Human Rights Act has the potential to cure the deficiencies that allowed the Indian residential school to happen. It can provide a measure of power to First Nation communities and can play a tremendous role in ensuring federal accountability. Can you expand on, I know you spoke a little bit about this, but I'm wondering if you can expand on why you chose the human rights system specifically as the forum to seek redress for the First Nations Child and Family Caring Society claim?
Well, naively, I thought it was citizen friendly. I was naive, but compared to the charter, I guess it is. Second of all, though, and most importantly, it can order specific remedies. And I think that we had, remember, all those reports with specific remedies. So we were going to the table advocating for these remedies. And the best forum to be able to achieve that was the Canadian Human Rights Act. The third thing that I think it had playing for it is that we could actually surface this evidence in the public. And that's where we needed that mechanism through the I Am a Witness campaign and the broadcasting of these hearings to make sure that it was amplified and Canadians were confronted with it and had to wrestle with it.
Mm-hmm. And you talked about becoming aware of the history of government inaction. And you talked about kind of initially writing reports and seeing no response. Is there anything that you would have done differently leading up to?
I would have done that historical research. I think so often a lot of us assume that these human rights abuses are happening because people don't know any better or don't have the resources to deal with it or don't have the answers to deal with it. In this case, that was completely false. Had I gone back as early as Dr. Bryce's report, I would have seen that they were choosing not to do it. And when you're dealing with a litigant who knows that they're breaching human rights and that's having devastating harms to people, but are still choosing to perpetuate that breach, that's a different type of response. And that also makes you more alive to the dangers of using official procedure and the price that will be paid if you get too wrapped up in that.
We're at 10:30. We can go for another 5 minutes if you can indulge us, Dr. Blackstock. Is that okay?
No, that's fine.
Yeah. All right. Well,
these translators, by the way, I just want to say thank you to the ASL translators. I really appreciate them bringing it to everyone's audience.
Yeah. Thank you. Thank you. So this has been a 15-year odyssey, which clearly would not have been possible without strength, perseverance, resilience. What advice would you give to other claimants that are taking on similar systemic issues?
I think you have to make sure you're doing right versus being right. And doing right means that you're accountable to the evidence, and you're accountable and work only on the authority of those who are really experiencing firsthand the discrimination. Don't get in there on ideology. That was the strength of our case, is that we could stand on a platform of truth. Canada couldn't do that. So it was procedural arguments and rhetoric, and all of that came crumbling down at certain points. So make sure that you're standing on a platform of truth. Make sure that you understand this is an endurance race, that it's likely not going to be resolved in a year or two, but be prepared to stick it out and not take an off ramp. Number 3, be aware of some of the tactics that are going to come at you and get support so that you can make your way through them. Know that when you experience retaliation, that's part of what's likely to happen, but you don't have to go through it alone. There's the frontline defenders, and frankly, I'm hoping that human rights commissions would internalize and actually have specialized mechanisms to support people experiencing retaliation as part of their work.
Well, I'm getting some notifications that we should start to wrap up, so I'm going to do that. Dr. Blackstock, I wish we had more time with you. This was incredible. It's been such an honor to have you here with us today, and I want to thank you for your insights and your incredibly valuable and inspiring work. You're a hero for me personally. I've told you that before, and I'm sure to everyone watching today. So I just want to thank you and Miigwech for the time that you've spent with us today.
Thanks, everyone. Have a great conference.
Thank you so much, Dr. Blackstock and Raj, for that wonderful moderation. As I reflect on Dr. Blackstock's words, I think several things come up for us. The first is that we can't say we didn't know. She opens by telling us this was publicly known and there was inaction and silence. And I think more and more today's day, we're thinking as human rights folks that silence and inaction is actually complicity at times. And you become a part of the harm doing when we say nothing or when we don't act. I think Dr. Blackstock also talked about what it looks like when the systems that are there to protect us not only don't protect us, but are blocking or harming us. And that you have to continue to fight against the systems to get justice, which they are purported to be there to represent for us. So what it looks like for an individual and a community to have to fight the very systems that are there to defend us, and your story of courage and your continued challenges. It was both painful and inspiring to hear. I think it was so important to understand how important it is that we embed our work not only in institutions and in legal mechanisms, but in social movements. The power of the social movement in pushing things forward, and we've seen this over and over again, of grassroots movements to get us to where we need to be, to know that the public has power, that all of us that are on this call, that it isn't just to ingest and learn, but what do we do with what we're hearing, right? And for me, one of the big takeaways was the cost of all of this, the cost to Dr. Blackstock, funding for organizations being withheld, what it means to have somebody being surveilled, and your privacy being breached, what it is to be attacked and ripped apart, the harm that is done to all the members of the community that's fighting, especially the children. And so we thank you for your work, not just your advocacy, but the sacrifices that you've made in doing this work and the courage you have to come forward and share your learnings with us. Thank you so much. We're going to take a bit of a break. We have 10 minutes instead of 15. And we're going to come back here at 10:45, and we will open up before lunch with a panel on addressing systemic discrimination in Ontario. Some incredible speakers on a panel. Enjoy a 10-minute break, and we'll see you back at 10:45. Thanks. Welcome back, everyone. Very short break, so I hope you got a bit of a stretch in. We're now back for our first panel discussion, which I can promise you will be very, very thought-provoking. And this panel is on addressing systemic discrimination in Ontario. Before we go into the panel, I just want to let you folks know that during the panel, you're welcome to use the Zoom Q&A feature. So just at the bottom of your screen where it says features, pick Zoom Q&A, and you can ask a question at any time. And the panelist, our facilitator, will get to it at the end when we're kind of going through all of the questions. If you're watching the YouTube live stream, please submit your questions via email to ontariohumanrights60@gmail.com, and that's the number 60. Okay, so please submit your questions anytime you'd like, and feel free to join our conversation on Twitter using the hashtag #humanrights60, and that's the number. So for this important conversation, our moderator is Sharmaine Hall. Sharmaine Hall is the Executive Director of Human Rights Legal Support Center. Sharmaine Hall has over 25 years experience in the legal field, including over a decade of combined experience in executive and managerial roles. Before joining the Human Rights Legal Support Center in 2016, she served in a similar role at what is now known as the Hamilton Community Legal Clinic, where she appeared before several administrative tribunals on behalf of low-income clients to protect their rights to income and housing. I can't think of something we need more right now. And now Sharmaine will introduce the panelists and begin our discussion. Thank you, Sharmaine.
Thanks so much, Tanya. Good morning, everyone, and welcome to the first panel of the day. This morning, we're discussing the topic that I think will be of interest to many who work and are keenly interested in human rights issues in our province. Let's set it up. Different marginalized and intersectional communities face barriers when trying to deal with human rights and discrimination. This panel will discuss the strengths and weaknesses of Ontario's Human Rights Code in addressing systemic discrimination. And we have a fabulous lineup of panelists to take us through our discussion. Let's briefly meet our panelists. But in the interest of time, I won't read their full bios, but please know that their bios are included in the conference materials. We'll start off with Brian Eyolfson. Brian is a lawyer who practices alternative dispute resolution, providing independent investigation and mediation and adjudication services, primarily in the area of human rights law. Brian has served as a commissioner with the National Inquiry into Missing and Murdered Indigenous Women and Girls, as acting deputy director in the Legal Services Branch of Ontario Ministry of Indigenous Relations and Reconciliation, and as a full-time vice chair with the Human Rights Tribunal of Ontario. Welcome, Brian. I'll move now to Dr. Laverne Jacobs. Laverne is a full professor at the University of Windsor's Faculty of Law. Her research interests lie in the intersection of critical disability studies, human rights law, equality law, and administrative law. Laverne is lead author of Canada's first textbook on law and disability. Law and Disability in Canada is the name of it. She is the founding director of the Law, Disability, and Social Change Project, a research and public advocacy center at Windsor Law, and co-director of the Disability Rights Working Group of the Berkeley Center on Comparative Equality and Anti-Discrimination Law. Last year, Laverne was named Canada's first ever candidate for election to the UN Committee on the Rights of Persons with Disabilities. Welcome, Laverne. Moya Teklu is Executive Director and General Counsel of Black Legal Action Center, a legal clinic aimed at combating anti-Black racism in Ontario through litigation, advocacy, and education. Moya has delivered anti-racism training to hundreds of judges, justices of the peace, lawyers, regulators, adjudicators, and educators across the country, including through the National Judicial Institute and the Society of Ontario Adjudicators and Regulators. While at Legal Aid Ontario, Moya authored LAO's Racialized Communities Strategy. Moya has participated in proceedings before the Supreme Court of Canada, the Federal Court, and the United Nations. Welcome, Moya. And Gary Yee is a lawyer with an unparalleled career in adjudicative tribunals in the adjudicative tribunal sector. He has been appointed as chair of 4 tribunals, including full-time chair at the License Appeal Tribunal and the Social Benefits Tribunal. Gary is vice president on the board of Chinese Canadian National Council for Social Justice and a member of the steering committee of Tribunal Watch Ontario. Gary has served as founding executive director of Chinese and Southeast Asian Legal Clinic, and in the late 1980s as national president of the original Chinese Canadian National Council. He spearheaded the redress campaign for elderly Chinese head taxpayers and widows. Gary is the recipient of several awards, including the SOAR Medal, the Federation of Asian Canadian Lawyers Lifetime Achievement Award, and the Law Society Medal. Welcome, Gary. And as I mentioned before, our esteemed panel's full bios are on the materials that you have received. So let's begin. And let's think for a second and have our panelists establish for us how each describes systemic discrimination. And in your response, panelists, please identify what barriers each of the communities you serve or identify with faces. Laverne, can we start with you?
Absolutely. Thank you, Sharmaine. I think that one of the best definitions of systemic discrimination was provided by former Justice Rosalie Abella in her 1984 report on employment and equality. She wrote, and I quote, that systemic discrimination results from the simple operation of established procedures, none of which is necessarily designed to promote discrimination. The discrimination is then reinforced by the very exclusion of the disadvantaged group because the exclusion fosters the belief, both within and outside of the group, that the exclusion is the result of natural forces. For example, that women just can't do the job. Excuse me. She added that to combat systemic discrimination, it's essential to create a climate in which both negative practices and negative attitudes can be challenged and discouraged. While Justice Abella was speaking about the employment context in her report, and primarily gender, her ideas are very fitting for many other marginalized groups as well, for which exclusion is an everyday reality. It's not surprising then that her ideas have been adopted by the Supreme Court of Canada and that they have used her ideas where equality and systemic discrimination are at issue. So as the Supreme Court of Canada has developed its definition over the years, the jurisprudence is usually quite clear that systemic discrimination or adverse effects discrimination arises when a law, policy, or practice appears neutral on its face, but has an adverse impact on certain individuals or groups depending on their characteristics or life circumstances. The issue of adverse effects discrimination or systemic discrimination was first addressed in 1985 by the Supreme Court in Simpson-Sears, but to this day, the court continues to use the same definition, although adding additional pieces. For example, that systemic discrimination may emerge from a complex web of seemingly neutral systemic barriers, and highlighting that there doesn't need to be just one policy that causes the systemic discrimination. I'd be remiss not to mention the most recent case in Ontario discussing systemic discrimination, the Midwives case, which was released just 10 days ago, actually, from the Ontario Court of Appeal. It examines systemic discrimination under the code and reinforces and maintains in Ontario this definition from the Supreme Court line of jurisprudence. The test for proving a prima facie case of systemic discrimination consists of 3 elements, And the court has been clear that the applicant must show that they have a characteristic protected from discrimination under the code, that they have experienced an adverse impact with respect to the social area, such as a service, accommodation, or employment, and that the protected characteristic was a factor in the adverse impact. The onus then moves to the defendant to refute this using acceptable defenses. So I just want to say one last thing before I move to a quick overview of a few of the barriers faced by persons with disabilities. And I want to say that some scholars, most notably Colleen Shepherd, have astutely noted that those who have been overrepresented in advantaged positions in various social institutions have shaped our understandings of what is normal and what is desirable. And what I'll add to that is that those who are overrepresented in advantaged positions have not only determined what is considered the norm, they have implicitly determined as well what should be considered such a rare minority that it's unnecessary to be concerned on an everyday basis about what will happen if this minority doesn't fit within the norms, policies, or environments that we shape. When it comes to persons with disabilities, there are a myriad of laws, policies, and practices that are designed to be neutral in their application to persons with and without disabilities, but that don't take into consideration the realities of life in a variety for a variety of disabled individuals. People with disabilities therefore face a multitude of barriers in everyday life and through all activities of life, and these barriers exist across all 5 social areas of the code. In terms of barriers that persons with disabilities experience using the Human Rights Code, I'll just mention 3. There are several others, but the first is access to the human rights system. Many people with disabilities live below the poverty line, which can affect their ability to higher representation due to systemic issues relating to access to education. They may also not be in a position to represent themselves. And although the administrative justice system is designed to be easily accessible, they may be up against parties that are well-resourced and come with lawyers, etc. So it's wonderful that we have the Human Rights Legal Support Center, but budgets change, and generally speaking, they're never enough to support everyone who needs it. The second barrier that I'll just mention is the disconnect between what people with disabilities are looking for in terms of equality and what they can receive under the code. So I'm speaking about remedial outcomes here. From a study I did looking at human rights claims by persons with disabilities over local transportation, one finding was that a significant number of applicants were seeking the restructuring of transportation systems so that they could efficiently do things that they needed to do. But structuring and restructuring of transportation systems and processes is not really the type of remedy that's possible under the code. The third barrier that I'll mention relates to settlements and the fact that many cases under the Human Rights Code are settled and that the settlements are sealed. So as a result, there are ideas about how to improve for persons with disabilities that are not widely shared. So thank you very much.
Thanks, Laverne. So Gary, Laverne mentioned the test. She set out the test that we can find in the jurisprudence. I wonder if your definition differs in any way, and what barriers do you see for your community?
Well, I mean, if we look at, I want to focus on systemic racism, really, and the issues do cross a lot of the boundaries, of course, for all sorts of systemic discrimination. We obviously need to focus on both the individuals and the collective system. And, you know, it's usually the individual incidents of hate, right, that catch a lot of media and public attention, especially when it's, you know, something violent. And we also have to remember, you know, the really deep psychological impact on people who experience racism. But in the end, each situation, each person, you know, is different, both in their personal experiences and the impacts, and also, you know, it's different what may be needed for either the victim or the perpetrator. So while we're talking about all these, you know, individual from the individual perspective, of course, that deserves attention. But we know we cannot solve racism by just taking action against individual racist acts. Systemic racism needs systemic responses, and that has to be at the institutional and leadership level. And let's not fall into the trap that the Toronto police chief was criticized for last week when he focused, only on systemic racism and tried to suggest that individual police officers had no responsibility for racist acts. I'm going to talk, we'll talk more about systemic racism later. And I'm going to suggest that a lot of systemic racism is actually intentional. It's a choice. It's about keeping power. The second point I want to cover is about anti-Asian racism, not so much the barriers, I'll touch on that later in terms of accessing the human rights system, but perhaps more just to focus on some specific stereotypes that are really important to recognize when we're dealing with East and South Asian, Southeast Asian communities. I'll just point out two. One is the perpetual foreigner stereotype, and the other one is the model minority myth. So a lot of you may have heard about this already. The perpetual foreigner stereotype is about that powerful first impression when you see an Asian here, that you identify them as not as Asian. You're not thinking they're real Canadians, regardless of how long our histories have been here in Canada. We're always seen as a foreigner or an immigrant, and then our loyalty to Canada can be questioned, right? Remember former MP Derek Sloan asking if Dr. Theresa Tam, are you working for Canada or for China? That's the kind of first impression, the kind of thinking that we face, and it affects the kind of racism that the kind of discrimination that we face. The second common stereotype is the model minority myth. And this myth actually came from US when it was used in the 1960s to oppress the Black community by pointing to Japanese Americans as that model minority that was successful and did not demand anything from the government. I learned about these things myself in the last 2 years of tons of Zoom meetings and panels and all the connections between the different forms of discrimination. And as we know, even positive stereotypes could have negative impact. So Asians may be seen as obedient or good in certain technical skills, but you know what? Maybe that's also comes with not being seen as good in anything else, like people skills or communications or creativity or being tough, right? So we also end up being more vulnerable to racism or attacks if perpetrators think Asians won't fight back. And also the model minority myth means that anti-Asian racism is often not seen as a big problem. And even a pandemic where a few horrific incidents may not have enough impact to convince everyone about how many of us are affected by anti-Asian racism.
Thanks, Gary. Moya, a lot of interesting things coming out of what Laverne and Gary have both said. The idea of racism as a choice, and Gary mentioned also about the notion of the majority sort of holding on to power through that through systemic discrimination, and so I wonder how you would respond to the question from your perspective.
Yeah, thank you. A lot of interesting comments, and I agree with everything that's been said so far. When we're trying to understand the current realities of Black people in this country, we have to understand that they are rooted in a history of colonialism and slavery. And so to understand systemic anti-Black racism, we have to start there. Slavery was legal in Canada from the early 17th century until abolition in 1834. And following abolition, anti-Black racism continued to be institutionalized through de jure and de facto segregation in education, employment, and housing. And this is the history that sets the framework for modern racism in Canadian society, modern anti-Black racism in Canadian society. It's part of the foundation upon which this country has been built. And it's almost a straight line between, the 1700s till now. In the 1995 report on systemic racism in the Ontario criminal justice system, they noted that racism has shaped immigration to this country and settlement within it. It's led to denials of basic civil and political rights to Canadian citizens. It's excluded adults from jobs and children from schools. It's limited opportunities to acquire property, and it's barred people from hotels, bars, and theaters. And almost 30 years later, all of those things remain true for Black people. We continue to see the impacts and manifestations of systemic anti-Black racism everywhere. And so I'm also going to respond to the question of the barriers faced by Black people in Ontario and Canada by talking about manifestations of systemic racism. And then later on, I'll talk about barriers to addressing systemic racism. I feel like a lot of these issues or these stats or these facts have become more well known in the last few years, but Black people are more likely to live below the poverty line. Black children continue to be overrepresented in the child welfare system. Once they are there, they experience more negative outcomes and less access to service than their white counterparts. Black students are more likely to be streamed, more likely to be suspended, more likely to be expelled. Black women earn less than white women, and Black men earn less than white men. Even when you control for other factors, Black people are more likely to be stopped, questioned, searched, arrested, charged, assaulted, and killed by police. Black people are overrepresented in provincial and federal prisons. And while there, they also experience anti-Black racism in terms of access to programming, in terms of classifications, in terms of access to parole. And I could go on. There are manifestations of anti-Black racism in every aspect of our lives, which only makes sense given the foundation upon which this country was built. As Laverne mentioned, systemic racism is often caused by policies, practices, and procedures that appear neutral, but have the effect of disadvantaging racialized groups. And as Gary has noted, it is important to note, however, that people and system actors are responsible for the introduction and perpetuation of these systems. I say this because, as Gary mentioned, we're beginning to see a framing of systemic racism as some sort of phantom thing that exists out of the people that make these systems work. And it feels to me like it is an attempt to absolve people who are making decisions and positions of power from changing the structures and the systems that maintain the subjugation of Black people. And we have to be aware of that and be vigilant against it.
Thanks, Moya. Brian, lots there. I'm wondering if you could please just talk about the perspective from the community that you serve. And I'll say that, some of the themes that I hear coming out already are very much in line with what we heard Dr. Blackstock talk about earlier this morning.
Thank you, Sharmaine. I think that from an Indigenous perspective, systemic discrimination is also bound up with historical and ongoing impacts of colonialism, as well as racism and other intersectional discrimination in our society. It also includes historical and ongoing violations and abuses of Indigenous rights, inherent rights, and in many cases in Canada, treaty rights as well. And the impacts of the systemic discrimination have included the displacement of Indigenous peoples from their lands, social structures, and governance. With respect to colonialism, the ongoing violations of Indigenous peoples' human rights and Indigenous rights have a long history. much of this rooted in offensive concepts such as the doctrine of discovery and terra nullius. There was a 2018 report from the Assembly of First Nations that stated that it remained deeply concerned about the contemporary ramifications of these doctrines and called on Canada to reject and repudiate all such doctrines of superiority and reinterpret Canadian law in a manner consistent with the United Nations Declaration on the Rights of Indigenous Peoples and ensure and redress violations to Indigenous rights to lands, territories, and resources. And in terms of how this discrimination has manifested and continues to do so, the National Inquiry into Missing and Murdered Indigenous Women and Girls heard about significant historical and ongoing Indigenous and human rights violations in 4 key rights areas, that being culture, health, justice, and security. And in the area of culture, the National Inquiry heard about assimilationist policies, including the loss of land, forced relocations, the whole residential school system, followed by the 60s scoop, and significantly the ongoing child welfare systems. These things have altered the relationships of Indigenous peoples to their culture and identity. And in the area of health and wellness, the inquiry heard about inadequate health supports and lack of culturally appropriate health services. And in particular, systemic discrimination in the healthcare system is something that we all continue to hear about in the media with respect to Indigenous peoples. In the area of justice, we all continue to hear about the overrepresentation or over-policing of Indigenous people in the justice system, including the appalling overrepresentation in correctional facilities, and also the frustrations that Indigenous victims of violence and their families experience in dealing with the justice system, such as inadequate responses to their concerns and a lack of support. And some of the ways that the systemic discrimination is enabled to persist is through a lack of addressing the lived realities of Indigenous peoples. For example, the intergenerational trauma caused by colonialism, and in particular the impacts of residential schools, just not only on survivors themselves, but on the children and grandchildren and families and communities, which continues. And this intergenerational trauma is often not accounted for in the provision of government and other services, such as in the provision of health and justice services, and that needs to be addressed. In addition, healing for individuals, families, and communities needs to be supported. Another area is social and economic marginalization, and Indigenous peoples experience poverty, homelessness, food insecurity, unemployment, and barriers to education at much higher rates than non-Indigenous people. Access to clean drinking water continues to be an issue for many communities. So the basic needs of Indigenous peoples are often not being met. And arguably, these basic security needs need to be met not only on an equal basis, but on a substantive and equitable basis in light of the historical and ongoing deficits that exist. Thanks.
Sorry about that. I think everyone will be caught by the mute button some point today. So that was mine. I promise it'll be the last time. I think the themes that really stand out for me today are the historical, underpinnings of systemic discrimination that's come through in the comments that have been made by all of our speakers at this point. And I think we'll continue to hear that as we weave our way through this discussion. I am going to turn to the question of whether or not our system or whether or not the code successfully addresses systemic discrimination. But before doing so, the other thing that's happened to me today is too much of a reliance on my prepared notes. So I want to correct one little thing or update one little thing and congratulate Laverne, who is the first Canadian to be elected to the UN Committee on the Rights of Persons with Disabilities. I apologize for that, Laverne. So as Laverne mentioned, recently we had 10 days ago the decision in the Ministry of Health versus the Association of Ontario Midwives. And some might say that that decision is evidence that the code can be successful in addressing systemic discrimination. Brian, turning to you, has the code been successful in addressing discrimination? And what are the limitations of the current system as you see it, particularly for the community, the Indigenous community?
Right, thanks, Sharmaine. I'll start with some limitations. The complaint system set up under the code has been and continues to be largely an individually driven application process. That's not to say that individuals can't raise systemic issues in their applications, as many applications challenge laws and policies that impact many people. In addition, remedies that are systemic in nature can be pursued in individual applications and agreed to by the parties in settlement or ordered by the tribunal at the end of a hearing where appropriate. However, there are a few examples of what I would consider broader systemic human rights applications, such as the First Nations Child and Family Caring Society cases that Cindy Blackstock addressed this morning under the federal human rights system, and the midwives case under the Ontario Code. In terms of limitation, there are also access to justice issues. From an Indigenous perspective, and I don't want to overly generalize, but there can often be mistrust in government institutions, particularly in light of past negative experiences with government, which the agencies under the code, such as the Human Rights Tribunal of Ontario, can be seen to be as. This can be compounded by practical considerations such as geography and technology. Indigenous peoples in more remote and northern communities may not have the ability or means to access support in pursuing human rights applications because of distance, the lack of resources, and or the lack of technology. In addition, if you're struggling to have basic needs met, or if discrimination is so prevalent it seems normalized, pursuing a human rights application may not be seen as a practical priority. Also, the dispute resolution systems under the code may not align with Indigenous people's understandings or worldviews of justice, both procedurally and substantively. For example, an individual-based complaint process that does not involve community, where human rights violations are seen to affect not only the individual, but their communities, and that intertwine with Western approaches to human rights, as opposed to Indigenous worldviews on rights, may not be perceived as adequate, meaningful, or appropriate, where rights may be seen as community-based and not just individual. In addition, for many Indigenous peoples, there can be complicated federal, provincial, jurisdictional issues in determining where to pursue a human rights matter. And the Canadian Human Rights Act, instead of the Ontario Code, could be the applicable legislation to pursue a complaint, depending on the circumstances. With respect to successes or strengths of the code in the current system, I think that the code establishing 3 pillars or agencies, the Commission, the Tribunal, and the Human Rights Legal Support Center, is a strength of the system that creates various opportunities. For example, the Commission can do a lot of meaningful work to address systemic discrimination through its policy development and education mandate. The policy work addressing Indigenous spiritual practices is just one example of that. Also, the Commission has engaged in relationship building. Its agreement with the Ontario Federation of Indigenous Friendship Centres to work together to end discrimination against Indigenous peoples in Ontario is one example of that, as are the Commission's advisory groups, from which guidance can be obtained, including the Indigenous Reconciliation Advisory Group. The Commission's power to conduct inquiries is another effective means to address systemic discrimination, and the recently released Right to Read Inquiry report, which contained a section specific to Indigenous peoples, is a great example of that. The Human Rights Legal Support Center has an Indigenous Services and Outreach Committee that is focused on supporting Indigenous applicants. And as I mentioned earlier, the tribunal does have the power to issue broad systemic remedies where appropriate, and systemic cases such as midwives can be brought before the tribunal. The Commission can also intervene in cases before the tribunal and assist in achieving systemic remedies through an order of the tribunal, including by way of a negotiated consent order, such as in the John case, in which the Commission intervened and where the Commission is seeking to hold Ontario accountable for failing to meet its obligations under both a settlement and a consent order to keep prisoners with mental health disabilities out of segregation. But all these strengths depend on the three pillars being properly resourced to carry out this important work. Thanks.
Thanks, Brian. Thanks very much. Moya, what's your thinking on this question of whether the code has been successful in addressing systemic discrimination?
Well, I think my response to the first question addresses the second, which is that given how rampant systemic racism and anti-Black racism continues to be, the short answer is no, the code has not been successful in addressing systemic anti-Black racism. But I have more to say. So, first, I think it is important to acknowledge that we have one of the most robust human rights systems in the world. Brian spoke about the three pillars. In addition, we have jurisdiction over, both the public and the private sector, a tribunal that offers adjudicative processes and an alternative to courts, a center, the Human Rights Legal Support Center that can help with representation, a commission that can focus on research and public education, that can launch public inquiries, that can intervene in the public interest. None of these things are a given in human rights systems around the world or even across Canada. And we need to pay attention to attacks on this system. And vigilance seems to be my word of the day, but to remain vigilant in protecting it, because even though it hasn't, addressed systemic anti-Black racism, there are the tools are there, I think. The limitations of the current system, as Brian noted, stem largely from underfunding and I think also from political interference. Population has gotten bigger. There's been a general increase in awareness of human rights. The number of applications has increased. And I believe, though I'm not sure that the funding for the human rights system has remained essentially the same since the 1990s, when you look at all of the three pillars collectively. It was hard to do a sort of comparative analysis because of the change in 2008. But with inflation, what this means is that in real terms, the budgets of the human rights system have decreased in the last 30 years. And the system is not without its faults. The process takes a very long time. We've talked already about the Family Caring Society and the Ontario Midwives case. The Family Caring Society was filed in 2007, and it wasn't resolved until almost 15 years later. In Ontario, the midwives filed their application almost 10 years ago, and we just received the decision of the Ontario Court of Appeal 10 days ago. The tribunal, the Human Rights Tribunal, is accessible in theory. However, as has been recently noted, the tribunal is using rules of procedure to issue what are referred to as notices of intent to dismiss, or NOIDs, more and more frequently. A report in the Law Times just earlier this month by a study done, reported on a study done by law student Frances Nasca, and it suggests that the use of NOIDs has increased threefold since 2017. And also that people filing applications on the basis of race, color, and citizenship are more likely to receive NOIDs. This begs the question, if there is an increased understanding of human rights and the human rights system, why are we seeing an increase in dismissals on the basis that an application falls outside of the jurisdiction of the tribunal or is pleading just general unfairness? Because of the direct access model and limited funding to organizations like the Human Rights Legal Support Center and Black, the majority of applicants are, Black is short for Black Legal Action Center, I should say. The majority of applicants are self-represented. We can't help everyone, not even close. Tribunal Watch Ontario has noted that 80% of people who file claims with the tribunal are self-represented, but they are almost always up against represented and well-resourced respondents. For example, a study done by future law student Jonathan Carlson and published by Black just this week showed that people who file human rights applications against police services rarely had a lawyer or paralegal, while the police services almost always did. It's worth noting that very few applications actually result in a finding that the code has been breached or a reward of remedies for the applicant. In the study that I referred to earlier, from 2017 to 2020, 269 human rights applications were filed against police services, and only one resulted in a finding of a breach. That case was JKB, the case of a 6-year-old Black girl who was handcuffed by Peel police by her hands and ankles. That case took 7 days of hearings and 2 expert reports, and resulted in $30,000 in general damages, which brings me to my next point, and I'm going to try to go over this last point quickly, which is the quantum of remedies. The folks at Parkdale Community Legal Services recently launched a challenge to the provision in the Federal Human Rights Act that caps damages for pain and suffering at $20,000. But if you look at the Human Rights Tribunal and the awards issued by the tribunal, the awards rarely go over this amount. So I looked at 61 general damages awards issued since 2019, and 80% were $20,000 or less. A study that was done by Audra Rinaldi and Bruce Ryder back in 2017 looked at cases from 2000 to 2015 and found that general damages awards continue to be too low to reflect the importance of the quasi-constitutional rights protected by the code. It's interesting because the authors also compare the range of damages for breaches of the Human Rights Code to awards for general damages for injuries to reputation and defamation. These range from $25,000 to $500,000. And just last year, in the case of Laverne and Isaac, a judge ordered an Ontario woman to pay $100,000 in damages for accusing 2 women of being racist and mocking the murder of George Floyd. What this tells me is that there is a message being sent that being accused of being racist is considered worse than being a victim of racism. There are other limitations as well, but I will stop there just to say briefly that we are finding that the 1-year limitation period is causing a barrier to access because racism is a trauma. There's an understanding that it takes time to people who are victims of sexual assault to process the trauma and then to take action to address it. And the same is true for victims of racism. Settlements are confidential. The appointment process is politicized. I'll stop there because I know that other people will talk about it as well. Okay.
Thanks, Moya. Gary, I wonder if you could share with us what you see as the challenges to addressing systemic discrimination.
Yeah, I mean, certainly there are some very specific challenges which the other speakers are going through. I want to actually start out with a more general point about systemic discrimination and how challenging it is to fight it. And I'm going to focus again more on systemic racism. And as we know, racism does not require intent or motivation. But I think it certainly helps to look at systemic racism as something that actually involves a kind of collective intent to resist change. In the end, systemic racism is very much about keeping the power or benefits of the historical or existing systems. And we know that effective action against systemic racism means big changes, right? It means it affects those with power and influence more than focusing on individual incidents of hate and complaints about discrimination, right? Systemic racism, to act against that means big changes in policies, practices, priorities, laws, attitudes, and so on. For example, what happens if hiring and promotion processes are actually changed to recognize a wider view of merit? So not about representation and numbers, but a wider view of merit, include the value of diverse lived experiences and how that can enhance empathy, client service, teamwork, decision-making. What happens when someone can no longer get the same advantages they previously enjoyed because of that wider view of merit, or because they can no longer rely mainly on who they knew or their insider connections? Who benefits? Who may feel threatened by the changes? So that's what we're up against. It's nothing less than changing who has power and benefits. So no wonder it's hard, right? No wonder we often fail. And as I said in another panel last month, the reality is that so much of our social justice struggles depends on political decisions. So hard work, strong moral grounds, that will not guarantee us political success. And even with progress or success, history too often shows how easily that can be reversed. So, you know, I know I'm not really answering this question with anything that's specific, but I'll end by just adding to the practical suggestions of the others, and very briefly reinforcing a few points. Yes, we need to be more proactive, right? We can do more to prevent discrimination instead of just reacting to individual cases after they have happened. And for the barriers, they're the same as all the access to justice barriers we know that face many marginalized communities. So for a lot of East Asian and Southeast Asian communities, big parts of these communities have language barriers. And we know that a big part of access to justice is access to information. And when we look at the many tribunal or government processes, huge barriers, right? From not having enough help or representation. And then just generally, we know there are limits to what a traditional adversarial or adjudicative process can do to respond to racism or discrimination. Moya has talked about what can happen to an expert, well-respected tribunal like the Human Rights Tribunal when there's a complete changeover in members within a couple of years. Tribunals need to be treated with respect. Adjudicative tribunals need to be treated like courts. It should not depend on the election cycle, what happens to tribunals. And for the Human Rights Commission, it's clear it needs to do more with its power to initiate its own cases for systemic discrimination. We know this requires more resources, and we know we need to push for that as well. Thank you.
Thanks, Gary. Laverne, time's of the essence, so if you can be brief, that would be great. But do you see any positive steps forward in addressing discrimination under the code?
Yeah, no, thank you so much for that question. And I just want to do two quick things, hopefully. One is to say that I very much agree with what's been said so far, but I wanted to add just a bit of precision for people with disabilities. So there are many similar situations in terms of systemic discrimination, but I want to mention three areas. One is housing and a history of, institutionalization that people with disabilities are often working against, especially individuals with intellectual disabilities. Employment is another area that's quite significant for people with disabilities, looking at reasonable accommodation or even just the ability to have education, access to education, to have jobs, and services. So here, education I'll mention again, but, how to ensure that there's inclusive education, to ensure that people with disabilities are included within various spaces on campuses, et cetera, as well as transportation and public services. So those are some of the areas that people with disabilities are, where they're facing great challenges in lived experience. So I'll just say that I think that one of the greatest limitations of the human rights system is that the legislation is designed to be reactive, and it addresses particular claims, right? So there may be some room sometimes for monitoring the implementation of remedies and sharing lessons from a particular tribunal decision, but for the most part, we're looking at individual decisions. And what I've also seen through research is that there aren't many systemic discrimination cases being brought forward, and this could be for a variety of reasons, but I think it's primarily resources and knowledge. So one thing that I would suggest is that we have, greater information, greater opportunities shared with the disability community, in order to bring forward systemic discrimination cases more easily. And the final thing I'll just say, and this is picking up on something that Moya had said earlier, is that when you look through cases dealing with persons with disabilities and human rights, many of those cases are dismissed early. Many of them have self-represented litigants, and many of those cases show a challenge connecting disability with the actual grounds under the code. So that's another area where we need to place some emphasis. Thank you.
Thank you. Again, themes coming through, the issue of resources in really taking these cases forward. So at this stage, what we've done is we've looked at the definition of systemic discrimination. We've considered, whether it's been successful, dealt with successfully under the code. I want us to turn our attention now to what a system would look like, what a successful system would look like. Perhaps, Gary, you can lead us off. What does a successful system that manages and deals with systemic discrimination, particularly for the community you serve, look like?
Thanks, Sharmaine. I'm going to focus on two things here. The first is the need to be connected with the affected communities. And second is the need to establish the foundation for more permanent changes. So the system I'm imagining is one that is proactive and preventative, right? Instead of being reactive and focused too much on enforcement. It addresses discrimination from both the individual and systemic perspectives. It gives access to the system for everyone by supporting those who are marginalized. It's not one size fits all. It's flexible and diverse enough to work for different communities and situations. And it's a system that involves the communities in developing and designing the system, implementing it, assessing it, improving it. So yes, the Human Rights Commission with more resources and powers will help, but only up to a point. A human rights tribunal that is depoliticized, independent, effective, and expert will help, but again, only up to a point. For true access and true justice, we need much more support for the users of the system who have less power. So this means more support for community groups and legal clinics. We need to link the marginalized communities with the institutions that have the power to affect those communities. Too often we're just missing that bridge, that connection. And yes, I may be biased, but I really think that community legal clinics and the Human Rights Legal Support Center is an example of that. I think that community legal clinics are the best example of the kind of groups that we need. And our frontline contact with clients and communities gives us the information and the credibility to identify concerns and advocate for systemic changes. So the second point, any change system won't be worth much if it cannot last beyond an election cycle or beyond any regressive trends in society. And in the past 2 years, we've seen a whirl of possibilities open up by the upheaval from the pandemic and the big social justice movements. But how much of this will last after the horrible headlines fade away? How much of this will lead to foundational change? And when will those with power choose to stop this systemic discrimination? Those are negative questions, but I actually see some hope because I can compare it to our struggles from literally 30, 40 years ago. Yes, I'm getting old, right? I can see progress even if it's not linear. I can see the power of the internet and the power of our growing networks and allies. We need legal and other systematic ways to require accountability from our leaders. So this could include things like required data collection, reporting requirements, communication standards, tools that bring a human rights and equity lens to the policy development and the analysis. And those are the kind of things that we need to set up. And for permanent change, if we can somehow continue to link human rights and anti-racism more strongly to public trust and democracy, then I think we can set up a foundation for a human rights system that will last because it'll be integrated into our legal traditions, our democratic institutions, and our collective culture.
Thank you, Gary. Wow, I see lots of hope there. Laverne, what would you add, if you were to sort of add to your visioning exercise?
Yeah, absolutely. Thank you. And yeah, I really liked Gary's comments. I would add three things maybe. The first is something I call the universality of the human condition, which I think should be quite central to human rights and equality law enforcement. I'll just use that as a general expression. But the idea is that the law, the Human Rights Code and its processes should be designed and used in a way that supports everyone, including persons with disabilities, so that they're on an equal basis with others. So I see a human rights tribunal system where everyone is supported, and that where persons with disabilities are not struggling to do the everyday things of life's experience, such as raising children, getting to appointments, using transportation, things like that, having employment. So that's one thing. And I think that it can be done through the way that the code is interpreted. So I think that it's possible, for example, to have a rebuttable presumption, so that when we think about the connection between adverse impact and the experience that someone has had and the ground of discrimination, disability, I think that there might be the possibility of having a rebuttable presumption, so that it makes it a bit easier for those who are bringing matters before the tribunal. I also think, secondly, that it's really important to not just focus on compliance and enforcement, and this picks up a bit on what's already been said, so I'll just quickly say that we need a whole of code approach. I mean, in the code, there is, for example, a provision dealing with the Disability Rights Secretariat, so that's on the books. We know that there are opportunities to develop policies, and several have been made. Taking this whole of code approach is very important. The third thing that I'll just say is that we need to think about connections, as Gary said, but we also need to think about additional administrative actors. So there are administrative actors elsewhere who are to interpret the code. How do we make sure that they are doing so in a way that upholds the rights of the code and also, generally respects all of the various communities that we're talking about today? So that's what I'll say. Thank you very much.
Thanks, Laverne. Thanks so much. Brian, what would you like to see in terms of a system that effectively serves Indigenous communities?
Thanks, Sharmaine. I think some of my comments in this area reflect what others have said. I think that increased access to justice continues to be an important issue. So, for example, to address potential mistrust that Indigenous peoples may have in government institutions, including the human rights mechanisms, who are experiencing discrimination, to have better access to support by and through Indigenous identified organizations and individuals to assist them. For example, having more information and supports for filing human rights applications under the code at various Indigenous agencies across the province, and not just in larger urban areas where Indigenous peoples can more easily and more comfortably interact with people in a culturally appropriate manner in terms of pursuing their human rights and be supported. Also incorporating Indigenous approaches to justice into the code's dispute resolution processes that may better reflect Indigenous people's approaches to resolving conflict, and ensuring that Indigenous protocols and practices, including spiritual practices, are respected wherever dispute resolution processes may take place. I also think increased policy development to better reflect Indigenous worldviews in human rights policy and law would be helpful as well. And similar to what Gary said, I think in achieving these objectives, it's important to have ongoing relationship building with Indigenous peoples and communities, with meaningful input from people with lived experience to better inform these processes. So to ultimately work towards decolonizing the Human Rights Code and the system in Ontario. And I think, of course, education continues to be very important beyond, in addition to litigation. And I think that 3 pillars under the code can all play a role in working together with, in terms of educating the public, but also to strive to find ways to hold governments and service providers accountable, whether that be through legal processes like enforcing consent orders before the tribunal, or finding other means to encourage service providers to be accountable and provide non-discriminatory services to all Ontarians. So those are my few comments on that. Thank you.
Thanks, Gary. And Moya, last word to you on this particular question.
Okay.
What would your visioning experience, or where does your visioning experience take you?
Yeah, so I have a sort of a general comment and then 2 more specific comments. I think generally a lot of the comments the suggestions or recommendations that I would make will echo those of the other panelists. Ensuring that we have a system that meets the Paris principles, one where human rights legislation has primacy over other laws, one where there are adequate resources so that applicants are not self-represented, one where the Commission has resources to publish studies and conduct public inquiries, a broad mandate to both promote and protect human rights, formal and functional independence, including, as Gary mentioned, through security of tenure for adjudicators and other sort of protections to avoid the politicization of the appointment process, and a system that is transparent and timely. So those are the general comments. I think specific to addressing anti-Black racism, I focused the response to my last question a lot on litigation, but litigation, I think, is likely not the most effective tool to address a systemic issue, as a number of the panelists have said, and I agree with that. And that's why I think that when we're talking about systemic discrimination and systemic racism, the Commission has the Ontario Human Rights Commission has a particularly important role to play. As we've seen in the last few years, they have done a really good job of bringing to light what used to just be anecdotal evidence of anti-Black racism in policing, of anti-Black racism in the child welfare system, through public inquiries, through studies, through reports that have been issued by the Commission. There's been the views and experiences of the Black community have in essence been validified or validated by the Commission, and that's important for a number of reasons, both in raising general awareness of and informing people of the existence of anti-Black racism, but also to provide organizations like the Black Legal Action Center with the tools to engage in advocacy and systemic reform, with the tools to go to lawmakers and seek legislative changes, to launch test case litigation, and to provide us with the evidence that we need, the statistical evidence that we need to establish that there are systemic issues. And so, that brings me to sort of the 2 parts, which is one, to create the evidence of anti-Black racism, and then to enable the use of that evidence to provide redress and reparations for the harms that have been done. So, I think that I'm still sort of grappling with what we do with, we have all of this evidence of systemic anti-Black racism, and there's no disputing its existence. But the what next of it, and how do we use that? And I really like the idea of a rebuttable presumption, because the odds are really stacked against applicants and even organizations like us in establishing and making the connection between, what the systems are doing and the harms done to individual people. And so it is possible, but I think that that's what we need to sort of continue to work on in order to enable the real sort of change that Gary and others have talked about.
Thank you. We're coming to the end of our time, and I just want to draw out what I've seen as the themes in the sort of areas that we've talked about. We started by looking at the historical underpinnings of systemic discrimination. And I think that was an incredibly useful exercise to really take us to a full discussion of this issue. And what I'm noticing is that we are now, I don't know that I was expecting this, but what I've heard you all talk about is a more holistic approach. So this idea of litigation may not necessarily be the panacea. And we have to sort of look at a more sort of wraparound way of dealing with these issues, where it's supported by community and supported by litigation. So absolutely a more holistic view of things. And I thank you for that. I think you all did a great job of really teasing out those issues. In the time that we have remaining, and we do have 2 questions, but I think we can do this. We'll save our questions, but I just want to do a quick go around and maybe ask you each one question. You got 30 seconds each to address them about. So we'll start with Moya. Moya, sort of following on the comments that you've made, what is one thing you think would have a significant impact and would move the needle towards effectively addressing systemic discrimination under the code? Just the one thing.
Okay, I know you said one thing, but I have 2 things. Okay, so on a practical level, I think the answer is just resources. We're in a sort of a very David and Goliath situation where we're up against well-resourced and represented respondents, and it's not a fair fight between the applicants and the respondents. There's an understanding that human rights law is meant to protect the most marginalized, but how they're marginalized in a number of ways, including socioeconomic status. So we need resources to level the playing field. And the other is more sort of a broader issue, which is my hope is there's a realization of the commonalities between all of the struggles and the oppressive systems and the way that they manifest for the Asian community, for people with disabilities, for Indigenous people, for Black people. There are more of us than there are of them. So that's sort of my big, broader theoretical hope for how we can address systemic issues.
Oh, that's great. I think Laverne said in her talked about the universality of the human condition. And I think that's, we do need to sort of look at what is common and where we can actually form partnerships to effectively deal with systemic discrimination. Brian, what steps can the system take to ensure that it is accessible to Indigenous peoples? And is there 1 or 2 concrete things that can be done?
Thank you. Yeah, and I may be somewhat repetitive, but I keep coming back to relationship building and outreach. I think it's really important that the pillars under the code engage with Indigenous peoples and communities and appreciate the diversity of Indigenous peoples and communities across Ontario. And work with people with lived experience, because in my view, they are the experts and they have a better idea of what will work going forward. So I think it's very important to build those relationships, to listen, meaningfully learn, and see what can be done.
Thanks, Brian. And Gary, there's a theme that's come through in all 3 areas that we've talked about, and that's resources. And so, given your experience as a member on various tribunals, I wonder if I can ask you about the importance of appropriate resources to ensure different communities can obtain successful hearings and otherwise in terms of systemic discrimination cases.
Yeah, I mean, just very briefly, I mean, resources, if we look at it as, more than just funding, but the human resources, the staffing, the leadership, the policies and legislation and powers that need to be put in place, that's what's needed. And then it's not just a commission or a tribunal. It's an integral part of it, of this larger system we're talking about that links to communities and has these relationships with legal clinics or other stakeholders. There are there are narrow requirements for tribunals because we apply the law, we don't apply policy. So you cannot rely on tribunals for a lot of what needs to be done for systemic racism. But when you have a tribunal, respect the tribunal as an adjudicative body, as basically a judicial body, and don't politicize it. Don't let an election affect the tribunal in the way that it has in all jurisdictions, not just Ontario, but all jurisdictions across the country. That's just not right.
Thanks, Gary. And Laverne, last word to you before we get to questions. What would you say is the key takeaway from our discussions today?
Yeah, thank you so much. I mean, there's so many wonderful takeaways. I think that overall, though, we might say that we are moving towards a more human-centered approach. And I think that, based on a lot of what I've heard, this involves both the policymaking of the tribunal, reaching out to the communities, making sure we understand lived experience, and also within our processes, I think at, the tribunal itself, making sure that we understand and can bring in these lived experiences in a way that's valuable. So I think that human-centered approaches and understanding communities are quite central to what I've been hearing today. You say that that's the takeaway. Thanks.
Thank you. Thank you so much. We have about 4 minutes. And so one question that we received from the audience is, do you see the Canadian system moving to a direct access system similar to Ontario? So as a bit of a background, Ontario has a direct access system and so does BC. I'm trying to think of who I should pose this question to. Maybe we have time to hear responses from 2 people, unless anyone is interested in, jumping in here. So maybe I'll go to Gary. Maybe Gary, you can start us off on that.
There's a lot of controversy, some division as well in the community, in the human rights community when we move to direct access in Ontario. Again, I want not one system works for everyone. And the key is to break it down to the common principles. What do we need? Access. We need resources. No system will work without being properly resourced and without access for the communities. So as long as we can guarantee that somehow in whatever system change we have, then let's go for it. But that requires some fundamentals.
Anyone else want to jump in here? Laverne?
I agree with what Gary has said. And I think that, if we want to think about moving to a direct access system, we just have to we have to weigh the pros and cons of what we've experienced since 2008. I think there are a number of people who will say that we're missing perhaps the advice that we got from the Commission, and others who will also say, there are people who really can't handle the direct access. Possibly there are positives as well. So I think we just need to have a thorough kind of canvassing of what those elements are before making that decision.
Thank you. And then just very quickly, I know we don't have a lot of time, and I think I see Tony's come on. Is that the hook, Toni?
We just want to give these people lunch. The people need to eat.
Okay. So why don't I then just wrap up? So first I want to thank very much our panelists for their participation this morning. I really found this to be very engaging, and I think we could have gone on for the afternoon as well. So thank you all for your participation. And I know that I didn't see all of it, but I did. I was sort of keeping an eye on the Q&As and in the chat. And so thank the audience as well for your engagement. And I turn it back over to you, Toni. Thanks so much, everyone. Have a good day.
Thank you. And Sharmaine, thank you so much for moderating that panel. I would agree that I could literally listen to each one of these sections for the whole day. It's the biggest struggle to get it all in, but your perspectives, what you bring in terms of lived experience and the experience of people fighting the behemoth that is our system, it's invaluable. And so we're grateful to all of you for coming, and thank you, Sharmaine, for moderating. I will let you all go for lunch because we have a quick lunch. So we have 30 minutes. and then you're coming back for extraordinary panels, another incredible keynote. And so you have 30 minutes and we'll start right at 12:30 and stretch, have a bit of a break, close your eyes, eat something yummy. Thank you, everyone. Brian?
Yes. You just muted, so now I can't, but now I can.
Nobody else can hear us?
Oh no, everyone can hear us. I'll see you in the chat.
Beautiful. We will be starting in just a few minutes, folks.
Would you like me to do a testing right now?
I think the test worked, Patricia. We're going to just start. That's wonderful. Welcome back, everybody. I hope you had a little time to break and have lunch. And for me, I was digesting all of the dense and important information that I heard. I'm now very excited to invite you to our second keynote of the day. It's delivered by Dean Donna Young. She's going to be introduced formally by our OHRC Chief Commissioner, who you heard from already, Patricia DeGuire. But I want to just say in one sentence, I work directly for Dean Young, and she is the person of the highest caliber, capacity, and class that I have ever worked with in my entire life. So you're in for a treat. Over to you, Patricia, our Chief Commissioner.
Thank you so much, Toni. Hello again, everyone. Jolly good afternoon. I hope you found time to have lunch, because I believe, as Toni said, we are in for a treat. And before I say much more, I just want to let you into a secret, and you've got to promise me you won't tell anyone, that Dean Young and I went to Osgood Hall together. And yes, we did a lot of positive things, including turning the gender question on its head and to be identified as women of color who would not stand being othered. And so I'm very pleased to introduce Donna Young, the founding dean of the Lincoln Alexander School of Law at the Toronto Metropolitan University. And before taking on this great position as dean, she was the President William McKinley Distinguished Professor of Law and Public Policy at the Albany Law School, and a joint faculty member at the University at Albany's Department of Women, Gender, and Sexuality Studies in Albany, New York. And by the way, everyone, Albany is really the true capital of New York, or not New York. Since becoming dean at the Lincoln Alexander Law School, Dean Young's contribution to the legal profession in Canada has been recognized in several ways. Apart from saying it has been enormous, impactful, timely, and edifying, she was the recipient of the 2021 Canadian Law Awards, Female Trailblazer Awards, the recipient of the 2021 Top 25 Women of Influence Award, the recipient of the 2021 University College Alumni of Influence Award at the University of Toronto, and acknowledged as one of Toronto Life's 2020 most influential Torontonians. And so we are indeed grateful this afternoon to sit and feast on the words of Dean Young. Please join me in welcoming her to the podium.
Thank you, Patricia. I'm absolutely delighted that we are gathered together to consider how racialized Black and Indigenous people and all women can share our stories, explore our commonalities, and work together towards reconciliation while furthering Canada's promise of reinvention and of equitable access to racial and gender justice. It really gives me great pleasure to participate in this wonderful conference today. And I'd like to acknowledge the important contributions of the panelists this morning. They've done so much of the work of explaining the lived realities of our communities and how systemic oppression hinders our full participation in the legal process. And I give special thanks to Professor Blackstock, whose incredible keynote this morning poignantly demonstrates Canada's shameful treatment of Indigenous children, families, and communities. and urges us to be critical of the tools that are used to address systemic harms. She has given voice to children who are powerless to advocate for themselves against a system designed to keep them silent. And for that, we should all be very grateful. And Patricia, thank you for your very warm welcome again. As we moved through Osgood together all those years ago, I knew you were destined to do great things with your legal career. But if you had told me 30 years ago that you and I would be engaged in this conversation, one as the Dean of the Law School at the university formerly known as Ryerson, and the other as the Chief Commissioner of the Ontario Human Rights Commission, I think I would have laughed out loud. But knowing what we were up to as law students, I think that silently I would not have been completely surprised. But today we are being asked to think about the Ontario Human Rights Code, its impact, its pitfalls, and its promise. And to provide some context to my discussion, it might be helpful to know that before becoming Dean of the Lincoln Alexander School of Law, I was a law professor in the United States for decades. But I am a Torontonian and the product of two Canadian law schools, UBC and Osgood Hall. And I'm a proud alumni of the University of Toronto and of Toronto Public School System. And I'm also a member of a very vibrant legal community in Canada. As a racialized woman, the daughter of immigrants from Jamaica and Belize, I have personally experienced the sting of anti-Black racism and discrimination based on my gender. This last point about my experiences as a Black woman is part of my identity. To be a Black woman in Canada is to experience anti-Black racism and sex discrimination and the intersection of both. I say this not to elicit sympathy, but rather to state a matter of fact. And this fact matters as it has helped to inform my perspective on the law, on legal education, and on the practice of law. The Ontario Human Rights Code was designed to address discrimination against people like me. And though I appreciate this fact, I also encourage us to be critical of it and to make sure it's doing what it has set out to do. Again, I'm really honored to have been asked to speak at this conference, but I do so with some humility as I enter the conversation from a particular position. As a newcomer to the developments that have been taking place in Ontario human rights law while I was a law professor in the US and focused mostly on American civil rights laws. But it's also important to note that my analysis of American civil rights laws for the last several decades has been significantly informed by my experience with the analysis of a Canadian human rights framework. Before I became dean at TMU, I was a law professor in the US, and I examined the role of race and gender and how it played in the regulation of employment, the interpretation of criminal laws, and in access to justice through federal civil procedure. And as a law professor, I had the privilege of helping to guide scores of students through the study of law over more than 2 decades. But being an educator means taking on the awesome responsibility of training future legal professionals to serve the public in ways that make sense. Doing this means that legal educators are obligated to help our students understand how the practice of law and the very laws themselves have perpetuated and continue to perpetuate some of the worst injustices imaginable. And despite lofty legal doctrine and our professed national identity as a caring and fair-minded people, we Canadians remain too tolerant of inequality, inequity, and injustice. Without an anti-racist, anti-oppression, anti-colonial lens, we would be teaching our students a partial, whitewashed version of legal doctrine and history, and one that was at times purposely exclusionary and oppressive. As I contribute to this discussion, I ask you for your indulgence while I take you back 30 years to a time when I was briefly employed by the Commission as part of the work being done by the Anti-Racism Committee in its effort to address complaints by racialized employees about their experiences within the Ontario Human Rights Commission, and to address the low success rates of race discrimination cases at the Commission and at other human rights commissions across Canada. The final memo that I submitted to the committee was leaked to Christy Blatchford, as she was then known, a Toronto Sun reporter. And from there, it created a bit of a firestorm at the time. I'll read a few passages from that memo, and then a few headlines and snippets from some of the newspapers that reported about it. And then I'd like to highlight some of my findings and draw parallels to some of what we are experiencing now. And in doing so, I'll address the importance of critical theories of law and their practical application. And then I'll end my remarks by explaining why it's so fitting to celebrate the Code's 60th anniversary, but at the same time, why it is so fundamentally important to understand that the work of the Code is far from complete. Okay, so 30 years ago, which was coincidentally 30 years after the enactment of the Code, so now we're going in 30-year segments, I was engaged in a project at the Commission that was to have great significance in shaping my approach to and understanding the law. And I cannot believe how privileged I am to be here reflecting on that work, that summer work, 30 years later on the 60th anniversary of the Code. It was in the summer of 1992, and I had just been hired by the Commission to investigate how the Commission had been dealing with race discrimination complaints. And I described my project this way. The impetus for this project is the need for a critical examination of the manner in which race discrimination complaints are handled at the Ontario Human Rights Commission. Race discrimination is one of the most elusive problems faced by human rights organizations in North America. The success rate for complaints of racial discrimination in Ontario and other Canadian jurisdictions is low. This project is an attempt to identify shortcomings in the handling of race cases at the Commission and to suggest alternatives for anti-racist organizational change. Now, when I undertook this project, I had just finished articling, and the project took me about 3 months to complete. Over those 3 months, I examined about 12 years of human rights decisions from around the country and several years of cases, both decisions and investigation packages at the Ontario Human Rights Commission. And the idea was to draft a memo for the Commission's Anti-Racism Committee to help it formulate a plan to address complaints that were coming from employees. Now, when I undertook this investigation, the memo that I was going to write at the very end of this, the 3-month period, was followed by a couple of other memos that I was writing to update to keep the committee apprised of of what I was doing. And so when I finally did submit the report, I had already moved to the United States. And I have to say that my move to the United States was temporary, or at least I thought so. It turned out to be not as temporary as I thought. But in any case, I was in the United States when I finished writing the memo, and I submitted it by fax and I think snail mail. We had no internet at that time. I eventually came to learn that the memo was shared as is with employees at the Commission, and that it got leaked to the Toronto Sun the next year. That was in the middle of July 1993. Now remember, this memo was an internal memo that was going, what I thought, to just the Anti-Racism Committee. I didn't know how they were going to use it, but my understanding was that it was going to be the basis of some investigation, some internal critique, and kind of an educational program that would follow it. It was one small step in what I understood that the Commission was attempting to do. And so when I was in the United States, when the memo actually came out, I was kind of shocked to see that it was called the Donna Young Report. Now, I didn't label it the Donna Young Report. I just wrote it as a legal memo to the Anti-Racism Committee on this date. So that was the first thing that shocked me. The second thing that shocked me was that it was leaked to the Toronto Sun. And this didn't shock me. The headline that came out when the paper got wind of this report. And so the headline on July 14th, 1993 was "Racism Accused presumed guilty. And then when you read lower down in the article, it said, guilty until proven innocent. From there, other newspapers around the country picked up on it, and there were other headlines that followed. So for example, one on July 16th, like it or not, equality before the law is passé. Now, the memo was described as one that urged the commission to adopt a reverse onus position for race discrimination complaints. That's to presume that a respondent is guilty until the respondent can prove otherwise. That was the articulation of my memo that I was reading in the newspapers. By the next day, and you can imagine why this might have been a firestorm. The presumption of innocence is fundamental. I've taught now criminal law for almost 3 decades, and it is sometimes the only thing standing in the way of conviction without appropriate process. So the presumption of innocence, if my memo were attacking that, then it would cause some alarm. But it wasn't saying that. Nonetheless, the next day, there were calls to Premier Bob Rae to fire Rosemary Brown, who was the chief commissioner at the time. The attorney general and citizenship ministers were put on the defensive, and the report was subjected to heated exchanges at Queen's Park. After initially standing by the project, the commission took a stance that was somewhat distant from it and really just wanted the whole thing to go away. In the newspapers, the content of the report was described in various terms, and I'm going to give you a little bit of a few quotes. The Star said, the report places the onus of proving innocence on people and companies accused of racism, a reversal of the judicial premise that one is innocent until proven guilty. Another one says, citing other government initiatives, the Toronto Sun concludes that in combination with all of these other initiatives, these reports were a deadly combination of professional minority rage and bureaucratic white guilt. One op-ed title was, like it or not, equality before the law is passé, and that my memo said that only whites can commit racism. Another article said that it was a breathtaking recommendation that those accused of racism be deemed guilty until proven innocent. There were other headlines like unequal before the law. And then the one that hurt the most was came out of, again, the Toronto Sun, who didn't mention the report by name, but called it a sophomoric rant written secretly for the Ontario Human Rights Commission. And then there was some confusion about who Donna Young was anyway. And so there was, I was described in various terms, including as an articling student for a New York law firm, or an attorney from New York who was telling us how to deal with our own racism. In the memo, so all of that aside, and I'll come back to the effect that this media treatment had on me, because I was quite young at the time. I was removed from the situation already in the United States, and so not really getting a sense of how this was being played out in my hometown. But I want to say a few things about what the memo actually did say, and I'll tell you a few of my conclusions. One was that individual and systemic racism exists at the Commission and within Canadian society. That discrimination must be looked at in the context of complex power relations. That the normalcy of racism must be recognized rather than conceiving of it as a rarity. And then I said that we must assume at the investigation stage that a complaint is legitimate until its illegitimacy is established. That's important, because that was the line that was picked up, misinterpreted, I think sometimes deliberately, and used for political reasons. So I'll just say it again. We must assume that at the investigation stage of a human rights complaint, that a complaint is legitimate until its illegitimacy is established. I also found that in the human rights context, once we have established that social and systemic racism is the norm and not the exception, that the legal, that is the criminal presumption of innocence, is inappropriate at the investigation stages, again, at the investigation stages of race discrimination complaints. Now, this might be too subtle for some, but anyone who is a lawyer would know that investigations are different from criminal proceedings, especially investigations into civil wrongs like human rights complaints. And so it would be something like, and I thank Bob Ray for actually raising this at Queen's Park several days later. It would be something akin to the police investigating a complaint of robbery and not believing the victim. So in other words, at the investigation stage, we take the complaint seriously as though it happened and investigate. And through that investigation, if the complaint is illegitimate, no one has to prove it. If the investigator finds that it's illegitimate, it doesn't go anywhere. So what happened here was that I concluded that there was this weird thing that was happening in investigations and in some of the decisions that I was reading. And I attributed these weird things to the assumptions that I found that were at play in the treatment of race discrimination complaints. And these assumptions were coming through in the language that I was reading and in the way that race discrimination cases were decided, the rationale for dismissing them. And I put all of these together and I came out with an analysis of what I thought was happening kind of systemically. When you add up all of the individual reasons that were being put forward, you start to see this system, this commonality among those reasons. And what I concluded was that certain assumptions at play were things like the complainant, the person complaining about race discrimination, lacked objectivity. What they were complaining about was their own subjective belief. And thus, because it was their own subjective beliefs and not based on reality, they needed more corroboration than would otherwise be necessary. So if a person was complaining about race discrimination, that corroboration they essentially had to have someone else corroborate what they're saying. But oftentimes, and we know this, racialized people are some of the only people in certain settings, right? In certain employment settings, in housing. And all of the rest, right, are white or from other racial backgrounds that might not necessarily, that might not allow someone to understand some of the intricacies of certain kinds of race discrimination. And so I gave some examples about what I meant about this. And so, for example, the one example was from the British Columbia human rights case, where there was a failure to appreciate the significance of cultural stereotypes in influencing the respondent's actions, the person who was being, who the commission was investigating. That case involved a First Nations woman who had been denied service at a liquor store because the store manager believed that she was drunk. Now, the complainant was visually impaired, and she had a motor impairment which affected her gait and her speech. The store manager refused to believe her explanation and threatened to call the police. And we now know that calling the police is one of the most dangerous things that happen to people of color, to racialized people, to Indigenous people in this country. That's when violence escalates. But the commission upheld the discrimination complaint based on disability, but rejected her argument that she had been discriminated against on the basis of race, color, or ancestry. And so the fact that the respondent's belief was consistent to racial stereotypes of Native peoples was not considered. Notice that an intersectional analysis might have helped the adjudicator see that the understandings of racial identity and disability were being separated when in fact they should have been intertwined. Another complaint that I looked at was an incident which occurred when a mixed race student, a Black and white student, had been helping his gym teacher move some equipment. And another student joked about this and said to the complainant, "How do you like being used like a slave?" And so when the student, the mixed race student who was the complainant, erupted in a rage, the teacher's response was to discipline the complainant instead of the student who made the racially derogatory remark. And it was clear to me then that if the statement were made by a white person, this kind of strong emotional reaction might not have been invoked. And this is probably because there's a historical significance to the term slave for Black people in Canada. The history of Canada is one of slavery, right? That's something that we don't often teach, but it is true. Slavery existed in Canada. But more so, there were contemporary effects of the statement which gave it its racist meaning. And so therefore the impact and therefore the meaning depends on a cultural understanding of what slavery is, the identity of the person to whom the statement was made, and of the person who made the statement. It's not unreasonable to conclude that the white teacher who chose to discipline the complainant was discriminating against the complainant by failing to understand the racist implications of the statement and therefore misdirecting the punishment. I believe that case was dismissed at the investigation stage. And then one more example. I found that boards were reluctant to draw conclusions about someone's beliefs from what they say. In one case in particular, there was evidence that the supervisor of a complainant engaged in consistent racist name calling. And I'm not going to repeat the names that were being used. There's the N-word. There's a reference to Asian Canadians, Italian Canadians, Polish Canadians. There were sexist comments. And some of these comments were directed at the complainant. But this is what the board found. They found that a causal link between such thoughtless, insensitive, inappropriate, and hurtful expressions and the respondent's decision to deny the complainant a position in management, that there was no causal link, sorry. And the board therefore found no contravention of the code and suggested that it was the complainant's subjective belief rather than actual discrimination which led to the complaint. So the slurs were held to be unrelated to subsequent adverse action. So back in the 1990s, when I did this work, I was relying very heavily on a group of law professors that have been loosely defined as critical race theorists. These writings are complex, but wonderfully written in a way to respond to the almost complete erasure of Black, Latino, Asian, and Indigenous voices in analyzing, interpreting, and implementing the law. And out of a deep frustration with the still dominant idea at the time that racism was an aberration that could be eliminated through anti-discrimination laws without any deeper appreciation that the legal system itself was inherently anti-egalitarian and intertwined within a system of white supremacy. Now, law professors know that the outcomes of legal disputes often depend on who has the better story. The story can be a legal one, for example, whose story fits better into a legal theory of a case. But it also depends on how the story resonates with and is understood by the decision maker. So to understand how law is practiced, we must first appreciate that disputes consist of different and sometimes contradictory stories about the same problem. In other words, the law is replete with stories and dedicated to determining whose stories are the most persuasive. First-year law students experience this when they are asked to read cases. Lawyers who represent clients are telling different stories, and so too are judges in their majority and dissenting opinions. Judicial opinions and administrative decisions sometimes tell very different stories. And so it's not uncommon to read majority and dissenting opinions that have little in common with each other. In law schools, we must be dedicated to telling the stories that weren't and aren't being told in law. And so in the battle between stories, human rights laws are generally ill-equipped to deal with persistent structural barriers to equality, and instead focus too narrowly on individual cases where some stories have more purchase with the decision makers than others. And so a critical analysis of the law will begin with the premise that racism is systemic and it is part of our societal norms. It permeates our lives. It is embedded within systems and institutions like the legal system that replicate racial inequality. That racist incidents are not aberrations, but instead are manifestations of structural and systemic racism. And that even though overt intentional acts of discrimination are to be found scattered throughout workplaces, educational institutions, healthcare, housing, and public services, structural and systemic discrimination is more pernicious and destructive in some ways, as it is almost completely resistant to attempts at redress through human rights laws and processes. It leads to the privileging of the experiences and perspectives of those whose identities are aligned with those in power, who might be those who are decision makers. And it leads to persistent social and economic inequities that manifest themselves in lives, some lives mattering and others not. So Black lives, Indigenous lives, Asian lives don't matter, for example, under political, education, and legal systems that were designed and instituted with the purpose or effect of maintaining white superiority. Now, in preparing this conference, I dusted off the memo that I had written. It was typed on a typewriter, I think in Courier font, and I've read it now with fresh eyes. And I was struck by some of what I had written, some of which I wish I had articulated better, and some of which used language that was available to me only at the time. But the issues I raised continue to animate our conversations today. I argued that since the Ontario Human Rights Commission was tasked with educating the public, it was under a special obligation to get things right. I urged legal counsel to get more creative in arguing on behalf of complainants by empowering innovative arguments and taking on cases without corroborating evidence. I argued at the investigation stage of the complaint, investigators ought to treat the complaint as though it were legitimate and investigate it accordingly, instead of dismissing it before proper investigation. But I ended on an interesting note, and I do not remember this. So when I read it again, it really struck me. At the end of my memo, I critiqued my memo. I said this project focused on a specific issue, race discrimination. For this reason, it has been artificially segregated from other intervening considerations. It is very difficult to separate issues in this way, especially when discrimination is never purely racist, sexist, or homophobic, etc. A complex set of stereotypes and assumptions are complicit in discrimination. For purposes of analytic simplicity, this project focused on race. However, it can be legitimately criticized for not adopting the integrative approach that is an absolute requirement for adequately and comprehensively addressing human rights complaints. And so, of course, I was speaking about intersectionality at the time. I used different language, but the concept of intersectionality had already gained purchase in the legal education community. This was Kim Crenshaw, who was urging us to understand how aspects of a person's social and political identities combine to create different modes of discrimination and privilege. She says that when we tend to talk about race inequality as separate from inequality based on gender, class, sexuality, or immigration status, what we're missing is how some people are subject to all of these, and the experience is not just the sum of its parts. So much has changed since I wrote that report, and so has the practice of law. But of course, much has remained the same. And in my memo, I referred to anti-racist organizational change, unconscious bias and stereotypes, systemic discrimination. All of these issues are still hotly debated, at best misunderstood, and at worst, cynically misused to further an undemocratic political agenda. I think the Commission's work on systemic barriers to equality has contributed an important way to understanding, to our own understanding. And I think the courts have grappled with some of these same issues. Charter analysis began, I'm going to argue, in 1982 with a more enlightened view of fundamental rights than the US Bill of Rights did back in the 19th century. And so I think that in some ways we're ahead in terms of our analysis than other countries like the United States. But as our conference speakers have so profoundly demonstrated, Canadians have a really high tolerance for racist oppression. So just over the course of the last few years, we've seen an intolerably high level of anti-Asian discrimination, violence, and terrorism. Ongoing discrimination against Asian Canadians in a host of settings include housing, education, employment, and the provision of services. Islamophobia has manifested in laws, rules, and regulations, surveillance, and in deadly attacks on places of worship, and anti-Semitic attacks on and street harassment against young children and elders, the defacement of synagogues. We've seen the hard evidence of what Indigenous communities have always known: the violence and death within residential schools, the over-policing of Indigenous communities, the criminalization of Indigenous culture, language, and practices, large discrepancies in public services for First Nations children. And the Toronto Police Force has just recently issued a stunning internal report concluding that Toronto police officers use more force against Black people more often with no clear explanation as to why. We've always known this to be true. And our continued and persistent acceptance of discrimination against people with disabilities, in our failures of accommodation, our overt discrimination in employment and education, in housing and public service is manifest. So at the beginning, I was going to talk a little bit about how my arrival back in Canada back in January 2020 played out. And I want to say, I'm not going to go into detail, but I want to say that there was a really lovely note that was sent to me by Juanita Westmoreland Traore, who was the first Black female law dean in Canada. And she wrote me a beautiful note, and it was full of love and encouragement, although I hadn't even met her. But I also got wind of a couple of other messages from people who might not have been as thrilled that I was taking on this position. I'm going to just briefly point to one of those. Actually, there really was only one that was really serious that I was made aware of. But the writer of this letter sent it to the provost and president of Ryerson at that time. He sent it to the Premier of Ontario, the Minister of Education. He sent it to all of the committee members who hired me. And he was enraged that I had been hired. And in response to an announcement in the Globe and Mail of my appointment, he wrote that he pointed to the advertisement for the deanship that Ryerson at the time had issued. And in that advertisement for the position, it said this, and this is boilerplate language, you'll see it everywhere. We encourage, or we should see it everywhere. We encourage applications from members of groups that have been historically disadvantaged and marginalized, including First Nations, Métis, and Inuit people, Indigenous peoples of North America, racialized persons, persons with disabilities, and those who identify as women and or 2SLGBTQ+. Please note that all qualified candidates are encouraged to apply. So the writer of this letter looked at who actually got the job and asked this question: one is left to wonder if it would not have been easier, not to mention far more honest, for Ryerson to have come right out and said that applications from able-bodied heterosexual white men were not needed. By your despicable behavior, you have managed to accomplish at least three things. First, you have discriminated against a very large segment of Canadian society, something that is utterly unacceptable in Canada. There can only ever be one acceptable hiring criterion: merit. Two, you have forever tarnished the reputation of Ms. Young. There is at least a possibility, however remote, that Ms. Young was appointed on the basis of merit. However, in view of your blatant, utterly unacceptable discrimination, this can never be known. And for the rest of her life, Ms. Young will be viewed as a fifth-rater who is appointed entirely because she is Black and because she is a woman. I've mentioned this before at a couple of other conferences, and I always say, because when I read it, I always think, that was so thoughtful that he was thinking about my feelings. Anyway, and then third, you have brought Ryerson into even more disrepute than it already was. Excuse me. Which student worth his salt would want to be associated with an outfit that is crawling with vast hordes of social justice warriors, special snowflakes, Marxists, radical feminists, garden variety feminists, postmodernists, virtue signalers, thought police, and every other kind of similar loon? Equality of outcome and a trophy for everybody has no place in academia. Excellence and merit are all that matters. The shame on the lot of you, he says. Now, this language of merit, and remember what provoked this, it was the appointment of me as dean of this new law school. And in that language, I'm not going to parse it, it's pretty obvious what it is, but in that language, this notion of merit comes up. And in the articles after the so-called Donna Young report was leaked to the press, many of those articles also talked about merit and how the idea of merit was being undermined by affirmative action and by different ways of seeing equality, and by even addressing notions of systemic racism or systemic inequality. And so I read this not because I want to shock anyone or gain sympathy, because this letter didn't, it was a bit shocking at the time, but it ultimately didn't have an effect on me. I didn't take it personally. It didn't slow me down. It didn't embarrass me. It didn't undermine my confidence, but it had the potential and was in fact designed to do all of that. But it's important to note, not for a minute did I think that this was merely the rantings of a disturbed person. In fact, I think this man was expressing an undercurrent of thought that has sought to keep us in our place, to define our successes as failures, our gains as ill-gotten, our achievements as undeserved, and our very identities as disqualifying. There are growing undercurrents of intolerance in our communities. Calls by some prominent members of the legal profession who have vowed to put pressure on law schools to teach courses that they want, to engage in only certain kinds of research, to ban different theories of thought from the curriculum, and to target faculty members for the courses they teach. I mentioned this letter from this disgruntled lawyer to help explain what motivates me. I'm telling you this story to flesh out the realities of what some of us face when we enter into spaces not designed to have us there. Discrimination is felt not as a list of statistics, but through personal experience. And those experiences are real and they have consequences. The promise of the Ontario Human Rights Code is that it can address these experiences and signal that they are unacceptable. Professor Blackstock poignantly pointed out this morning that the failures of the human rights system, ignoring what Indigenous people were fighting against at every opportunity, against the inertia, the disinterest, and the cynicism of Canadian systems designed to impede inequities. She points out that there are these failures, and I agree. And that's what I was arguing in this memo that I wrote 30 years ago. But the instances of this discrimination continue, the systemic barriers continue, a misunderstanding of the laws continue, and a misunderstanding of theories addressed to, designed to address these inequities, right? The political case against critical race theory or feminism, all of those things we have to fight against. They've always existed though, and that's important to remember. Finally, I'd like to end on a more personal note, one that pays tribute to the relationships that many of us have that allow us to move through difficult times. And so what was the immediate fallout from the report 30 years ago? I really don't know. There was radio silence. I didn't hear from anyone from the Ontario Human Rights Commission, except one person who I had a very, very brief conversation with. And it kind of surprises me that even after all of this time, I still have a lot of questions. I don't know, for example, what the fallout was within the commission. I was never told. I was never contacted. I have no idea. And I really don't know, except as it was translated through me from friends and family, what the effect of these newspaper articles were. No one ever followed up with me though. And so I had no explanation, for example, as to why the cover page was called the Donna Young Report, when it was just an internal memo that I was writing for one of the committees. And who linked it to Christy Blatchford anyway? That was very designed and very deliberate and very political. But in any case, what happened when it came out, that initial media report came out July 14th. And I had just begun teaching as a law professor in the United States 2 weeks earlier. And again, there was no internet and I was very disconnected. And so I was really scared at the time. Now, it might seem silly for me to be scared, but I was scared. The articles were really reputation damaging. They were really misguided. They deliberately, I think, misconstrued what I had actually been saying. And it really knocked me off my feet. And so I was really new to my job and I had a lot of insecurity. I was an untenured, 20-something-year-old first-year law professor. And I didn't know how this was going to affect my job or my colleagues or how they would see me. That was a little bit naive because my colleagues knew nothing about it and life went on as it would. But eventually I began to see op-ed articles and articles about the Donna Young report. And that was when the analysis actually did start to come out. What I actually said started to come out. Clayton Ruby, several months later, wrote an op-ed. And he said this about the report and about the reporting of the report. And he said this about Christy Blatchford's article. He said, lies, damned lies. And then which made me feel good. And then he went on to directly quote from my report in such a way that made it unnecessary for me to defend myself. He got it, he defended me. So did Premier Ray. And so did Rosemary Brown. They all understood what I was saying and they defended it. But during that time, yes, I see that I'm about 10 minutes, but during that time, my parents were on the phone with me several times a day, reading me the headlines, faxing me newspaper articles. And when I returned to Canada in 2020 to begin my deanship, I discovered that my mother had kept all of the articles from that time and she shared them with me. I use them today. I'm going to end there because I see that my time is running short and I apologize. And I will turn it over to Patricia, but I did want to say this one last thing. As you heard this morning, racism is a trauma, and it is felt individually, but also as a community. And so my experience through all of this was insignificant compared to the violence of racism perpetrated against individuals and groups. And that is why it's so critical to use our own experiences to inform how we see the law, but also why we fundamentally need to listen intently and carefully to others. I have the privilege of being surrounded by experts, my faculty, lawyers, and perhaps most significantly, my students, who are some of the best teachers we have. And so we have to listen to others in order to address these concerns ourselves, not as individuals, but as groups. Thank you. Patricia.
Thank you, Dean Young, for sharing your reflection and providing the overview and the context of your rather infamous Donna Young report in 1992. And believe me, I read it, and it was a source of Saturday night laugh for me because I understood all the misunderstandings. But on a serious note, what I hear you say, in fact, what I heard Dr. Blackstone say this morning, and that was echoed by the panelists in the subsequent panel. I heard you say, and as well, is systemic issues continues, and the human rights institutions remain a good tool to combat systemic discrimination. But we need to reimagine and rethink the tools that we use to fight the good fight. I understand as well, to use my own language, that human rights people, those of us who work in these spaces, really, I won't call them spaces, but call them trenches. And we must take a multiple approach in dealing with these issues. And so I want to ask a question. In fact, this question came from Sarah Luther, who said, what in that memo stands true today, and where have we made the least movement forward? And perhaps you covered that in part with your closing arguments for the benefit of Sarah, understanding that her question was asked and understood, that you might want to give us a 30-second commentary on her question.
So I think that a lot, it's really interesting. A lot of what I wrote, again, I was using language that was available to me 30 years ago, but a lot of what I wrote, I stand by. I don't think there's really anything that I think that was kind of illegitimate at the time or even today, because I think we're seeing some of the same issues arise, right? Systemic issues of racism are not only systemic discrimination is repugnant, but it's also it's so forceful, it's so ever present, it's so always, and I don't think have come up with the right tools yet to address those issues. But I'm not even sure that we've come up with the right tools to address those overt, purposeful kinds of discrimination where we actually have evidence of it. It seems that we still see adjudicators bending over backwards, trying to justify that, the treatment of other people. It has to be everything other than race. It's something else. So I think we have a lot of work to do.
Okay, thank you for that, Donna. And I think when there's another question is on my behalf for the audience, I'm sure that the audience is curious to hear more about how the code tackled intersectionality when your report was written. But it's not just when your report was written, it is still today where the concept of intersectionality is either underused or overused, but I'd say grossly misunderstood and applied when dealing with human rights matters. So has this shifted in any way or over the last few years, or has it improved?
Yes, the understanding, so intersectionality was a concept that came out in the late 1980s, right, from Kimberly Crenshaw and others. And so it's not a new concept at all. It came through legal literature, and it was used to address why certain kinds of discrimination complaints from the US context were not successful. And the idea was that the kind of discrimination that, for example, women of color face was not recognizable, not the same as the kinds of discrimination that either white women face or men of color. And so it had its unique kind of, it manifests itself uniquely. I think what happened now is that that term has been used, it's been kind of rediscovered, and it's been used, I think, very effectively, you've got a backlash against it. And that backlash consists of re-articulating what it really means. So intersectionality for political purposes now means that white men can never be discriminated against, or white men are evil, or white men are the problem, right? So it's a way of a rallying cry. It's kind of this, this rallying cry to suggest that these racialized people are getting too ahead of themselves, right? That we have to keep them in check. We have to start articulating what it is that they're saying in ways that, that create passion in some people and violence. So I think that it's being misused and misunderstood for sure, but it's not a new concept.
Thank you. Earlier this morning on a panel, we heard Gary said, and I'd say rightly saying so, that the community's involvement in the rights, not just discourse, but outcomes, is critical.
Yes.
And when I think about the community clinics, we have more of them now than before, and they are able to deal directly with the individuals and use their lived experiences to create evidence-based information in presenting their cases, whether to the courts or to tribunals. But what is critical, I heard from all the different people who spoke, was that one of the big hindrances for the human rights to grow, where they use research, public education, inquiries, interventions, whatever the tool, collaborations, which I find is a very rich tool these days. And no matter what tools are used individually or collectively, one of the biggest barriers that the institutions face from all levels is resources. Any comments on that?
I agree. I absolutely agree. The resources, but remember, the distribution of resources is a political act. So if these institutions and these community groups and these clinics are not getting the resources, right, that is a political act. That's deliberate. We have to ask why that's the case. And if I had more time, I would talk a little bit more about the politicization of clinics, especially in legal clinics, especially in the United States. We do not want to go in that direction. We've got state legislatures shutting down clinics that are designed to protect the rights of poor people. And we cannot go in that direction. So it can be very, very political. So far, we haven't gotten there as far as I know.
Yes, it is political, but it is also judicious, because in Irving Toys, the Supreme Court of Canada indicated or said quite strongly that government or politicians had the power to determine where they spend their money, because resources were sparse, and they also had the right to determine where to distribute their money. So it really wasn't helped there on the resource question.
No.
Lastly, and I notice we're out of time, and the last question, I would say, I am sure that's some, if not all in the audience agree that 30 years ago, you were accurate. And what issues do you expect to emerge in the next 30 years?
Okay, so because we have run out of time, I am going to assume that the next set of speakers are going to address some of those issues. So I'll leave it to them, and I look forward to hearing from them. And thank you, Patricia, so much for those lovely questions. Thank you.
Thank you so very much for your participation today. It really was a trip down memory lane. Have a jolly good afternoon, everyone. Good luck in the next session.
Dean Young, if we could, we'd bring you back for the closing so you could close us off with that answer. Oops. The host.
We can hear you, but we can't see. Okay, I'm going to mute myself and turn off my camera. Bye. Thanks, everyone.
Oh, okay.
So we're going to go straight into the next session because we have back-to-back panels. But I think what emerged most from what we heard for Donna Young's, what I would almost say testimony, is not just of an experience that she had 30 years ago, but an experience that we're hearing from her, from Dr. Blackstock, from everybody doing this work, that there is an incredible cost to the lives of people that experience this discrimination. And those who fight and advocate and litigate and try to bring that knowledge to the public also pay an incredible personal cost, right? And that these are parts of the manifestations of racism, that it is endemic, that it's in our systems, that even when we reveal that it exists, Donna Young is telling us, you're punished and discriminated against for that. So thank you for your incredible words. To keep on time, we are going to go straight into the next panel. And we have back-to-back panels for you right now. So we're very grateful that you will take breaks as you need them. That's the wonder of doing something like this on Zoom. So we call these our back-to-back power panels. And for the very first panel, it's called Rights Inflation or Rights Realization. And in this panel, we're going to look at contemporary expansion of human rights claims. And we need to consider whether this amounts to rights inflation. Are we having more and more rights claims? Or is it actually a rights realization? These exist and we didn't have them before. So for example, two of the newest code grounds that have been added is gender identity and gender expression. It's not that people didn't have those before, it's that we hadn't articulated them within our rights code, right? So moderating this session for us today is Dr. Remi Warner, who I work extremely closely with. Dr. Warner is the Director of Human Rights Services at Toronto Metropolitan University, where he oversees the administration of the university's human rights policies and institution-wide efforts to protect, to promote, and advance the culture of human rights at the university. Prior to that, joining Toronto Metropolitan, Remi headed the Toronto District School Board's Human Rights Office. And prior to that, he was an advisor and manager at Ontario's Anti-Racism Directorate, where he played a lead role in the development of the province's anti-racism strategy and legislation, as well as did tons of work around data standards for the identification and monitoring of systemic racism. And again, for those of you who haven't met Remi yet, you're in for a treat. This is a person that in 10 sentences can have you thinking for the rest of the year. I'm not joking. Over to you, Remi.
Well, that's a big billing, Toni, that I'm bound to disappoint. Thank you very much for your kind and generous introduction. Good afternoon, everyone. Welcome to our exciting and somewhat provocatively titled panel, Rights Inflation or Rights Realization, Perspectives on Expanding Rights Claim. I will be the moderator, as Toni mentioned, and I'm pleased to be joined today by our esteemed panelists, Dominique Clément, Nathalie Des Rosiers, Anthony Morgan, and Aziza Kanji, whom I'll be introducing very shortly. Our panelists today will be reigniting a debate that was first explicitly articulated and framed in a book by Dominique Clément entitled Debating Rights Inflation in Canada. In this book, which forms a backdrop for today's reflections, Clément describes rights inflation or rights proliferation as the growing tendency among a growing number of people and movements today to frame their grievances as a violation of their human rights, a trend that Clément argues first began on a wider scale globally and in Canada in the 1970s, when human rights entered into the common Canadian vernacular as a way to frame anything that is deemed an injustice, quote unquote. The book explores the history and consequences of this trend and invites four other contributors, including with us today, Dr. Nathalie Des Rosiers, to debate the implications of what Clément characterizes as a failure to distinguish between human rights and social justice-based claims on society and the state. many of the latter of which Clément argues should not, properly speaking, belong in the pantheon of core human rights, hence their characterization as rights inflation. Needless to say, not all agree with this characterization. Much disagreement centers on whether and where one should draw the line between judiciable human rights and non-judiciable social justice claims more generally. Among Clément's arguably more controversial claims, as relates to today's overall conference theme, and of course, Dominique will have the last word on his position in this respect, is that rights claims centering on systemic inequity of various kinds belong more appropriately in the political sphere as a matter for political debate and contestation over the distribution of social goods and benefits in society. I have centered this dimension of the debate in particular today because much of today's proceedings focus precisely on the uses and limitations of human rights in effectively addressing entrenched and systemic inequities and discrimination, including those seeped in deep and long-standing colonial and neo-colonial social and political arrangements. So joining us today to expand the circle of debate in this book, in addition to Dominique and Nathalie, who are featured in the book, is Anthony Morgan and Aziza Kanji. Aziza is a legal academic, writer, and I'm calling her an activist. She doesn't self-identify as such. Public intellectual and journalist whose work focuses on issues relating to racism, law, and social justice and their intersections. Anthony Morgan is a racial justice analyst and strategist, educator, and lawyer. He is also the manager of the City of Toronto's Confronting Anti-Black Racism Unit and co-founder, among many other things, of the Sentencing and Parole Project, which aims to reduce the over-incarceration of Black Canadians. Dr. Nathalie Des Rosiers is the principal of Massey College. Her many former distinguished roles include being an Ontario MPP for Ottawa-Vanier, Dean of the University of Ottawa's Law School, General Counsel of the Canadian Civil Liberties Association, and President of the Law Commission of Canada. Finally, Dr. Dominique Clément is a professor in the Department of Sociology at the University of Alberta and a member of the Royal Society of Canada. Dominic is the author of Canada's Rights Revolution, Equality Deferred, Human Rights in Canada, and Debating Rights Inflation. His website, historyofrights.ca, provides a portal into the history and evolution of human rights and related social movements in Canada. I encourage you all to look at the bios in the conference program agenda for a fuller accounting of the depth of experience and qualification among today's panelists and what they're bringing to today's discussion. Quick note on the format: we'll begin today's dialogue, which ends at 2:50, 10 to 3, with a short presentation from each panelist, which will be followed by an opportunity for each of the panelists to offer a response to their co-panelists, following which I will moderate a short Q&A before concluding with some questions from the audience. And in the meantime, as throughout the rest of the day, please feel free to write your questions in the Q&A function throughout the panel, and our facilitators will pass on these questions to me for posing to our panelists. With that said, I will hand it over to Dr. Dominique Clément, whose book helped to occasion today's debate. Thank you, Dominique. Over to you.
Thank you. And thank you for the opportunity to speak today. It's a pleasure to be here with such distinguished speakers. So when we talk about rights inflation, we are talking about the tendency to frame a broad diversity of grievances as human rights violations. And I come to the issue as both an academic and an activist. As an activist, I often see how people conflate human rights with legal rights and the limitations of seeking social change through legal institutions. And in my historical work, I'm often struck by how narrowly we defined human rights in the past, how expansively we use the term today. Before 1972, for instance, no country recognized the environment or education as a constitutional right. Today, more than 150 countries have constitutional protections for the environment and education. This is, certainly from an historical point of view, an astonishing instance of the widespread recognition of a new right in such a short time span. International treaties recognize more than 300 human rights today compared to a couple of dozen in the 1940s. In Canada, it's common to hear systemic social problems such as poverty, wealth inequality, the environment or resources for education and healthcare framed as human rights issues. To be sure, these are among the most pressing social and political issues of our time. Such right claims demand our respect and protection. But the question for us today is how to best frame systemic social problems in ways that produce a compelling vision for social change. Now, the term rights inflation is admittedly something of a loaded term, especially in today's context. So let me just clarify a few points. First, rights inflation need not necessarily be negative. Rights inflation is a natural and healthy necessity for any liberal democracy. Ideas such as equal treatment, freedom of religion, or due process must and do evolve over time as technology and social norms evolve. Secondly, using human rights to frame issues such as inequality or discrimination is a very recent historical development. In the past, people were more likely to debate policy around education or poverty in religious or ideological terms. So it's really only been at best since maybe the 1970s that human rights has emerged as a truly global vernacular. Finally, there's nothing unusual about scholars or practitioners from all ideological perspectives criticizing the concept of human rights. Martin Luther King and Gandhi rejected the language of human rights. So did Marx and Bentham. There's an entire field of feminist scholarship today that derides rights talk as patriarchal. It's not that unusual to find scholars or activists who characterize human rights as a debased rhetoric. There's also nothing unusual about contemporary social movements rejecting the language of rights. Save the Children and Oxfam, for example, had for many years rejected framing poverty as a human rights issue because they perceived it as being too political. So I'm certainly not alone in questioning the transformative potential of rights talk. Because rights inflation is a recent development, we haven't fully come to understand its implications. It's a historically unique development that has been facilitated through the proliferation of human rights treaties, human rights NGOs, and human rights institutions, almost none of which existed almost 2 generations ago. So my point is that human rights is not the only language we can use to frame injustice. Framing an issue as a human rights violation is a choice, often a strategic one, designed to place one claim above others. So my central argument is that human rights is and should be the highest moral claim in any society. For that reason, we should be wary of framing every injustice as a human right. After all, it was the notion of a narrowly defined foundational principle of shared basic human values that enabled the idea of human rights to become a popular rallying cry among people from diverse societies around the world. And I should stress this is not a purely academic debate. There are manifest implications of rights inflation. It confuses how we teach human rights in museums or in schools. It has helped fuel a backlash against human rights law. It also has real life implications for people. Because human rights is a gender neutral discourse, men have been disturbingly successful in using the courts to challenge gender specific laws around child custody, naming rights, sexual violence, and more. As Clifford Bob argues in his recent book, rights talk can just as easily be used to marginalize and oppress as it can to empower. In fact, as Sam Moyn has also argued, human rights became a popular global vernacular in the 1970s for the very reason that it was not a transformative ideology. Human rights is arguably a poor language for addressing complex social problems. It's a discourse of absolutes. They're non-negotiable principles. It frames the issue in stark terms and thus limits options for compromise. It sets the stage for a deadlock conflict between social actors that have come to understand their grievances as non-negotiable rights. You need look no further than contemporary debates in the United States over abortion or gun control, where a rights-based framework has poisoned public discourse and fostered political polarization. Social justice, unlike human rights, is negotiable in that it is contingent upon the available resources of a society. Furthermore, framing a grievance as a human right almost inevitably makes it a legal issue. In contrast, framing inequality as social justice infers a broader societal problem that requires systemic solutions. Human rights are best served in the political, not the legal arena. I'll just quote Conor Gearty here, a distinguished law professor at the London School of Economics, a leading expert on human rights, and he writes, "The least effective way of securing social rights is via an over-concentration on the legal process, with the constitutionalization of such rights being an especial disaster wherever it occurs. Such a move turns the whole subject over to its falsest of false friends, the lawyers, a community which amount to little more than an array of pseudo-politicians on the lookout for shortcuts to difficult questions and for ways of plying their trade that are more agreeable to their ethical selves. Now, to be clear, this is not an argument in favor of a hierarchy of rights. Hierarchies of rights are inconsistent with the very notion of human rights. Yet framing systemic social problems such as poverty as rights violations has the same effect. Liberal capitalism is premised on the existence of poverty and unemployment. You can't have one without the other. In a society where resources are limited, therefore, we have to make compromises. If these issues are framed as human rights, we invariably create hierarchies of rights when we decide to fund some social programs over others. A human right that is inconsistent with our economic and political system, or that cannot be enforced by the state, is arguably no human right at all. I'll just wrap up with a quick comment on why this matters to human rights commissions in particular. Commissions play a key role in shaping our rights culture. They are increasingly the battleground for competing rights claims. They engage in education that fosters new rights claims. Yet the statutes and institutions, with some exceptions, have not changed significantly since their inception. That design is arguably ill-suited for our modern rights culture. Now, it's not to say that it should be this way, far from it. Ideally, we would see an infusion of resources for human rights commissions across Canada that would allow them to, among other things, focus more on resources and education. I see no contradiction in envisioning human rights commissions providing legal mechanisms for rights violations while using education to proffer a vision for a better society premised on social justice. Either way, rights inflation has created unique challenges that will undoubtedly impact these institutions in the 21st century. Thank you.
Thank you, Dominic. I'll now turn it over to Nathalie.
Yes, thank you. And first of all, thank you very much for inviting me to this fabulous conference. I've learned a lot since this morning, and it's hard to follow the great speakers that we've had throughout the day. I want to acknowledge that I'm speaking from Massey College on the treaty land of the Mississaugas, and the great privilege that I have to do so. Now, I was a critique of Dominique's argument in 2018, and still am. I continue to believe that there are things on which I agree. Certainly, I think law and human rights discourse is not the only discourse that we should entertain. And certainly, I've done so myself. Going into politics to make change is also a very valuable and very probably sometimes more useful way. Nevertheless, my argument is that discussing rights inflation is the wrong debate, and it is the wrong time to do so. I want to make a few points first in response to Professor Clément's arguments, and then I want to add a few comments about what should be the right debate, in my view, that we should have in our society now, and also more generally as well in the legal community. In my view, we don't need less human rights, we need more of them. And we need more of them now. We don't need less equality, we need more equality. The real issue here is why engage in that debate on taxonomy when indeed the real issue is how we make human rights being more accessible, realizable, and being enforced in a really good way. The pandemic has shown the depth and the lethal consequences of systemic inequality. Last week, we had a report on policing and race that discovered and that highlighted that Black people were more likely to have more violence inflicted upon them by the police. This threatens the very foundation of our legal system if you cannot believe that there's equality in front of the law. So those are crucial times to address inequality in a profound way. What is the role of Human Rights Commission and the human rights system more generally in this crucial dismantling of colonization and deep-seated systemic inequality and discrimination is what's at stake. So in my own view, I think the role of law has always been to be a place where you can say things that you could not say elsewhere. It is often, and Cindy Blackstock said that this morning, the only way that you can be heard. All public engagement, public education campaign, political campaigns are essential, and they will continue to be, but sometimes you are unable to access them unless you frame your issue as a legal issue, as a human rights issue in the current case. So to get change, we must use all available tools, and to eliminate or limit the human rights tool would be trying to expect change with the hands tied behind our back. It would indeed, my sense is it almost contributes to systemic discrimination if you limit the ability of using human rights claim to express new injustice. The human rights system and the human rights framing since the 70s has always been about allowing new people, new voices to be heard and assess and claim their injustice and give language to their injustice. That's what it does. And it is normal that it would continue to evolve, because the moment you open the door to some people entering a building, they notice things that they weren't there because they were not there in the creation of that building. They start noticing how many more injustices there are. So to me, I think the idea that there would be an involvement in the claim, an inflation, if we use that word, although I think it's as too much negativity for it to be useful, is essential, is part of the human rights journey. So human rights, as I said, has always been about habilitating silence voice. It always was that vulnerable, marginalized communities who were discriminated against would access a voice through human rights language and would ask for more, and they should. And that's what it's all about. So in my view, I think the second aspect of this is we know more about the factors that contribute to discrimination as we continue to open doors and open newcomers to actually express themselves and ask and label their injustices in rights. I would also want to debate, I don't think the language of rights is a language of absolutes. Indeed, I think in Canada, we know that it's not, that all rights are being subject to some limitations, whether it's Section 1 in the Charter or some limitations that exist also in the Human Rights Code. So, so to me, it's an opening statement, is the way in which many people will get to be heard, and then compromise happen. You know, most cases get settled out of court. And the reasons why they do is because the legal route is often very cumbersome, very lengthy, and very debilitating for some people. So I'm involved in trying to make that legal route better, not shutting it down. And that's a little bit the point of my discussion here. So let me continue a little bit to say that I continue to think that the failures in to protect socioeconomic rights, to make them aspirational as opposed to real, the same way the civil or political rights have been made real, was a mistake. And it's a mistake that is costing us now, because it is a mistake that actually threatens the very foundation of civil rights and political rights. There's no point in talking about the presumption of innocence when somebody is murdered during an arrest. So you cannot have civil and political rights that continue to be supported if indeed they are going to be threatened by the depth of inequality in our society. So I know that there's only 1 minute left. Let me just conclude that the right debate for me is about how we deal proactively with access to justice, how we litigate effectively with communities to make sure that they have access and they own and continue to push for a better human rights framework. So I'm in a position that when I was in politics, I asked for an improvement to the Human Rights Code to add new grounds of discrimination on social injustice, on social condition, immigration and status, police record, and genetics. And I think that's the way to go. I hope that we continue the discussion.
Thank you very much, Nathalie. Anthony, over to you.
Thank you so much for having me as a part of this rich conversation. And I want to say that I'm thankful to be a part of this conversation, to offer my contributions in thinking through thinking through rights with these esteemed panelists, because of course, based on the work that I've done, I've thought a lot about these issues as it relates to the experiences of people of African descent. And in that reflection, of course, there's a kind of ambivalence when it comes to rights and rights conversations, because often the language of rights has been used historically as a way of situating Black people outside of that which we are entitled to enjoy as human beings. But then, of course, over time, some of the organizing and struggles have been fundamentally rooted in rights claims. So everything from the right to the ballot, right to be seen as human beings, access to education, against rights to be free from racial profiling, racial injustices. And so I note that as a kind of, again, an ambivalence, knowing that it's not, when we talk about rights, it's not something that we should be thinking about it insofar as Black communities concerned as one side or another, but being able to hold those tensions. But one thing that I also think about is the way in which we have to recognize that there is a kind of, there is an actual white supremacist culture that is embedded within rights discourse and rights framing. If we look at where what we often refer to as the modern foundations as contemporary rights, we are talking about white men overwhelmingly making assertions and claims against state power, other white men, and finding ways to what are identified as core rights, leveraging those core rights to advance their claims to a kind of freedom, while at the same time, ironically and obviously, removing the rights from Indigenous people, the human rights from people of African descent, and other people who are not raced as white or don't have that privilege. And so I think we should always be mindful of thinking about that. When we look at sort of the main origins of what we refer to as modern rights and modernity, often there's a reflection on the United States and the movement of Americans to form their own body outside of England, and that was really largely framed in rights discourse. And then we of course talk about France and the Declaration of the Rights of Man, but one of the spaces we rarely talk about is Haiti. Haiti in the 1801 Constitution that was initially written was one of the most powerful and revolutionary documents that undermined that white supremacist framing and grounding for rights, but said insofar as you step on this land, no matter who you are, not just a Black person, you are a free person. You can access and dispose of property freely as long as you are a person who possesses humanity, your conscience being. And I think the fact that so few rights historians, rights thinkers meaningfully take on Haiti and that Haitian constitution and what Haiti represents for the global African diaspora in terms of being the most successful slave revolution that this world has known, modern world has known, I think is telling. It is telling because it speaks to who has the province of rights and who can debate what is at the core of rights. Because if you ask Indigenous and Black people, they would often say, hypothetically, how are you to decide what is at the core of this thing that is central to my humanity that you and yours have been denying for centuries? And so there's an underlying presumption that people of European descent, white, Western, modern world, they own rights. And the language and what will shape the future of rights is largely to be guided and grounded by what is first validated by that original lineage of rights. Now, of course, I recognize that I might say the wretched of the earth using Fanon's language or racialized people, marginalized people, but of course, queer and trans folks living with disabilities have taken on that language of rights and have been able to use it, as I mentioned from the outset, ground claims for greater inequality and greater inclusion and greater advancement and well-being for themselves and their communities. But that has also been often, when you study the histories, that is largely a concession of sorts, because power is such that rights ends up being one of the surest often only meaningful ways that these systems of power, of government, we're talking about policing, border patrol, and different organisms that really control power within our society are responsive to the needs, well-being, voice, and interests of these historically marginalized people. We have our whole state, the Dominion of Canada, built on the disenfranchisement of Indigenous people. And of course, coupled with that is the use of enslaved Black labor to help build up the space. And then the further use of the labor of racialized people through migrant worker programs and different initiatives of the sort, where racialized people have only been granted meaningful access to this space or this stolen land through these cordons of legal rights and human rights. And so it's only been, the pushback has only been strongest when we've been able to leverage and advance the language of rights. And so I would say that for all of us considering this question of rights inflation, we need to be thinking about and starting with the people who've been most denied these things that we refer to as rights, and reconceptualize who has the ultimate power to determine the contours of these rights, and make sure that when we are thinking through and having these conversations, we are not, as this world becomes increasingly inclusive, offending the very people who we often seem to be arguing for or in support of, because Black communities, people of African descent, Indigenous communities will often speak to the ways in which this dialogue has systematically, not in terms of rights, but certainly not just in terms of that, but in terms of the very humanity of these peoples. And so when we're talking about rights inflation, I think ultimately what we should be thinking about is what are the realities of the people who are historically on the margins, and recognizing that rights often, again, is one of the, if not the strongest measures, because if you look at what it actually takes to take up space in the political realm, often there are barriers that have been historically erected. The cost of running a campaign, for instance, the kind of money that it takes is largely contingent on wealth distribution. That is about racial capitalism, white people having money, resources, access, and redistributing it among their own. And so to think that it's going to be those same political spaces that are going to offer this redistributive, these redistributive gains is, I think, not consistent with what we know and understand about our histories. And so when we think about these issues, I think ultimately we should appreciate them, at least from Black perspectives and communities often, as seeing it as an approach that it could be equipped as by any means necessary. And when I say that, I mean it in the sense of, if we look at the limitations that exist in pursuing rights or pursuing the well-being of these people, this is the means that emerges as the most necessary and most viable. Does it mean it's totally emancipatory and it is the salvation of racialized people, Black people? No, but ultimately it emerges in this liberal democratic framing as the most necessary to curtail the injustices that exist in frames of power. Thank you.
Thank you very much, Anthony. Aziza, over to you for the final short presentation.
Dominic, Nathalie, Anthony, and greetings of peace and justice to everyone who is watching and participating in this conversation. I am speaking to you from Toronto, lands of the Anishinaabe, Nashone, Wendat, and Mississauga's peoples. These land acknowledgements are not mere perfunctory performances that we check off before moving on to the quote unquote real substance of the conversation, but rather they are a vital reminder that we are having these conversations about human rights, injustice, violence, and state power on land that is colonized Indigenous land, and that these operations of genocidal dispossession are ongoing in the present, enabled even in some cases by ostensibly liberatory discourses like human rights. For example, Canadian courts up to the Supreme Court have repeatedly refused to recognize Indigenous spiritual connections to land as protected under religious freedom rights, under a colonial concept of religion that was built in order to dispossess people of their lands and that continues to be deployed to enable state and corporate extractivism and depredations of sacred indigenous space. These exclusions and omissions are not accidents or arbitrary, but rather they flow from the colonial genealogy lying behind the very concept of the human institutionalized in colonial modernity, a concept of the human premised, as the eminent Caribbean philosopher Sylvia Wynter and many other decolonial thinkers have pointed out, a concept of the human premised on the exaltation of the figure of the white, Christian, property-owning, colonizing man as the paradigmatic model of the figure of the human who is entitled to bare rights. And so, Canadian courts again and again and again have refused to recognize even the most basic human needs, such as to housing, as a protected human right, even as homeless people in Canada continue to die in the streets. 216 deaths of homeless people just in Toronto in the last year alone, effectively deprived not only of their basic right to life, but even of the very fundamental right to have rights, including civil and political rights at all, the right to meaningfully enjoy any of these rights. Muslims seeking legal redress for the pervasive Islamophobic rights abuses in the quote-unquote war on terror, too, have repeatedly been rebuffed by Canadian legal institutions, even as the quote-unquote war on terror itself rationalizes itself as an exercise in protecting human rights. The continuation of a long colonial civilizing discourse in which extreme acts of violence against those deemed by their colonizers to be barbarians, savages, uncivilized, have been justified as necessary for their civilization. From Canada to Kenya to Jamaica to India to modern day Palestine. Under the terms of human rights, other than human animals, those who bear the brunt of socially sanctioned violence in our society, such that when we say that a human has been dehumanized or treated by an animal, what we mean is that they have been subjected effectively to torture and killing without restraint. Under the terms of human rights, non-human animals are explicitly denied any recourse to rights. As we were brutally reminded just days ago by the decision from a New York court that refused to even entertain the possibility that Happy, an elephant confined under solitary isolation for the last 16 years in the New York Zoo, could have access to the right of habeas corpus, the right to be liberated from illegitimate or unjust confinement, because the court, without reason, deemed that this was a right that was limited to humans alone. Even as we remember that human prisoners too, in America's mass incarceration state, have also been locked up and detained under solitary confinement for years or even decades on end, without any meaningful recourse to courts to protect their rights. There is nothing natural or normal or necessary or inevitable about this state of affairs. It is not the case that there are no historical precedents for building and imagining a world organized differently in traditions that lie outside the scope of the Western canon and gaze. Rather, it is that these other possibilities for a world organized differently have been actively dismantled and erased from our memories and from our imaginations. I am so grateful to colleagues at the Yellowhead Institute, for example, for sharing teachings about Indigenous political and legal theories, which pertain not only to the rights that we may have as humans, but also to those rights that non-human animals and the environment have against us. Teachings that resonate with my understanding of my own tradition, Islam, in which, for example, the right for non-human animals and human animals alike to have water to quench their thirst was a protected right. It is not that there are not other possibilities for a world organized differently, but that these possibilities and precedents have been actively dismantled and erased under colonial modernity. And so I think the relevant question for us to be asking in the relevant issue is not about human rights inflation or constriction, but rather about human rights decolonization. Whether and how we can draw on all of these traditions relegated to the underside of colonial modernity in order to transform our legal, social, and political structures towards a deeper justice, to transcend those colonial limits and dynamics that continue to be reproduced, including through human rights. In this, too, we remember, as always, to invoke the great Black abolitionist, feminist, scholar, activist Angela Davis, that justice, like freedom, is a constant, unceasing struggle, one that continuously exceeds the boundaries of any of our human-created frameworks or discourses to realize it, including that of human rights. Thank you, and I look forward to the discussion.
Thank you so much, everyone, and for your temporal discipline. So we'll move on to the next segment, responses and rebuttable presumptions. So following in the spirit of the Debating Rights Inflation book, as you've seen, the very title and framing of which itself is debated as a descriptor of the phenomena it seeks to describe, we will now provide each panelist an opportunity, 3 minutes each, to respond to their fellow panelists' presentations. And so I think we'll re-loop the circle and return to you, Dominique.
Thank you. So thinking a little bit about Kanji's comments, my concern about rights-based framework is similarly linked to a profound skepticism of seeking social change through the law or the courts, because courts are unelected, because they lack the technical expertise to address complex social problems, because the focus on individual needs inherent in the legal process can come at the cost of the public interest, because of the inappropriateness of the adversarial model for resolving systemic problems, because it derails energy and leadership from other campaigns, because of the danger of empowering judges who can be just as easily impede progress and more. So part of this is a skepticism of the law. Now, we could address some of the problems around this debate if it were possible, I think, to dissociate human rights from the law. And there certainly are examples of framing rights outside the law. The trend is in the opposite direction. A great example is human rights commissions. In the past, commissions were far more diverse than they are today. Kathleen Ruff, for example, the first director of the Human Rights Commission in BC in the 70s, had no formal legal training, yet was one of the most innovative and effective leaders of any commission in the country. Human rights commissions were once staffed and led by a diverse team of journalists, academics, homemakers, tradespeople, business leaders, and more. And given that they're arguably the most important institutions in our society, or among the most for shaping our rights culture, it's interesting that the trend is towards legal expertise and training. I see this, another example would be the Canadian Civil Liberties Association, where Des Rosiers and I used to be involved. This is a group that used to be involved in political activism and a diverse board. Now it's predominantly lawyers that focuses a lot on litigation. So there's a trend towards the law that concerns me. The only other point I'd make is, as my colleagues were speaking, I was thinking about a new book by Jamal Green in the US where he talks about cacophony of rights claims. And he tries to resuscitate rights talk in the US by taking a European style approach. So rather than treat rights as absolutes, as Des Rosiers was talking about, he argues that we should see rights as a basis for compromise. So in other words, the recognition of a right begins a dialogue around the legitimacy of state action. It's a compelling argument, certainly addressed many of the concerns around rights inflation, but it is premised on the notion that there are no moral absolutes. Yet it seems to me that there are some moral absolutes when it comes to rights. States, for example, should never be able to kill their own citizens, whether through death squads or the death penalty. The prohibitions against forced labor and slavery are absolute rights. So I worry that we legitimize hierarchies of rights when they're premised on the belief that rights are open to dialogue or to compromise. It's very much a departure from the ideal of a foundational universal moral principle. And I'll just finish by saying that I do worry about it providing a moral foundation to justify limitations on human rights when we see them as open to compromise. if there's one defining trend around the contemporary history of human rights in Canada, and I was thinking about Morgan's comments in this regard, it's the appropriation of right-wing movements of rights talk to entrench privilege and to increase marginalization. And this is something that needs to be fiercely resisted. Thank you.
Thank you, Nathalie.
Yes, let me respond on two ways. Number one, I think it is appropriate to debate the framing of human rights. It is appropriate to recognize that law is not a panacea and that it will always be just one tool out of many. Part of it, I think, is many organizations should do public education, should build connections with communities, should empower community to argue and debate and be present on the political scene. I think that's useful to do and that it is sometimes crucial, but not to abandon at this stage the role of law in actually helping at times force the issue to be resolved, I think is a mistake. And that's, I think, the way I read the rights inflation, is that it has the potential for saying law is no longer the avenue that you should use. Whereas I think law can be and should be better. It's not a panacea. It doesn't lead to all the good results that we want, but I think, and it can be expanded and it could be molded. There's nothing that prevents us from having new, the animal rights movement, for example, can be part of the evolution of rights base. And I agree that we should debate the origin of rights and be critical toward this. I worry that if we close the door, we're closing the door at a time where new voices are inside or trying to argue for an indigenous vision of constitutionalism, and that's what I worry about. I continue to think that most organizations are not, that lawyers are not the worst people on earth to continue to argue. I think they have a role to play, and that's what they're trying to do, is try to actually advance claims in such a way that indeed it puts the issue on the table. It cannot be ignored. A politician can ignore an issue but once in the legal framework, it can take time, but eventually it will get resolved. You will get an answer. So let me conclude in this. And I think it's a right time for human rights commissions to be more creative and for the human rights system to look at itself and be much more proactive on access to justice, on litigating, and the legal community should be critical of itself, of its role, its arrogance, and so on. But I would not close the door on having legal avenues to redress injustice. I think that will hurt more than it will help.
Thank you very much. And I'll turn it over to Anthony.
Yeah, I really appreciate this this debate. I mean, what it makes me think about is the importance of pushing for a kind of return to the political, structural, and to some degree, the theoretical roots of rights as a tool to protect those vulnerable from power, state power, particularly, but not exclusively. And I think what the challenge with, whether it be right-wing factions or anyone who's co-opted rights or this inflation of rights, often what you're seeing is an engagement with rights in a way that is devoid from historical understandings of who actually has power socially, who has historically had power. And I think one of the challenges that, or one of the frustrations, admittedly, I would say, when I look at the work of human rights commissions or look at decisions that come out of judicial and quasi-judicial bodies on or discussions on human rights, is this dehistoricized understanding that where rights often has its most critical potential and power is where it is moved to equalize and rectify and respond to historical injustices faced by one or more communities. And I think if we are not being conscious of that and taking that lens into that work, then all rights claims look equal. And I think it confuses the notion of human rights, fundamentally confuses the notion of human rights in so many different ways. And I think it does create a space of stalemate and ultimately undermines, I think, the true potential and power of rights, still recognizing the limitations. But again, I would say that those limitations are often about folks coming from historical places of power and co-opting and leveraging rights or pushing back on those who have been historically marginalized and seeing their gains and being like, no, you know what? These gains have gone too far. Here's how we are going to evoke the same language, we're going to evoke the same power and ultimately use it to remove this particular power from historically marginalized groups. And what I'm speaking in general terms, but if you think very specifically about the way in which voting rights in the United States emerged, you talk about the 1960s, Black communities get that and then fast forward, recognizing that I don't have a lot of time, that one of the strongest movements in the United States now is about disenfranchisement or responding to disenfranchisement. Now, that's not being led under the language of human rights, but there's this elevation of states' rights often in a way that confuses those rights with human rights. And it leverages this kind of rhetoric, leverages this rhetoric in a way that confuses what rights actually are. And so again, I refer to that as a way in which those coming from spaces of power often co-opt and colonize and recenter what rights are to suppress and diminish and push back and effectively kick away the ladder that many oppressed, marginalized communities have found in human rights traditions.
Thank you, Aziza.
I think that so much of this debate starts from a problematic premise that rights are being inflated from a predetermined core, that Indigenous people, Black people, racialized people are new entrants into this discourse, infringing on the legitimate core of human rights. We are not new participants. We have always been there. We have had our traditions. And the issue is that the colonial modern institutionalization of human rights, this falsely universalized Eurocentrism, was built upon the erasure and the dismantling and the marginalization of these other traditions. And so these aren't new concepts or new entrants into the canon of what is considered just ways of organizing our relationships with each other and the world. Rather, they are just those that have been rendered invisible in the service of the projection of a universalized, of a colonial project that projects its vision of the world and justice as being universal. As Dominique pointed out, so much of the way that law has been institutionalized is premised on a liberal capitalist society that necessarily generates and depends upon homelessness and production of poverty. And so instead of reifying and doubling down on the core concept of rights that is associated with that economic order, surely the solution is not to double down on that, but to assault it at every opportunity and work towards its deconstruction and towards a vision of economic justice. The question then is not whether rights are being inflated in this struggle, but whether any particular claim of rights is advancing that struggle towards justice, which transcends the realm of law, but cannot avoid engaging it. For example, Dominique, in the book, you gave as an example of rights inflation, not necessarily a negative example, but an example of rights inflation, the Human Rights Tribunal granting a damages award to migrant workers who were sexually abused and harassed by their employer. In that situation, I don't think we can fairly call that a situation of rights inflation, because those very protections are still denied so many migrant workers, the vast majority of migrant workers who under the temporary migrant worker system are vulnerable to deportation for launching a complaint against their employer. to whom their employment and their ability to remain in Canada is tied. And so there, the issue is not the Human Rights Commission granting damages to migrant workers in an inflated concept of human rights. Rather, it's the underlying capitalist exploitation, the model that depends on the exploitability and vulnerability of foreign migrant workers to sustain the economy, that excludes so many from justice in the first place. So the question then is not rights inflation, it's to ask, is this particular expansion of or recognition of rights to those who have been systematically denied it before, is it helping to advance our struggle towards the deconstruction of this inherently exploitative system? Law is, of course, not a solution. It's not a panacea, but it is itself part of the terrain of struggle. And it is one that we cannot afford to cede by conceding to the idea that merely a small core of rights that were primarily oriented around protecting the interests of those who were exalted as fully human under colonial modernity, to cede that ground to continue to prioritize their interests and claims.
Thank you very much, Aziza, and all panelists. I will use the next segment of time, 13 minutes, to pose questions to you, and anyone from among the panelists may respond as they see fit, and may also pose questions as well to each other. I think I see I'm monitoring the Q&A because we'll conclude with entertaining some of those questions in the Q&A function, and there's quite a few questions, particularly for you, Dominique. And you know, I know part of this debate, a significant part of the debate, is about how we think about the history and evolution of rights. And you know, the idea of rights inflation is sort of one framing of that history, at least since the 1970s. But I'd be interested in how others understand the history and evolution of human rights, and how you think the human rights landscape, whether the nature of human rights claims and issues or the instruments by which to take those up, has changed over your respective lifetimes. I won't ask you to all go 60 years back, because you don't all have 60 years of life behind you. And perhaps, Anthony, you've spoken a lot about providing sort of an alternative understanding and framing of the history and evolution and trajectory of human rights, if you would like to address that issue.
Yeah, I think policing and like rights of an individual vis-a-vis the state in that particular context, when thinking about Black communities, it would be a striking one for us. I've written about this, but I also was echoing the tradition of many organizers and activists from Black communities and who supported Black communities, who've noted that many of the gains as it relates to resisting racial profiling, unlawful search and seizure, right to a lawyer, often within the Ontario context especially, you find that it was through the violation of Black people's rights. And it's the organizing, the social movements of Black people, well, perhaps most popularized through the Black Action Defense Committee. And before that, it was the Albert Johnson Committee in the late 70s through the 80s. And so the recent report that emerged last week shows that there's still a considerable gap between the entitlements and rights of people of African descent and other racialized people and Indigenous people within Toronto. But that does not deny the fact that we are having different conversations around racial profiling, around carding, around street checks, around what the rights of an individual are when they come face to face with state power in the form of police. And so I'm especially alive to this, not just because of the work that I do, but also as a Black man raising a Black child in this society. So there are conversations and ways in which that I can move, and I would hope my child can move, that I know for certain my parents couldn't move with the kind of freedom and certainty that they would be as easily violated. Not to say they don't happen. Again, the report that emerged last week shows that violations are there, but even in my young years, I think there's many things to take serious when we look at police oversight, addressing racial profiling and the very conversations we're having around the rights of Black people to be free and equal to walk around in their communities.
Thank you, Anthony. Aziza, I wonder if you are observing, the communities you serve increasingly engaging or having confidence in the human rights system as a tool to address various forms of discrimination, or rather, is there a certain disenchantment setting in? Any thoughts to share in that respect in your own advocacy efforts?
I don't know if it can be characterized as either confidence or disenchantment totally, because the issue is that paradoxes are built into the concept of human rights. They can be used in a liberatory way, but they can also be used and have been used and very powerfully used and continue to be used as instruments of colonial and state power. So looking to the origins of human rights again, we know that the first documents on human rights in the 1940s were promulgated at a time when most of the world was colonized, that the reference to human rights in the UN Charter was introduced by one of the architects of South African apartheid, and that these paradoxes and oxymorons continue to pervade human rights discourse, so that we have, for instance, someone elevated as a figure of Canadian human rights, Erwin Kotler, having a speaking engagement at an illegal settlement on occupied Palestinian land against Canada's own official foreign policy. And so it's not a question of us having faith or confidence in the human rights system as it is and as it exists now, because we know that anything that we can use as a tool for our liberation can also be used as a weapon and as an instrument for our continuing dispossession and disenfranchisement. There is nothing that is not co-optable as a tool and an instrument and a weapon of power, whether it be the language of abolition, which European colonial states used to justify their scramble for Africa as a supposed exercise in eradicating slave trade, trade in enslaved people within Africa, to the language of systemic racism, which we've seen police forces in Canada very cynically using in order to deflect from the question of individual accountability and responsibility of police officers, as in the Toronto Police Force's response to the report on the endemic pervasive racism in Toronto police forces, something that was always already known by the communities most subject to the brunt of their force, and yet which somehow perpetually needs data to prove. So the language of systemic racism, also we know used by the Trudeau federal government in order to try and fend off the claims for reparations that were owed to Indigenous children, determined by the Canadian Human Rights Tribunal regarding their discriminatory funding of services for Indigenous children. And that too, the federal government tried to use the language of systemic racism to say that individual reparations and damages aren't the solution to what is a systemic problem. So there is nothing that is not co-optable as an instrument of power, whether it be the language of systemic racism or the language of human rights. The whole question is how we use it, how we organize, how we build our power in order to bring into the being the type of world that we know has existed in the past in contexts and histories outside and beyond colonization, and the type of world that we know can exist again in the future.
Thank you, Aziza. Natalie, you've functioned both in the political and legal spheres, and I think based on that unique experience, have a good sense of the strengths and limitations of those two different fora for advancing social justice claims. I wonder if you could offer any comment on precisely that, the strengths and weaknesses of using law to advance social justice, or using the political process to advance social justice, because you've engaged in both fronts.
Well, both systems need improvement and need to be more responsive to inequality, to the deep-seated inequality. I agree that systems can be co-opted, and they can certainly be used by the powerful to increase their power. And this would be the same in both systems. Therefore, it is incumbent on systems to self-reflect. I think the political system must be used and must continue to be assessed for the way in which it distorts voices at times. Not everybody has the right to vote, as has been pointed out in the chat here, and I agree myself that, and that's one of the reasons why I went into politics, was about expanding the franchise to permanent residents. So that's on the political side, and on the legal side, I agree. It's a complex tool. It certainly does not lead to good results. It can be used by people to oppress others. Nevertheless, it's there, and therefore my claim is that they should be used and criticized within their framework. So the legal system could be criticized for not delivering on social justice, for not delivering on socioeconomic rights. And we should all, as the legal community, reflect on the legacy of that are polluting our jurisprudence, and be more creative and more inventive, more responsive to the current injustices that are felt, that are used, and the stories that need to be told. So I started my career in trying to improve the ability of the legal systems to respond to survivors of childhood abuse that could not even get in to talk about their stories. Eventually, it got changed. They were able to access the courts. Now, was it a panacea? No, some cases were terrible. Other people felt validation and not. So it's just a tool that needs to be improved constantly. So I would say that they each have their own logic, and it's important that they both be more accountable for what they do. And I think that's the job of different communities, to continue to demand more of both of these systems.
Thank you. Dominique, you've introduced this distinction between human rights claims and social justice. How do you think these do or should differ, if at all, and why? And how would you distinguish between grievances, as you term them, that warrant framing as a human rights violation, versus those that are more appropriately situated as or framed as a social justice matter? How do you distinguish and draw those lines?
Yeah, it is something that I struggle with. In the original book, I talked about the concept of core rights, and I used an historical approach to try to suggest maybe there are some core basic rights. I struggle with this, and even hearing comments from colleagues on the panel certainly challenges me and makes me think about how we would create these distinctions. Even on the one hand, even people who are critical of the rights inflation argument do acknowledge that rights are best realized in a representative democracy, and that most representative democracies do require certain basic fundamental rights. So that's led me to think about of human rights as those basic rights that make a dialogue possible, and then think of social justice as our vision for a true social change, and a vision for systemic social change. So I started to think of human rights as the basic rights that we need to ensure that we can have a functioning dialogue, and then social justice being how do we compromise as a society in finding ways to address systemic inequalities. But one thing I do keep coming back down to, as I struggle with this idea of benefits of a rights framework versus not, whether or not inflation is the best way to frame it, whether or not social justice is the best alternative, I always come back to the belief, though, that human rights just has never struck me as a very transformative ideology. It became popularized, arguably, because it didn't require a lot of us. We think about how religion or ideology like communism envisions profound systemic social change. human rights is more about individual rights and about equality. And so it was arguably popular because it didn't demand a whole lot of us. And so as I struggle with the issues, and I agree with a lot of what's been said today, for me, I think about the distinction between human rights as the basis for a dialogue and then social justice being how we achieve profound social change. Whether or not that's the best way of thinking about it, I struggle with it, but I do see limitations with human rights in mobilizing people for a genuine systemic social change.
Thank you. And if anyone wants to respond, I saw some eyebrows raised there. And certainly, I think it's been raised by the panelists that the House of Human Rights as individual rights is a very white liberal house, or as it's being constructed. And so how would you respond, Dominic, to the argument that in fact you are reifying the core rights as that you deem necessary in a democratic society, precisely as those rights as envisioned by white British settlers drawing on a civil liberty tradition?
Yeah, I'd respond by, it's not exactly what Morgan and Kenji were saying, but it does build a little bit on their thoughts. When you were asking earlier about how you think things have changed over time, it strikes me one of the most important developments in the history of human rights for the past 3 generations has been the effective appropriation by especially right-wing groups, but certainly people with privilege, of rights discourse. That's not as old as you may think. People have always debated what free speech means, to be sure, but the way in which conservative governments today frame tough on crime stances as a victim's bill of rights, opposition to or hate speech against minorities becomes about right to free speech. Military intervention abroad becomes about protecting democratic rights. The debate in Canada right now over religion, or Quebec, sorry, over religious symbols is filled with justifications for protecting women's rights. And so they become so effective in appropriating this discourse. To be sure, I might be guilty of reifying a certain list of rights. And I think it's more of a dialogue than actually setting a list that we all have to agree on. But I think it should be also concerning to note how effective rights is now increasingly being used by those who would actually seek to marginalize and entrench privilege.
Thank you.
Remi,
Yes.
can I say something?
Yes. And we're down to our last few minutes. And so I'm also going to pose some questions from the audience, but yes, please.
Which is that I think from a deeper historical perspective, this current use of conservative and right-wing governments of rights language and civil liberties language looks less like an appropriation than a continuation of a very dominant strain in the way that concepts of rights, freedoms, liberties have been developed. The philosopher Charles Mills, for example, elucidated in his work on the racial contract, the deep racial contract that has been embedded in much liberal philosophical thinking on rights and entitlements, in which freedom and rights for white people have been premised on the domination and dispossession of racialized people whose subjugation is the very precondition for the conceptualization and realization of those rights. Historian Tyler Stovall has a recent book called White Freedom, looking at the long history of colonial and enslavement projects using the language of freedom to advance their aims. For example, American slaveholders, in response to abolitionist efforts, depicted themselves as being enslaved and impermissibly denied of their freedom by being denied the right, the quote unquote right, to enslave others. And so this contemporary iteration, I don't think it's an appropriation, it's simply a reflection of the fact that rights, like any discourse of power, encode the dynamics of domination that are pervasive in the societal structure that gives rise to it. And that's what it's our job to deconstruct and disentangle.
If I could piggyback off those insightful comments, is I think where this becomes most obvious in the conversation, where Black Lives Matter versus All Lives Matter, and more perverse, Blue Lives Matter. So you go from this basic right to life that Black people are seeking to assert and their allies are seeking to assert, and then it gets massively co-opted and reframed and reformed to police officers as police officers seeking to assert their right to, when we look at it, operate often with impunity and not be held accountable for when they harm the lives of folks. And so if you look at rights struggles, you see that continued co-optation or recolonization of these systems of power to diminish and dismiss the lives and well-being and the rights claims of historically marginalized people.
I think, thank you very much. To bring it closer to a conclusion and reading some of the questions, I think, some of the questions relate to what does all of this mean for the code, right? It's a bit of an abstract debate, possibly, and concretely, what does this changing human rights landscape that you're variously assessing and evaluating, what does it mean for the Human Rights Code, and how do you think the human rights, let's say the Ontario Human Rights Code and related policy needs to evolve in response to the changing human rights landscape? And I'll leave this one open to all of you to provide some comments, bringing us full circle back to the code and implications for the code of the changing human rights landscape. Anyone like to go, Natalie?
Well, I think the human rights work is always in contested terrain, and this debate is about the contestation even of the continued existence or the ambition of the Human Rights Commission. So I'm not surprised that it's happening, that there is a debate about whether or not they should continue to exist as they are, whether the language that is used is appropriate and so on. But if you're in it and if it exists, then I would say it's particularly important to be more accountable, to have Human Rights Commission and human rights work being accountable to the communities that they seek to. There's a great saying, you can't, if you're doing it on behalf of the poor, it will come back and haunt them, So I think you have to just be much more accountable to communities. I believe in data, and I thought that, I think the more there is studies about the work that's being done, how it's being done, how it can be improved, and how it can be more responsive. My sense would be, I took some notes as well, that in a way on the funding model, we could try to move away from having a Human Rights Commission or human rights work or that is constantly asking for money, to embed it in the budget. That every time there's an increase in one service budget, a 3% increase, it has to have a 3% increase in the accountability framework, whether it's Ombudsman, Human Rights Commission, and so on, so that it's not debatable. The more services, the more racism there will exist, the more we need an accountability framework. So that's one way of trying to move away from this sort of piecemeal negotiation to really recognize the importance of a formal accountability around much of the work that's being done by different services of government.
I might just add quickly too, one of the human rights commissions and the statutes haven't actually changed all that much really since they were created in the 60s and 70s, with some notable exceptions. But one thing that has changed dramatically is profound underfunding for the commissions, especially since the 1990s. And just to echo something that was mentioned in a previous session, what we really need is more resource to focus on education. They were originally designed with education being a priority for these institutions, and that dealing with cases was never supposed to be the primary focus. And yet, for reasons of necessity, that is what has happened. So that's something that could profoundly make a big difference, would be those resources for education, which was the original mandate.
Okay, well,
I want to offer quickly. I think one of the things that is sadly very characteristically Canadian is a historical amnesia as it relates to Canada's truest treatment of Indigenous and Black people, most especially with Black communities. So what does this mean for commissions? I think commissions need to commit to a recentering and prioritizing a deep, rich understanding of those racialized injustices, the histories of slavery, segregation, and marginalization, and recognize that the issues that come before them are the legacy of those things. So that's not history. You're seeing the tip of history come before you. And I think if that interpretive frame is not an active commitment of human rights commissions and the lawyers that support them, they will look at a claim of a white person being called a name by a Black person and be like, well, this is terrible. You shouldn't, because it's the absence, it's devoid of a historical understanding. Not to say that that's okay, that kind of thing, but the point is to really get at what human rights, unpack the emancipatory potential, is to truly understand the histories and the legacies of those historic injustices and apply that to the work actively.
Thank you.
Can I
yes,
say
sorry,
one final, very quickly,
yes,
which is, I think that the systematic misrecognition or unrecognition of Islamophobia by the Human Rights Commission and other bodies is highly diagnostic. Anti-Muslim racism is reduced to a question of hate crimes or interpersonal violence, obscuring the systemic racism of the quote unquote war on terror, which is built on centuries-long colonial foundations and continues to also be used to enforce the colonial project against Indigenous peoples. Perhaps it would be oxymoronic for an institution premised on state sovereignty that depends currently on erasure of Indigenous peoples to recognize this deep matrix of colonial racism, but to the extent that it can't, it continues to serve as a tool of obfuscation.
Okay, well, thank you so much to our panelists and audience for engaging in this critical dialogue as we reimagine the future of human rights. As this debate on what, properly speaking, belongs within the genre of human rights, if we say, will no doubt need to be considered and revisited in any future effort to have the code better address entrenched colonial and systemic forms of discrimination. So thank you, everyone. Bye for now. And I'll hand it back over to Toni. Thank you, Toni.
This was honestly, I'm reeling from this conversation, the depth, the courage of your convictions, your ability to self-critique and critique a system that's meant to protect us, but that has also been used to further oppress the very people that it was supposed to protect. Thank you for your thoughts and your ideas. I have so much more to say, but I won't, because I also think there must be rest in this orb. And I need 3.5 months. I'm going to watch this again on the recording just to catch all of the things that I know, the nuance of what you all have offered, that I know I have missed some of it. So I want to give folks a little bit of a break. We need a 5-minute break, and we're going to start again we'll give you 5 minutes and we'll start again with the final panel of the day. Thank you so much, all of you. Thank you, Remi, for moderating.
Thank you.
All right. I hope that 5 minutes was enough to breathe and maybe stand up. That's my guess, or just move yourself around if you're able. We are back now for the final panel of the day. This panel, I think, was the nexus and the heart of what we hoped to examine today, which is decolonization in terms of the future of human rights. So all of this has kind of led up to this cumulative theme of decolonization and examining our history and its relation to human rights. What we'll look at in this panel is an examination of what is actually required to decolonize the human rights system to better advance systemic substantive equality. And we'll look at it specifically in the lens of how it impacts Indigenous people. So moderating this session is Professor Karen Drake, who serves as a member of the Wabagon Lake Ojibwe Nation, and who serves also as the Associate Dean of Students and as an assistant professor at Osgoode Hall Law School. Professor Drake researches and teaches in the areas of Canadian law as it affects Indigenous people, Anishinaabe constitutionalism, property law, and dispute resolution, including civil procedure and Indigenous dispute resolution. She has a very wide background. She's a member of the Legal Advisory Panel for Raven, and she previously served as the Commissioner of the Ontario Human Rights Commission, on the Board of Directors of the Indigenous Bar Association, and on the Board of Directors for the Human Rights Legal Support Center. Over to you, Karen.
Wonderful. Thank you so much. So, Ani, bonjour, good afternoon, everyone. My name is Karen Drake, and it is my pleasure to serve as your moderator for this panel. So our plan for this panel is to have a kind of Q&A session with our panelists. Once we've done that, we're going to have time to open it up to audience questions. I'm going to start with a very brief introduction of each of our panelists. And for more information about their bios, I encourage you to take a look at their bios online. First, we have Brenda Gunn, who is Métis and a professor at the University of Manitoba's Faculty of Law. She is also the academic and research director of the National Center for Truth and Reconciliation. Professor Gunn's work combines academic research with activism, pushing for greater recognition of Indigenous people's inherent rights as determined by their own legal traditions. Her work is, in my view, extremely impressive. It's both local, including work with Manitoba First Nations, and also international, including work with the United Nations Expert Mechanism on the Rights of Indigenous Peoples. Thanks so much for being with us, Brenda. Next, we have Professor Erin Mills, who is Anishinaabe from Couchiching First Nation in the Treaty 3 relationship. Professor Mills is an assistant professor, and he holds a Canada Research Chair in Indigenous Constitutionalism and Philosophy with McGill University's Faculty of Law. His work focuses on learning about Anishinaabe law and community on the land through stories and guided by elders. He is a community engaged scholar who is frequently consulted by Indigenous individuals, communities, and organizations. He served on the board of directors of Aboriginal Legal Services and on the board of directors of the Indigenous Bar Association. He currently sits on the advisory circle for the First Peoples Justice Center of Montreal. Welcome and thanks for being with us, Professor Mills. Finally, we have Keith Smith. He's a member of the Thessalon First Nation. He is Director General of the United Nations Declaration on the Rights of Indigenous Peoples Act Implementation Secretariat with Canada's Department of Justice. He was previously at the Canadian Human Rights Commission in the role of Director General of the Policy and Communications Branch. Before that, he served as the Director of Policy and Acting Chief of Staff for the Minister of Justice and Attorney General of Canada. He has also served as the Director of Policy, Research, and International at the Canadian Human Rights Commission. Welcome so much and thank you for being with us, Keith. Okay, so our first question gets to the heart of the topic of this panel. So why does the human rights system need to be decolonized? In other words, what is it about human rights and about the human rights system that requires decolonization? So Erin, I'd like to call on you first to answer this question.
Bonjour, and Dinaway Mognitok. Hello, my dear relatives. I'm very delighted to sit with you today and grateful to Karen and others for organizing this event. I hope to learn a fair bit from the other speakers. I wanted to start by saying Nindibwe. So what I'm going to share with you today is just the truth as I understand it. It's an awkward way of speaking, to be hedging every comment. So I like to just say that up front so no one takes me as speaking in too strong a way. So for me, it's helpful in thinking through this first question if we sort of separate the Indigenous people's experience of oppression into two registers. So I'll talk about them each in turn. And the first one, I think most of us are pretty familiar with, and that's undue exclusion, just in the way that oppressed minorities of all different types experience. So the starting point is we begin with an understanding of human dignity that centers on individual autonomy. That is, an individual's freedom to choose their own goals and to pursue those goals to the extent that realizing them is consistent with the freedom of others to pursue their own goals. Discrimination in all of its forms constitutes an interference with these freedoms. And what's really interesting is what oppression in this register assumes about justice. So when oppression occurs, justice demands that individuals be returned to a position of autonomy, that is, of choosing and of acting for themselves to the maximum extent possible. In identifying protected grounds, that's precisely what human rights law tries to do. This assumption is categorical, and so the response holds for all subject positions, for all humans. That is, it has a universal application. Human rights debates are ordinarily framed by the purpose of a return to individual autonomy. So the debates arising then typically regard what effect this return to autonomy, how to give effect to it. So for instance, the classic debate between formal and substantive equality. Well, in my view, on this register of oppression, I think human rights regimes and the OHRC is doing really well in addressing the suppression of undue exclusion, and in fact has much to be proud of. We have to fudge it a little bit. We tend to treat indigeneity as a kind of race and not as an independent ground of oppression. But given this allowance, I think the framework works and more is important. But there's a second register of oppression that Indigenous peoples experience, which perhaps with some irony is forced inclusion. And as everyone will predict, this has to do with our reality of colonialism, and in particular, what we call internal or increasingly today settler colonialism, that kind of colonialism where Indigenous peoples' lands and jurisdiction are taken over under the sovereignty of some colonizing body, and we live with them. So prior to that process, Indigenous peoples had vibrant systems of law and of governance, and they still continue today, although often not vibrant, badly damaged through the colonial process. Those systems were never legitimately superseded. So to the extent that Indigenous peoples are made subjects of newcomer sovereignty, we experience oppression. And we typically hear this claim given voice through the language of a denial of self-determination. Well, within our own systems of law, the very nature of dignity, and so the relevant tensions and the debates we have about our deepest interests are different. And to begin to understand what that means, I want to start with just a subtle point of worldview very briefly, and it's this. For all the Indigenous elders I've had the privilege of sitting with, creation, or if you prefer, the living earth, is a contingent, not a certain fact. It could all come undone tomorrow. What keeps it spinning is the reality that everyone remembers to give their gift. So for instance, the sun rises every day, the moon does its work with the tides, animals all fill their roles, etc. And the way we do this, that creation spins on, it consists in the exchange of gifts and needs. That's what keeps life spinning. We're a part of that exchange. Humans matter to all of creation. Indigenous law recognizes this fact. And I would go so far as to say that the largest part of most systems of Indigenous law are actually about structuring expectations around gift exchange. Well, against this very brief background, dignity is the capacity to participate in creation's unfolding. And practically speaking, that means participating in gift exchanged. That's what has to be unpacked, respected, protected, and promoted. So a few points just to make about that before I wrap this first answer up. It isn't just humans who carry gifts, right, to keep creation moving. So from this second register of oppression, there's a problem with human in human rights. We would have a much more expansive view of other kinds of beings in creation. And second, the idea of a gift is to be construed very broadly. We're not just talking about the exchange of material goods, as we might think of with presents, for instance, but labor, good feelings, anything that contributes to the wellness of the recipient, we would think of as a gift. And so law that is meant to reflect this reality doesn't take the form of clear legal propositions. It takes the form of what we call teachings, which are inherently relational. And we have to work with the earth or the elder or the legend or whatever it is that holds that normative content to bring life to it. So this is to say, there's also a problem within this framework with the idea of rights. We would more typically think of gifts and needs as responsibilities we carry, not claims that we make on others. So I would say that the human rights system needs to be decolonized insofar as it hasn't really taken seriously yet this second register of oppression of forced inclusion. And I would say that the interests we strive to capture with humans and with rights are universal, but with respect, again, to the second register of oppression, forced inclusion, for Indigenous peoples, we need to be much more aware there are other ways those interests might be protected and promoted, and we can look to Indigenous law for that task.
Wonderful. Thank you so much, Aaron. I've heard you speak on this topic many times and over a number of years, but I feel like every time I understand it with a slightly different nuance. So thank you so much. Brenda, I want to give you a chance to jump in on this question as well. So why does the human rights system need to be decolonized?
Thanks, Karen. And thank you, Aaron, for starting us off with such a lovely tone to the comments. And I just want to start by acknowledging that I'm here on Treaty 1 territory in the homeland of the Red River Métis, and my office in the National Center for Truth and Reconciliation. And you know what, today I actually have maybe a cheeky response to this question, and I'm sorry for it, but I kind of want to say, let's also recognize the steps that and the impacts that Indigenous peoples have already had, at least at the international human rights level. And I wanted to sort of just shake up this premise that it needs to be decolonized, in that I want to say we need to continue on this journey. So when I look at the UN Declaration on the Rights of Indigenous Peoples, or I look at the American Declaration on the Rights of Indigenous Peoples, I think you can really see how Indigenous peoples, in searching for avenues to address the challenges they've experienced through various colonial projects, saw the international human rights venues as a place to gain support and to advocate for themselves. And so over the course of, Willie Littlechild will talk about, the 1970s when he first started going. So that's sort of often my starting point, but we know Indigenous peoples went earlier. But, we went from having sort of NGO recognition and sort of being very challenged in how to get into, by 2000s, having multiple mechanisms that look specifically at Indigenous people's rights, and that have really responded to how we have articulated things. And so when you look at the UN Declaration as an example, I think you can see how Indigenous peoples have been impacting international human rights and pushing how the international world understands human rights. And you can see that in the terms, the fact that the UN Declaration recognizes collective rights of peoples in a way that no other international human rights instrument had done. In part because even where you see recognition of self-determination in the International Covenant on Civil and Political Rights, I was trying not to speak in abbreviations there, and the International Covenant on Economic, Social, and Cultural Rights, you can, that wasn't sort of, it was self-determination, but then everything, thing was really about individual rights. Where when you look at the UN Declaration, including the preamble, there's a couple of really key factors. It focuses on the rights of the peoples, and it focuses from our own understanding. Yes, it uses the language that was familiar to UN nation states. It uses the rights language, but it really at every turning point turns it back to us and our own institutions, our own laws, and is really about creating space in that international human rights arena to respond to our needs. So I think that Indigenous peoples, through decades of advocacy, have really had a significant impact on the United Nations, for example, in a way that you haven't seen elsewhere. So I think we need to continue, and Erin did a phenomenal job of identifying that we still have significant barriers to overcome. Like there are nation states have to keep moving, and the people who work in international human rights, my sort of more, I don't do a lot of domestic human rights, but that international framework, we still have a ways to go, but we've taken significant steps. And, I even think when you look at the American Declaration, there's not as much attention to the American Declaration, but we're going to work on that, right, Keith? We're going to keep expanding your mandate a little bit to include the American Declaration. But there's specific reference to the obligation of states to implement the spirit and intent of treaties. Now, that's what is meant to be included in the UN Declaration, but it's explicit now. So imagine an international human rights instrument recognizing the spirit and intent of treaties, right? So maybe I'm feeling congratulatory and celebratory during this week of the year, but I really wanted to acknowledge and recognize that it was hard work. The people that have been there for 40 years have, like, blood, sweat, and tears have pushed, because it's not like the nation states were like, oh, great idea, let's go with it, right? It was persistence, and it continues. It's relentless work. So I just thought I would say those few words to start us off. Thank you.
Great. Thank you so much, Brenda. And we're incredibly fortunate to have you on the panel to be able to share your extensive experience on the international stage with the United Nations. Thank you so much. So Keith, I want to give you a chance to jump in on this question as well. So what are your thoughts on why do human rights and the human rights system, why do they need to be decolonized?
Thank you, Karen. And it really is a pleasure to be here with my esteemed colleagues. And I promise everyone we did not practice, but you will see that some of our remarks today will overlap considerably, of course. And I think we share some common values in terms of our discussion today that's going to take place, of course. And I'd like to acknowledge that I'm speaking to you today from the traditional territory of the Algonquin Anishinaabe people. And again, very nice to be here. So I'll just mention, of course, that we all know very well that the path to decolonization is very difficult. And of course, we must atone for the injustices that Indigenous peoples in Canada have endured. And we know that change can be difficult, and dismantling systems, dismantling institutions that have existed for decades will be incredibly hard. But I think, as the saying goes, if you're not uncomfortable, you're not doing your work. And so for many organizations and institutions, the changes that are required are not even on their radar. And so I think it's incredibly important that we all reach out to work with Indigenous peoples, ask them what their needs are and how they want to play a role in that decolonization and that restructuring. I think there's currently will to see change implemented, And I think this is a really critical time where we can actually see things done. But we all know that it's going to take work at all levels of government, at institutions across the country. But I think discussions like today's discussions are incredibly valuable opportunities for us to find sort of practical ways to remove the colonial influences on our institutions and move more towards a culture of human rights, including Indigenous human rights, of course. So just on the specific question, I think like all colonial institutions, they weren't necessarily built to support and respond to Indigenous people's needs, of course. And so the concept of what human rights differs, it's true, amongst societies, cultures, individuals, collectives, and I would say even within Indigenous communities themselves. So one system naturally doesn't necessarily serve all. And so why this needs to be addressed is because we have institutions that inadvertently or deliberately do not acknowledge Indigenous peoples as collectives or individuals as equals really within society. And this is, of course, is incredibly harmful. We also know that, and Aaron spoke to this, but colonialism has perpetuated a power imbalance that leaves a segment of people without really fair access to recourse. And so when people are seen as less, it is difficult to change perceptions, and these perceptions unknowingly disenfranchise Indigenous peoples. And I would finally point out, this is not the first time that these issues have been debated or discussed, of course, but changes to address human rights violations within broader systems have been outlined in many incredibly important and significant reports. They're outlined in the Truth and Reconciliation's calls to action, the MMIWG's calls to justice, as well as Joyce's principles. Joyce's principle that calls for the right of equitable access without any discrimination. And, I will talk more throughout today's discussion on the fundamental role of equality and non-discrimination as part of our approach to decolonizing. But certainly we need to address all of these issues without discrimination when it comes to social and health services, as well as the right to enjoy the best possible physical, mental, emotional, and spiritual health. And I'll just leave it there. Thanks.
Wonderful. Thank you so much, Keith. Okay, so that brings us to our second question. So now let's turn to thinking about what is the starting point for decolonizing human rights? What's our inroad into this project? And the reason why I think it'll be helpful for us to talk about this is that some of us in our experience speaking about these issues have found that people in the audience when we're speaking about these topics often find the discussion perhaps overwhelming or perhaps overly theoretical. So people often want to know, what are some practical steps we can take? What can we do as a society or as an institution or even as individuals to start to decolonize human rights? So Keith, we ended with you, but we're going to start with you on this one. So back to you. What are your thoughts?
Yeah, no, happy to speak to this question, of course. And, I have for years worked on Indigenous rights issues, on human rights issues at the Canadian Human Rights Commission. Now I'm at the Department of Justice. I've done a lot of work on international human rights as well. So like just an incredibly complex question, of course. And I would say that decolonizing human rights, I think, requires us to look at why we actually have them in the first place. And I would say in the West, we have a really personal approach to human rights. But in many cases, Indigenous people see human rights through different lenses. So there's collective rights versus individual rights. There's rights as viewed through relationships to the land, of course, or through the perspectives of the medicine wheel, for example. So we already see that this very issue of interacting systems plays out in our courts and in our laws, of course. And I will mention that, of course, I did just most recently work at the Canadian Human Rights Commission, but I was around since about 2013. So I'm very familiar with the repeal of Section 67 of the Canadian Human Rights Act, of course, right? And so, as people likely know, we have a human rights audience that we're speaking to today. First, the Indian Act was previously exempted from the application of the Canadian Human Rights Act. And now that it's gone, it applies to it applies to the Indian Act and to band councils, along with their programs and services, and to employment on reserve, of course. And so this has opened up, I would suggest, Indigenous structures to human rights challenges that didn't previously exist. And so I would ask folks in the audience, how do we let these conflicting systems work together without undermining each other? That's a fundamental question, I think. And I think, the repeal of Section 67, as we all know, had some very positive results. The First Nations Child and Family Services case, of course, has resulted in, I'm hoping, will result in very much systemic change in terms of inequitable funding and addressing it. But there are systems still that exist that are competing. And I do know that a number of First Nations leaders were opposed to the repeal of Section 67. And I think I can say that that was because it didn't reflect or respond to the right to self-determination within that context. And so we do have to have broader discussions about how Indigenous nations implement structures for addressing discrimination within their respective governments and nations themselves. So yeah, how do you let these conflicting systems work together? And I would say that a significant part of decolonizing human rights, again, will involve listening to Indigenous peoples, really trying to understand how their perspectives demand a different approach to human rights in many cases. And so this kind of listening, understanding exercise, I think will also ensure that human rights serve both Indigenous nations and their communities, those communities that have inherent rights. But I'm so glad that Brenda spoke to this, because I have been working on the UN Declaration for a very long time, and I'm very proud to be working on its implementation in my current capacity. But I do think the UN Declaration could provide the start of a roadmap for the way forward. So I would suggest in the Declaration Act, the Federal Declaration Act, it includes both monitoring and oversight components. And I think those could provide opportunities to hear from First Nations, Inuit, Métis, about how institutions can be designed through the lens of their traditions and practices and laws. And I do know that we will be, I know very well that we will be undertaking a very intensive, inclusive engagement process. And, the point of the engagement is for Indigenous peoples to identify their priorities for an action plan to achieve the objectives of the Declaration. And so when it comes to monitoring and oversight and recourse, the perspectives of Indigenous peoples will be at the center of the engagement work that we're going to undertake. So, I think it offers a really wonderful opportunity to hear the perspectives of Indigenous peoples in terms of their priorities for how you close that divide around oversight, if you will. So I think, I think it's relatively fair to say that institutions that protect human rights are predominantly dominated by non-Indigenous interests. And so they haven't always been very responsive to the needs of Indigenous peoples in the past. And, I think, I certainly had discussions with my Indigenous colleagues around this issue. And, we talked about dispute resolution processes, which are not particularly culturally competent, generally based on Western ideology, shaking hands, making everything better. There is a much more restorative, holistic approach that I think could be employed that reflects Indigenous people's values and cultures. And so, who do these broader institutions serve? I think that's a fundamental question. And what identified needs do they address? And how do they provide people? And, Erin mentioned this earlier, and I very much noticed it. How do they provide people with the inherent dignity that human rights are supposed to protect? So the Universal Declaration on Human Rights, of course, was drafted to protect dignity. Yet we know that many of the policy moves seem to miss that mark to a large extent. So, I'll go back to this listening exercise. So we need to listen to, to sort of hear Indigenous people's perspectives on how we redefine the balance between parties. And, I would just finally point out, of course, that we have discussed, certainly the idea of a nation-to-nation relationship with Indigenous peoples. And for me, that's fundamental. And, there's such a heavy power imbalance at play that currently exists, and it's not really reflective of negotiations as equals. And so, from my perspective, as long as one party dominates and prescribes the way that human rights will be implemented, without being attentive to the needs and interests and inherent dignity of Indigenous peoples, then it's going to be an incredibly difficult decolonization road ahead for us. So I would just, finally say there's we talked about practical steps. And I think we all need to put aside our preconceptions of what human rights are and again, engage in that listening, understanding exercise, create those spaces for discussion where there's no power imbalance at the table. And, I just would, of course, we all recognize this, but Indigenous peoples are not a monolith. And, we might have to sort of look at initiatives and narrow them down to the Indigenous nation or local levels to really get at the crux of what sort of fundamental changes might be required. I'll leave it there. Thank you.
Wonderful. Thank you so much, Keith. We're really fortunate to have you in the role that you're in at the Implementation Secretary with respect to the UN Declaration Act. And I'm so excited to see the important work that you're going to accomplish in that role.
Thank you.
So, Brenda, I want to give you a chance to jump in on this topic as well. So what are some steps, some action items that we can engage in to decolonize human rights?
I think I actually want to pick up where Keith was speaking. And, one of the things that I'm really excited about right now at the international level is the traction that we're seeing in what we refer to as enhanced participation. UN always has terrible sort of speak, but so we're talking enhanced participation, but what is actively being negotiated and discussed is how do Indigenous peoples participate in UN processes. And I mentioned briefly that at first, the UN was very closed. It's about nation states. And then they started, as we added in more human rights, realizing maybe you need more people in there. And so non-governmental organizations were able to participate. And then there's this thing called ECOSOC status, which is a really long bureaucratic process to get recognized. And Indigenous peoples, being super astute, have learned these processes and knew how to negotiate them. But for many years, Indigenous peoples' participation, including at the Human Rights Council, has been through the NGO, non-governmental organization status, ECOSOC recognition of non-governmental status. And there was a recognition for a long time. Indigenous peoples always said, this is inappropriate, but this is our in. But what we see coming out of the World Conference on Indigenous Peoples is a resolution from the General Assembly to consider Indigenous peoples' participation. And so there is actively conversations and negotiations about recognizing Indigenous peoples' ability to participate as Indigenous peoples, as governments, as organizations. And so, I think it's going to be a tough slog. There's ups and downs to these negotiations. But it's been really clear, and many states understand that it cannot be the United Nations that's accrediting Indigenous peoples. They are very much aware of the fact that the UN can't decide who is Indigenous, and it can't be states accrediting. So that's huge, right? So what we see from that is, I think, this recognition that engaging with Indigenous peoples and this, what we could call a decolonization process, at least at some level, is about engaging with Indigenous peoples from their position and from where they are, right? So I always think about the process. It's not about fitting Indigenous people into the system, right? We can't be the square peg that is shaved down to fit into the round hole. Right? We actually have to fundamentally change the whole to reflect all of us. And it has to be our holistic being. It can't be part of us that is cognizable to these systems, right? These systems have to learn to see it from our perspectives. And so, recognizing Indigenous peoples as right holders, but not because everyone has human rights. And this is where the UN Declaration starts, right? And I don't want to, I feel like Keith might get there, so I will try not to say too much, but this idea of equality and non-discrimination means that we're peoples, but we're also Indigenous. And so we start from that place. And so I think that's a really critical place, is thinking about when and how are Indigenous peoples at the place and at the table? Are they there as governments, as decision makers, contributing to the process? And so I think that's a real important starting place for me.
Great. Thank you so much, Brenda. Okay, so now we're moving on to our third question. So we've talked about the why and a little bit about the how, and this third question focuses on the challenges. So what are the challenges of decolonizing human rights in the human rights system? And Aaron, I want to give you a chance to jump in here. So over to you, Aaron.
Okay, so I really found that very helpful listening to Keith and Brenda. And I'd like to start actually by linking two of their comments. So Keith mentioned, in the context of human rights specifically, one system doesn't fit all. And to overcome that challenge, we need a listening exercise. And I understood him to be saying of deep listening, really where there's, it's not just an exercise of recognition, but a capacity, an openness to being transformed by what we hear. So on that scale, so that's key. And I think that connects very tightly with what Brenda was saying about hearing Indigenous peoples as Indigenous peoples. So it's not enough to just have a colloquial seat at the table, but we have to be heard, not just heard, but heard on our own terms, as she put it, from their position. And to me, the significance of all of this, one of the great challenges that we face is sort of a classic human problem. And as Canadians, we're no different than anyone else, or as Indigenous peoples, we fear what we don't understand. And because of that, there's this incredible drive towards sameness. And I think that's so unhealthy. And I think it's so untrue. I don't think we should fear deep difference. And I don't think we should always strive in our scholarship or in our policies to emphasize sameness. I think we just paper over a lot of what really matters most to folks when we do that. We need to really sit with the depth of difference that characterizes our societies and our relationship and be okay with that. And then learn to speak across that by careful listening. So part of the challenge is, I think, a partial and piecemeal willingness to do this, and certainly not a state level, deep institutional commitment. There are certain institutions and organs within that I think are developing real capacity here, and others that are not. And so it would be nice to have a more uniform, principled commitment to this approach to engaging with the quote unquote other, the Indigenous other in this case. And then I think part of that is also by engaging with those who are different from ourselves, our own ethnocentrism is revealed to us. And I don't say this as a dig. I think it's part of the human condition. We all have this. It's hard to see the culture that we inhabit, right? When it's everywhere we look. But engaging in this deep listening with others, it starts to be disclosed to us, and then we can attend to it. And so we might realize the sort of idea that I presented at the outset. There isn't just one meaning that can be given to dignity, the idea of individual autonomy, so precious, arguably sacrosanct in modern liberal democracies. But many Indigenous communities think of dignity in a very different way. And if we can listen and understand the rigor and the coherence of their perspective, we might start to be able to be okay with it. So that's one piece. Another challenge is holding the two registers of oppression together, because as undue exclusion and forced inclusion, they're in considerable tension and is difficult. And I don't think it's simply a matter of committing ourselves to legal pluralism, of accepting the idea that we live in a multi-juridical country. Those are wonderful starting points, but the task is much harder. I would argue that Indigenous law, and so Indigenous conceptions of human rights, aren't just different, they're different in kind. When we're saying dignity means something else and our law works a different way, a different kind of legal reasoning. And we can't simply assume that we can map easily from Canadian law to Indigenous law. There's a real question to be asked there that has to be worked out in practice. So again, it means sitting with a deep difference and taking that time rather than privileging shortcuts that assume sameness rather than learning if that's actually how to characterize our societies. And then the last piece would be, I want to encourage human rights bodies to take this register of forced inclusion as a register of oppression seriously. I can't say much on this point, but one brief contribution would be it's by virtue of our humanity that we hold specific gifts and needs as participants in creation at the heart of our conception of dignity. So there's a direct link to the human element, even though I've suggested a more encompassing approach would be consistent with Indigenous law. Second, if we were to take indigeneity seriously as its own category of protected ground, we think we're sort of forced to confront the fact that it exists in a binary with settler. And were we to do that, it would be hard not to take the second register of oppression seriously. And so I think that's a specific sort of doctrinal and policy point, challenge that I would certainly welcome those folks who are positioned to do so to push on.
Thank you so much, Aaron. Those were three really significant challenges, but I'm optimistic that if you can articulate them so clearly, perhaps there's hope for us to work through them. Thank you. So Keith, I want to give you a chance to speak to this as well. So you're leading the implementation of the UN Declaration Act. So you probably have some pretty good insights on what the challenges are in this project. Over to you.
Yeah, no, thank you. And I liked everything Aaron just said, of course. And I think it was really brilliantly articulated. And I think one of the biggest challenges, and this touches a bit on what Aaron just said, was it's about changing people's mindsets who are in positions of power, influence within systems themselves, of course, right? And I mentioned at the beginning, I think we're seeing some positive signs around a willingness to take that hard look at existing structures and systems and figure out how to better serve Canadians and Indigenous peoples in Canada as well. And so I think, there's a lot of work to be done, of course, to change the current way we work with Indigenous peoples. I think everyone would recognize that. But this will be part of the work, I think, in implementing the UN Declaration in Canada. And I do think that the UN Declaration Act does set a framework that could lay out, how this could be done in Canada. I like sort of describing it as an opportunity to look at the art of the possibility when it comes to the transformative change that we all hope will result from implementation of the declaration, of course. And I think our engagement work, our working in consultation, cooperation, and partnership with Indigenous peoples on identifying their priorities for the action plan for measures to ensure consistency of laws, I think could be this just an incredibly bold starting point for trying to affect that change. We and I know folks have heard this, but there's a big challenge there's a huge challenge around dismantling existing structures, of course, right? And we know that so many don't necessarily serve the needs of Indigenous communities, and dismantling, rebuilding them. I mean, the focus is on rebuilding, of course, right? But this time rebuilding them in partnership with Indigenous peoples, of course, right? As equal partners at the table, I think will be fundamental, and I think aligns incredibly well with the sort of objectives of the declaration itself. We all know that not making changes will continue to be incredibly detrimental to Indigenous peoples and their human rights. And so, I think we could all just sort of sit back and think, how could we identify ways to be more inclusive, just like in our day-to-day activities, but more broadly as we look at sort of, significant institutional transformative change within society. How can we make everything we do more inclusive, including, of course, in respect of Indigenous peoples and their rights. So I'll just leave it there. Thank you.
That's great. Thank you so much, Keith. Brenda, I want to give you a chance to speak to this as well. So what challenges do you see in decolonizing human rights?
Thanks. I wanted to share a thought that really just came to me listening to Aaron and Keith and reflecting on a conversation that I had last week with someone else. And and I have a ton of respect for human rights lawyers. It's an area that I think doesn't always get recognition as being, real law. And so I know it's always a tough slog. But I actually think, if I'm going to be direct and maybe brutally honest, that one of the challenges are those people who work in human rights systems, the human rights lawyers, in part because they have developed expertise over decades, have done phenomenal work. And part of the change we're talking about requires a profound recognition of deficiency of an area that most people are probably not familiar with. And relatedly, most human rights lawyers that I know do it as a labor of love and are really invested in the process. And that is really important, I think, to be committed to this work. But I think we all need to check that. I want to call it a hero complex. And I don't know if that's, but we do it because we want to sort of help people, right? There's a real helping. But at what point does that turn into a wanting to help someone and what actually needs to be done, not moving in, but stepping back and creating the space? And so I wanted to share that reflection only because I'm going to encourage everyone on the line today to think about their own, why are you in this work, and what is your obligation? Is it to take it up and move forward with this, or is it about stepping back or stepping to the side so that Indigenous peoples and our legal orders have the space that's needed in the Canadian system? And so I just want to encourage people to really think about making sure that in your own personal commitment to advancing human rights, that you don't become the obstacle to the decolonization process.
Thank you so much, Brenda. Okay, so this brings us to our fourth and final question, at least that I have for the panelists. And then after this, we'll have time for audience questions. So you can start to think about what question you'd like to put to our panelists. But first, our fourth question. So this question also relates to one that we have received already from an audience member. And throughout this discussion, we've heard about the importance of giving effect to Indigenous laws and Indigenous legal orders. And this question asks, what exactly will that look like? So how do you see the interaction between Indigenous laws and between human rights? And the way that this question is put from our audience member is, when we talk about these different frameworks, so the framework of Indigenous laws, Indigenous legal orders, and then the Canadian legal framework, do we see these as working together in some way? Or do people have to choose which system that they're going to operate within? So that's just one way that an audience member has put the question. Okay, so Brenda, I'm going to turn it over to you to speak to this one first.
Thanks, and I'll try to be quick. I wanted to maybe use a concrete example that I think is maybe helpful to think about from some of my work where we've talked about braiding together international, domestic, and Indigenous law. So there have been land rights cases in Latin America, mostly through the Inter-American human rights system. And what we've seen done is an international human rights instrument that recognizes a right to property being applied in a country in Latin America. And what the international courts have said is that, yes, we recognize a right to property, but when we're talking about Indigenous people's rights to their traditional lands and territories, you have to turn to Indigenous law. So in the case of the mine of Belize, what Belize needed to do was to sit with the mine and understand, what traditional territories do you use? How do you use the land? How do you sort of govern that relationship? And that then had to be reflected in Belizean law. So you take a general human rights principle, right? The right to property, the right to security of the person in relation to Indigenous peoples includes a right to a healthy environment because we are so connected to the environment. And so then you turn to Anishinaabe law, you turn to Métis law, and you say, okay, well, what is contained within that? And the nation state does nothing but recognize that in domestic law to provide that state level protection. It's not changing it, it's not transforming it, it's simply recognizing that legal systems and those rules.
Great, thank you, Brenda. Okay, so Erin, I want to give you a chance to speak to this question as well. So how do you see the interaction, if any, between Indigenous laws and human rights or Canadian law?
Okay. Well, so the risk that I worry about, so first, I guess my starting point should be, I think there are all kinds of us who want to do good. I don't question that. I have no doubt about that. We have different ideas about what good means. And the risk that I fear is that folks who are unequivocally well-intentioned will just try to fold Indigenous difference into Canadian law, again, on that assumption of sameness. And I think we're hearing versions of this from Keith and Brenda as well. So to me, this is sort of like the central worry. It's actually not the case that it's sort of clean and easy, and all we need is a kind of openness of heart to make that space. The task, that massively undersells the scope of the task. We have to engage Indigenous law on its own terms. It has its own institutions, right? It isn't sufficient simply to consult Indigenous folks on how Canadian law institutions should give effect to a certain policy. That's obviously a good thing. We should do that. But we have to be clear about what it is we're doing when we do so. That is not the work, to my mind, of reconciliation or of decolonization. That's just sort of basic equity. The larger task, for those loftier goals, we have to sit with Indigenous law on its own terms. And that's hard. Most of us don't yet know how to do that. And so there's a huge education piece. I have often promoted the OHRC's document To Dream Together from 2018. I think, as all things, it's certainly imperfect, but there's much in it that I find to celebrate. And so I just want to make sure if there are policymakers or legislators or others in our circle today, they're aware of that, right? Because I think there are elements of it which can be quite eye-opening, and lots of community members' voices expressing little snippets of Indigenous law, which will be difficult to reconcile with law as most of us think about that word. So a way to open up new understandings. Some specific things though, so my sort of principal point, that my governing point, that we have to engage Indigenous law on its own terms. Some specific things of what that means. So I've mentioned already, being educated about Indigenous law. We can't really commit ourselves to engaging with it on its own terms if we don't even know how to identify what that is. And I know from previous conversations, sometimes folks receive that invitation as an imposition, but my sort of ready response to that view is that Indigenous folks have long been expected, not invited, to understand, accept, and operate all of our necessary functions within the framework of Canadian law. And so not just to identify a potential double standard, but from my view, our national standard is already one of deference to difference. And we just want to make sure that it runs in both directions, on both poles. Second point would be allowing and more actively supporting Indigenous peoples to revitalize their own legal systems. And so I think Brenda was also expressing a version of this. And again, I think human rights bodies could play a leading role here. And then the third, and I'll just sort of state it as a simple point because otherwise the conversation is far too big, but an invitation for settlers to engage with Indigenous peoples' systems of law so that thinking through what it would mean to actually live out dignity on the conception that I put down, participating in creation, that the idea that you have gifts that the rest of us need, right? To sort of sit with those ideas and think about what that might mean in practice in a daily sort of way. Yeah, that's it.
Thank you so much, Aaron. Okay, so now we have time for audience questions, and I do have a question from the audience already. So this question is building on the last point that Brenda made, and specifically it's asking what exactly should human rights lawyers do to stay alert to the issue that Brenda identified, which is to ensure that as part of the human rights system, human rights lawyers do not become part of the problem. So what can human rights lawyers do to ensure they're not an obstacle in the process of decolonizing human rights? So the questioner is inviting Brenda to answer, but and so Brenda, I want to give you a chance first, but then Keith and Aaron, if this is something that you might want to speak to as well, I'll ask you afterwards too. So Brenda, what are your thoughts on this?
Thank you for the question. And thank you, Aaron, for your previous comments, because it actually helped me think through how I want to respond to this answer. Because more and more, and I might answer the other question there about lobbying for more staff and budget. More and more, I think we don't need the system to do more, we need it to pull back. And I think this aligns with what Aaron is saying, is that Indigenous peoples don't need the human rights system to come to them. We need this space. So in answering this question of what can you do, I think when there's an urge to act, I think it's stop and check yourself. Are you the one that should act right now? Or is this the time and space? Or is this the time to make space, sorry, for Indigenous peoples to have opportunities to advance their causes, to advance their laws on their own, right? And it's a really fine balance, and it's sometimes you don't realize to the end that you're like, oh, I just occupied a space because I wanted to help. And I took a step forward to help, and I should have stepped back. And so I think in relation to some of these challenges and into the decolonization process, yes, we need to address, and I think the human rights system can change. But also what I was trying to point to in my example was that the Belizean law, it was just pulling back, right? It's not that the Belizean law needs to create a test to recognize law and do all these things. It's simply needed to ensure that at least under Belizean law, that the Mayan land rights and their legal system and structure of governance and protecting that was protected under, from the incursion of oil companies. That was the situation, right? So I think that it's really just that sort of more often than not, I'm more and more thinking that the answer is stepping back.
Thank you so much, Brenda. Keith or Aaron, would you like to jump in on this question? So Keith?
I can, yeah, sure. I can jump in quickly. And it's just, based on my experience working at the Canadian Human Rights Commission. And it's a really great question. And of course, the lawyers, the human rights lawyers that I know that work at that commission, their hearts are absolutely in the right place. They are absolutely committed to equality and to non-discrimination and to the rights of Indigenous people. So it does become a complex issue when you're working within the confines of legislation, of course, right? And so, I think national human rights institutions, there's a set of principles that, apply to them called the Paris Principles. And, a national human rights institution has a responsibility to promote human rights and to protect human rights, of course. And so I would say within that context, I agree with Brenda, of course. I think, within the promotion role, you can sort of create the space for Indigenous, and be an ally to Indigenous peoples and letting them articulate what their priorities are for human rights, and then of course support those priorities moving forward. On the protection side, it's a challenge, of course, right? And I think there is more work that needs to be done because with the repeal of Section 67, and individual First Nations people can bring their band counsel, file a complaint against their band counsel, for example, for discrimination. The lawyers have an obligation to review those applications, or those complaints rather, and figure out what to do with them and whether there's sufficient enough reason to refer it to tribunal for decision, of course. And so that is an important role that is absolutely required of them, of course. But the repeal also provided space for consideration of Indigenous laws and legal orders within the consideration of those particular complaints. And my experience there was that has never been fully fleshed out. So I think there's some more work that could go into really looking really closely at how that could, again, exist within the broader context of complaints against Indigenous nations themselves, sort of thing. So, they have a job to do. They are sort of protecting, in this particular case, individual rights and trying to address discrimination against individuals with the broader context of the Indian Act and Indian Act governance, of course. But the thing is that repeal was always intended to be a stopgap measure until Indigenous nations could draw down, their own sort of authorities, in order to deal with discrimination complaints within their own nations and governments, if you will, sort of thing. But that's been a long time coming, right? And this is one of the issues, I think, with the Declaration when we're looking at the foundational right of self-determination, self-governance, and what that might look like. I think, the Commission could, for example, engage in a discussion with Indigenous peoples about how that might manifest within the broader context of implementation of the rights of Indigenous people. So I think there's a lot of space there for listening and further discussion and action. Thanks.
Wonderful. Thank you, Keith. Erin, I just want to give you a chance. I don't know if this is something you want to speak to, but if it is, I want to turn over to you.
Just very briefly, thank you. So I think it's a terrific question. We should focus on what's practical. And I guess to my mind, I'm not sure it is actually possible to do it without meaningful engagement with Indigenous peoples. And so I would say, use us. You heard it here. You now have some kind of authority to appeal to. Take that to your employer and say, as an institutional commitment, we need to sort of sit with and learn from, and it shouldn't be a one-off. And without that, as I said, we're all good-hearted people. We can attend to the conditions of openness within our own societies, but it's not actually clear, is it, that that's going to be sufficient to meet the standard Brenda set. You may actually have to learn something about someone else to understand that it means something different for them. And so I think the only way to know is to actually take that time. And so my suggestion is come into our spaces too.
Wonderful. Thank you, Erin. Okay, so one more question that we've received from the audience asks, what is the most effective way to lobby for more staff and budget for the Ontario Human Rights Commission? So given that the Commission has played such a significant role in facilitating today's event, if we have some suggestions for how the Commission could be supported and how to effectively advocate for an increase in its budget, I think that would be wonderful if we could put them forward. So Keith, Brenda, Erin, do you have thoughts on this?
Can I just say I'm in Manitoba and I had no part in the last Ontario election? Is that a fair response? I mean, not that my province is much better. I think the thing that I have learned from the people that I've worked with is needing to be relentless, right? Like, so that sort of just constant, if the budget, if the staff isn't sufficient to do the work that needs to be done, I think it's just, It's not a one-time ask, right? Like, and it's that constant, I don't know. That's sort of my advocate approach. I'm the mosquito that just never goes away, right? Like, just keep the buzz in the ear.
Absolutely. Excellent advice.
I also live in a swamp, so.
Keith or Aaron, any thoughts?
Oh yeah, that's a tough one. You know, I'm a public servant myself, of course, right? So I can't opine too much on that question, but I have worked in politics in the past too. But I think you know, I think making the case, right? You know, we often see when it comes to advancing you know, progressive social issues that you somehow have to tie it to, you have to sort of really clearly delineate why advancing that particular issue will result in you know, a better quality of life or higher standard of living or what have you, close socioeconomic gaps. And I think that's okay, you know, of course. And so I think, you know, governments are looking to, they're looking at what the results are of that funding, right? Of course, what are the outcomes of that additional funding? What are those going to be? Of course, and I, you know, having worked in human rights for some time, have always sort of advocated that addressing, you know, those disparities will enrich all of the country, right? All Canadians, including, you know, the most marginalized of Canadians as well. There's an economic benefit to equality that I think we don't talk about enough, of course. So yeah, I think I'll just leave it there. It's a good question. Thank you.
That makes a lot of sense. Identify the outcomes, the take-home points, the deliverables that will be achieved with more funding. Great, thanks, Keith. Aaron, is there anything you want to add with respect to this question?
No, for a brief period, I was a public servant of the Competition Bureau. That was like 20 years ago. I'm over my head.
Understood. Okay, well, we're nearing the end. And so I've got my final wrap-up question for us. So in 1 minute or less, I want to give each of you a chance to tell us what makes you optimistic about the future of human rights and about the project of decolonizing human rights. I hope that there's something that makes you optimistic, but if there isn't, then the alternative is to answer the other question, which is what makes you pessimistic about this future. But I'm hoping you can answer the first part of the question. So Brenda, I'm going to give you a chance to respond first.
I will say the youth. One of the wonderful things I get to do in my job as academic and research director at the National Center for Truth and Reconciliation is I get to see the projects and the work that's done through our Imagine a Canada. So kids submit projects and pictures and poetry about what is a reconciled Canada looks like, and like bawling because the kids get it. And like they get the deep nuances and the hard work that Aaron is talking about. You know, one kid drew a picture and they were sitting around a campfire and each person said hello in their own language. And like, that's what a reconciled Canada looks like to the kids, right? Where we're coming together, but on our own terms, in our own ways. And so like the youth get it, we just need to not mess them up. So I'm like, those days that I get to see what the kids are doing and how supporting them towards, you know, changing Canada, like we'll be okay. And Indigenous peoples, we're fierce, we're relentless, like it's gonna happen because we're not gonna let up.
I love that example. Thanks so much, Brenda. Aaron, I want to give you a chance to speak to this. What makes you optimistic?
Well, at the outset, I said, Nindabwe, I speak my truth. So my truth is, it's mixed, it's both. But in the way of my elders, I will certainly emphasize the reasons that I feel optimistic and my gratitude. And so the first is a concrete, observable trend in my life of the passion, the hunger amongst students, many ecumenical communities to learn and to engage with Indigenous law as part of their personal or collective reconciliation projects. And I see a direct connection there to how what they take on from their own larger society and then learn from Indigenous peoples can translate and I think, again, I think human rights can be one of the mechanisms through which that work happens. So I think there's already a large body of folks who are really committed to learning and to doing the work, even amongst non-Indigenous peoples. And so for me, that's, I take inspiration from that almost on the daily. I guess the second piece would be global challenges we're all familiar with, the rise of populism and far bigger still, anthropogenic climate change. Indigenous peoples, and specifically Indigenous law, has answers. They're not perfect. Of course, they're not perfect, but they're significant. And I think the tide of the high tide of liberalism is waning, and we need other resources. And I think folks will do well to turn to Indigenous law. And so that's another source of optimism for me. And then the final one, which I learned really from my mom in one way, who's listening actually, and not through me. It's quite an incredible thing. We spoke this morning and she mentioned, are you doing a human rights thing today? So hi, Mom. Through my mom and then through my grandmother, now in spirit, is that ultimately the power is in people. When we have sort of a popular sovereignty and we're represented in our governments, but at the bottom, we've never given up that power. And I think Indigenous peoples, better than others, remember that and practice it. And I think that's something that should be revitalized and is a source of extraordinary transformative change. And so, and that's at the heart of Indigenous law. And so, you know, for me, that's a third source of real optimism.
That's fantastic. Thanks, Aaron, and hello to Aaron's mom. Okay, Keith, over to you.
Yes, hello, Aaron's mom. Yes. So I am an optimistic person by nature, of course, and you know, I've been around government for quite some time, and I was offered this position, and it would have been probably the only other position that someone could have offered me that I would have taken, because I really did enjoy working at the Canadian Human Rights Commission. But the opportunity to work on the implementation of the UN Declaration on the Rights of Indigenous Peoples was just something I had to do, of course, and something I'd been waiting for a really long time as well. So I'm pretty optimistic. And I think, you know, I would say that I think we're seeing many institutions stepping up and coming forward and showing a real commitment to implementing the rights of Indigenous peoples. I've seen it more than I've seen it in a very long time, and I think in a really legitimate way that really really lines up with the needs and the interests and the rights and the aspirations of Indigenous peoples. And so I do really think there is you know, this interest in protecting the rights of Indigenous peoples, but I think more importantly, doing it on a nation-to-nation basis, which is, of course, modeling the UN Declaration on the Rights of Indigenous Peoples. And so, you know, that nation rebuilding exercise, Indigenous peoples assuming, you know, their right to self-determination, self-government, looking at its implementation. These are all things, you know, I think, you know, again, I think the implementation of the declaration is, you know, it's about exploring the art of the possibility in terms of the sort of generational, transformational work that can be done moving forward. And so I really am enthusiastic about that, and to working with Indigenous nations and the representative organizations to move that work forward for sure. It's definitely daunting. There's no question. I think we can all recognize that. But I think if there's a will, there's a way, of course, and I do think there's a will, both on the side of governments, but also, of course, you know, a strong desire by Indigenous peoples to move forward, of course. And so, you know, all I would say is that I think we could and can reconceptualize human rights in a very positive way moving forward. And I think the UN Declaration process could be one of the mechanisms that can be used to do so. And I think, you know, we are all looking at moving forward in a way that meets the needs, interests, and again, to Aaron's point, the dignity of Indigenous nations and communities. You know, the very people that Indigenous human rights and the Declaration are really meant to protect. So I'll leave it there, and thank you again for the opportunity.
Wonderful. Well, Brenda, Aaron, and Keith, you've taken time out of your busy day and your busy schedules to be with us here and to share your extensive knowledge and experience. And for that, we're very grateful. Chumigwich, thank you so much.
Chumigwich.
Thank you all, and thank you, Dr. Drake, for moderating that panel. It was such a profound and powerful way and a call for us to close. I'm going to ask for Dhir to come up and Dr. Warner, Remi Warner to come up, and we're going to do some closing remarks. We'll hear first from Raj from the Ontario Human Rights Commission.
Thank you, Toni, and thank you so much for being such an amazing host through the course of the day. You've been fantastic. Wow, what an incredible day. It has truly been a pleasure to hear from such deep and dynamic thinkers. On behalf of the Ontario Human Rights Commission, we have been delighted to have had the opportunity to partner with the Lincoln Alexander School of Law and Human Rights Services of the Toronto Metropolitan University to create this space to foster this important exploration of potential new directions in human rights law and policy. Today was truly a day to reflect and imagine. And as we reach 60 years of the Human Rights Code, we know that the human rights system is at an important crossroads. We heard today about the challenges that the human rights system is facing, including under-resourcing, delay, and the challenge to fully meet the mandate of addressing systemic discrimination for all communities. So where do we go from here? The discussions that we've had today make it clear that the Human Rights Code needs to evolve. For example, we heard that the code may be outdated in providing meaningful redress for the experience of discrimination. We heard that adjudicative processes may not always be amenable to systemic claims. We heard how the code was developed without the participation or even consideration of Indigenous peoples, and the importance of Indigenous peoples exercising their own self-determination and sovereignty to vacate the institutional space and to implement their own system based on unique worldviews. But it's not just the code that needs to evolve to be a fuller reflection of these and other perspectives. Institutions need to evolve with it. We heard about the need to reevaluate our approaches to addressing systemic discrimination, including reconceptualizing the way we frame rights, the use of the tools that we have to affect systemic changes, the use of enforcement mechanisms, the ways we can empower communities, the ways we can support duty holders and instill accountability, whether it's through institutional responsibility, public or legal accountability. Institutions ultimately have a responsibility to evolve in response to challenging needs of community as articulated by those communities to whom they're accountable. And part of that work involves building internal capacity to be credible, to be reliable, to be knowledgeable agents of change. It also means that there's a need for organizations, the OHRC and others, to establish meaningful, sustainable, and reciprocal relationships with communities and engage with these communities in order for us to improve our work and for communities to improve their work. And finally, we need to engage in ongoing and critical self-reflection, as we're doing today, to recognize the ways that entrenched systems, including systemic discrimination and colonialism, continue to influence our policies, practices, and structures. And we have to identify steps that we can take to address this. This is all part of the reimagining that we need to do to see human rights prosper in our communities over the next 60 years. Given the incredible costs of discrimination to all of us and to Ontario, we simply have to look at these issues. We have to continue these discussions. We have to continue them with the other pillars in the human rights system, with community partners, and with government. And these discussions must inform us as we embark on strategic planning in the next 3 years and beyond. So I just want to say in closing, on behalf of the Human Rights Commission, thank you for giving us your time today. Thank you for your inspiration, and thank you for your engagement on these important issues. I'm going to now turn it over to Remi Warner.
Thank you very much, Raj. And I echo deep thanks and gratitude to all of today's speakers, listeners, and contributors behind the scenes. It has been a most thought-provoking and hopefully practice-shattering and expanding day with lessons and insights that will no doubt continue to challenge and engage us in the field of human rights for some time to come. I remember the day I reached out to Raj about the prospect of partnering on an event to reflect on the past and future of human rights in our province. It was based on this haunting feeling at the time that we were at a critical crossroads. A crossroads not unlike that almost 45 years ago to this day, which occasioned the Commission's comprehensive consultation report, Life Together, that led to sweeping changes to the code, including the addition of 6 new grounds and the hitherto non-existent provision to deal with systemic or constructive discrimination. I believe, and I think we heard today, that we are at a similar crossroads where it is incumbent upon us to take stock and reassess the extent to which the code continues to be able to effectively grapple with the major human rights issues of our day, from struggles for racial justice and calls for Black Lives to Matter, to truth and reconciliation efforts to decolonize prevailing social, institutional, and legal arrangements. We know that when the Universal Declaration of Human Rights was first promulgated in 1948, as would go on to inspire the code, much of the indigenous and dark world, as W.E.B. Du Bois called it, was still under colonial domination, if not indirect rule, and absent from the development process. This has led leading theorist of decoloniality, Walter Mignolo, to argue that human rights as we know it today is largely a provincial Euro-American and North Atlantic project and invention designed to address the regional problems and mistakes of a handful of American and Western European states, from Hitler's Holocaust in Germany to Stalin's genocide in Russia to the American dropping of atomic bombs on Hiroshima and Nagasaki. It is thus rightfully being asked by many speakers today, who speaks for the human and human rights, when so many humans, especially those of a darker hue, continue to be legally degraded and denigrated in the barrios, reserves, and Black sites, suffocated and killed at point blank by agents of the state, stripped, searched, and stripped mined in the relentless pursuit of economic profit, which has commodified and poisoned the very land, water, and air upon which human life depends. How is this continuing to happen in the midst of the many and lofty modern international and domestic human rights treaties and instruments of freedom, equality, and fraternity, the enforcement of which continues to fall disproportionately on a small privileged class of white lawyers and experts, or saviors in Mignolo's terms, charged with classifying, protecting, separating the victims and perpetrators? How do we account for what Dr. Blackstock observed as the failure of the same human rights community of which I'm a part to investigate white supremacy's grossly unequal treatment of and service provision for Indigenous children and families? Perhaps this is because, in the paraphrased words of Ronaldo Walcott, the colonial history that gave rise to contemporary life in the West, settler colonialism, Indigenous genocide, transatlantic slavery, continues to haunt our human rights present. If our rights regimes have been primarily enunciated from a top-down place of privilege, even if in response to grassroots pressure, what could the future of human rights law and policy look like if developed from the bottom up? The French philosopher Jacques Maritain once described the Declaration as a document with 30 strings upon which many different kinds of music could be played. I'm pretty sure there are some additional strings that could be added from the global symphony. Indeed, in some cases, the instrument altogether could be made anew. And it is my sincere hope that today's dialogue continues to animate and inspire an overdue reimagining of human rights, for it is high time to think human rights otherwise, as Mignolo implores us, including in ways that take seriously the philosophies and traditions and lived experiences of the rest of the world, beginning first, the first peoples on whose lands we occupy. In my view, we cannot but appropriate and remake the language and practice of human rights as a critical emancipatory tool, even if not the only one around, for the language of rights remains, in the words of Rowan Williams, one of the only generally intelligible ways in modern political ethics of decisively challenging the positive authority of the state to do what it pleases, the only way of expressing how the state itself is under law, which is precisely why the language of human rights must be fulsomely expanded to better reflect the voices, experiences, and traditions of those who have been absented from the circles of those charged with universally defining and legislating the rights of the human. A universalism on the plane of ethics and law that can only ever be but partial, situated, and relational. In conclusion, drawing on lessons from today, what does this mean for human rights services? I and the HRS team are committed to continuing to subject our own taken for granted ideas, structures, processes, and ways of doing human rights to critical decolonial scrutiny. As we know, continuing with the status quo perpetuates harm as much as it alleviates it for many in our community. And some of the ways we hope to do this concretely in the shorter to medium term includes creating and cultivating a trans-systemic space. Thank you, Dr. Marie Baptiste, for sharing this beautiful new language and window for me. Creating a trans-systemic space for the meeting and use of diverse conflict resolution traditions, including as led by traditional knowledge keepers in the community, familiar with Indigenous and non-Western restorative justice traditions. By looking at how we can incorporate UNDRIP principles, beginning with the recognition of indigeneity as a unique ground of discrimination, and by looking at how we can embed more proactive positive duties to address and prevent systemic discrimination. Finally, and critically importantly, by increasing our collaboration with and engagement of communities on the margins of our institution or excluded altogether, using participative, decolonial, transformative methodologies as part of a broader effort to rebalance our economy of attention. Most importantly, to carefully and continuously listen and reflect. Thank you so much. And to you, Toni, a big thank you to you as the master of ceremonies and MC, indeed you have been. Take us away.
Thank you so much, Remi. I will close with some final thoughts. Remi and Raj have said so much that you can digest that for weeks as well. I will say that what came out for me was the importance of telling our stories. That when we're talking about discrimination and when we're thinking about human rights, we need to think about the stories that have been erased, misread, misunderstood, invalidated, and often unheard. And part of the work that we heard from everyone is we have to find ways to tell these stories, to put them on record, and to have these stories of lived experience count as evidence, right? That question around what is evidence and what are these systems that were created that do not serve the very justice that they purport to defend. The second thing that came up for me was the cost of the work. We heard from both of our keynotes the cost of the experiencing discrimination on the people who are harmed every day by discrimination to the point of death, people dying and losing their lives because nothing has been done in a careful and systematic, thoughtful way to prevent these individual acts of harm. That cost of the work also extends to all of the people doing the work. And we were called to think about what it means to feel like you're under-resourced, that there is a cost of your energy, your life, your commitment has a cost that goes beyond that, and that you're working for so little, for such a lofty and important aim, that can cost you everything from your reputation to your own life. And I think that that's all often not underscored enough, how much people are giving the courage of the comments and the conviction of the people on these panels and on these keynotes to me was inspiring and called on all of us to raise our voices. One of the things we heard over and over again from Dr. Blackstock, from Dean Young, from all of our panelists was that we need to act, that social movements have been at the forefront and at the center of the work actually shifting and transforming these institutions. We heard about what it would be like to mobilize will, to use our human rights discourse, and to think about the ways in which we engage with these systems and the people in power to mobilize a will to do it, an actual commitment of self that goes beyond, I have to do it because otherwise I'll be disciplined. I have to do it because I need to show statistics that I'm doing it. I have to do it because everybody else is doing it. But that will to want people to come forward and work and live in harmony, but also be identified as having lived and worked in dignity, and to know that their identities matter and are important and make our society a better place for folks to live. We were called and questioned to think about who is doing the work and to think about us as human rights practitioners and activists and what it looks like to be critical of the ways in which we may not be doing enough learning. We may not be shifting enough. We may be speaking up and sometimes for communities that should be able to be present and speaking for themselves. So how do we engage with those communities, and specifically our Indigenous communities, as we think about ways we decolonize our own work and all the frameworks that we've learned that come out of colonial methods as well. I want to close by saying that for me, one of the biggest things that came up, and it came up in every single panel and talk, was what it looks like to do this work well is to be well resourced. And having done this work now for over 25 years, the one thing that is consistent, it is a mighty few doing the work with all of their hearts and souls for very little recognition and with very little resources. And that is inspiring, but it is not sustainable and it is not just. And so as somebody who is not on the OHRC, I feel very confident to say the first commitment we need to make is to push our governments to support organizations like the Ontario Human Rights Commission and to support people that are coming forward to defend their own human rights, right? That David and Goliath model that we heard talked about today. We cannot achieve a just outcome if people don't have access to that justice. And so I think of where the code and where human rights needs to go. And we've heard about more talk of thinking about intersectionality and how our identities coexist and intersect and exist at the same time, right? And we have to think about ways in which we respond to that. Over 30 years ago, Donna Young was talking about that, and it continues to be something that we need to focus on. How we look at the code responding to systemic change and not just individual harm. How we have the code evolve to represent more and more people and to represent rights that have been underserved and under-recognized. That it's not an inflation, but it's a realization. And so my excitement was to hear at the end this talk of hope and thinking we always go to youth when we think about it. And I can tell you the young people that I work with in the university are the first to tell you that there is a better way. There is a more inclusive way. And they're often quick to think about communities that they themselves don't even belong to, right? There is a sense of injustice that is felt by all when one of their colleagues or classmates is suffering. And so that has been powerful. And that's what fuels me. That and the little wins that we see every day. Those little wins that over time result in a transformative wave. So before we close, I just want to make sure I thank all of the conference speakers. The amount of time and effort people have put in. We know how busy your work is and how under-resourced you all are. This has been one of the most critical and thought-provoking days that I have experienced in a very long time. And it's powerful to see the work that's being done every day. To the participants that have engaged, that is what makes the difference, that you will carry this work into your daily lives and hopefully into the way you vote, into the way you support the communities in which we are working, and sometimes in which we don't live, but who live adjacent to us. Thank you for showing up. Thank you for being here. It has been a very dense day. And so I hope you can rest and relax today. We want to thank the people behind the scenes. So the committee is made up of many people. You get to see the co-organizers here, the three of us on the screen. There's so many people that have worked. We can't even name them all. We put them in the program. But folks that we don't always name are folks that are ASL interpreters. Thank you for the work that you've done all day with us speaking very quickly with very dense vocabulary. Thank you to Brian and Dylan who do all this work behind the scenes to make this look seamless. And we also want to thank folks from the Human Rights Commission, Ontario Human Rights Commission, Toronto Metropolitan's University's Human Rights Services, and Lincoln Alexander School of Law that took on such a mammoth event on the side of their desks because we thought it was so important to honor 60 years of this code coming into being. And I say, honestly, some people see it as a policy that's thick and looks to discipline. Many of us doing the work see it as a blanket that people can put around them and hold with pride, their identities and who they are in their workplace. We're going to have recordings of today's sessions. They're going to be posted in the next few weeks. So if you had to miss a session or if you want to share it with somebody, please do so. I'm going to be rewatching many of the panels myself. But we'd also love to hear your thoughts about the conference. So every participant that signed up will receive a short evaluation survey later today. Please fill it out. It really helps us to think about what we can do later and what we could have done to improve. So we'd love to hear what worked for you and things that you'd like to see. Unfortunately, our knowledge keeper, Nancy, wasn't able to close us off. She had a personal emergency come up. So on her behalf and on my behalf and on Raj and Remi's behalf, thank you for staying with us. And I want to thank you because the people that are on this Zoom are already trying to do this work every day. So thank you for the work that you're doing. It makes a difference. It does not go unnoticed. Have a great day.